Welcome to the Criminal Justice and Public Safety hearings for Wednesday, 2/9/22. We're going to start by asking Representative Marston to lead us in the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, and with that, I am going to go ahead and open the public hearing on HB 1540 FN. No. Public hearing.
The committee now calls Representative Welch to introduce House Bill 1540.
My name is David A. Welch. I represent Rockingham District 13. House Bill 1540, I was asked to put it in. It's not my bill, but we also have an amendment to it. So I suspect that the people following me will explain the bill in more detail. Essentially what it does, it allows for, actually calls for recording interrogations in the police station. If you're arrested, they record the interrogation, and never having been arrested before, I suspect it might be a good thing. So I'll let the people behind me explain the bill.
The committee now calls Buzz Scher.
It's better when I'm off. Good morning, Mr. Chair, members of the committee. My name is Buzz Scher. I am both a police commissioner in the town of Portsmouth, the city of Portsmouth, and a law professor at UNH Law. As always, the opinions I express today are solely mine and not those of UNH School of Law, or the Portsmouth Police Commission. This is a bill that we've, the original bill we had a hearing on a week or so ago, and there were some concerns raised by members of the committee, and we have sought to address those concerns by helping Representative Welch write the amendment. So I'll address the changes to the amendment. The first is in, I don't have the line by line, but in the definition of custodial interrogation, no, still don't have it. We added the language associated with an arrest or detention. And in the definition of law enforcement officer, we added, in line with the concerns expressed by the representative from the Department of Corrections, Lynn Cusack, a probation officer, a parole officer, or a corrections officer, or a security officer employed by the educational institution who has the power to detain an individual. I believe Representative Abbas felt the definition of the security officer employed by an educational institution was too broad, so we added the who has the power to detain an individual. And Attorney Cusack had concerns about the ambiguity and lack of clarity relating to probation officers, parole officers, and corrections officers. So we added that language in there too. If you combine that language with the added language in custodial interrogation that is associated with an arrest or detention, it does not include corrections officers who are just engaging in investigation for possible internal disciplinary proceedings, which is a concern that Attorney Cusack had. And then if you go to 594-A:4, we've added the language again to account for the concerns of Attorney Cusack. Likewise, the provisions of 494-A:3 shall not apply to administrative disciplinary hearings in a state correctional facility or for parole violators not charged with a new offense. So I think those address the concerns that Attorney Cusack raised, and my understanding is there was an exchange between Attorney Cusack and Susan Pichel, who has been working with the National Innocence Project, the New England Innocence Project, and myself on this, and she approved of these, my understanding is she approved of these changes. And finally, in 594-A:5, there was concern expressed by several members of the committee about somebody who didn't want a suspect who was about to be questioned, who didn't want to be recorded, and we added an exception for somebody who didn't want to be recorded. So the police would not be violating these provisions if the person asked not to be recorded and wrote, and that was captured in a written document. The final thing I would address for the committee, I know I've heard some concern expressed about this possibly being an unfunded mandate. As any law professor should, I have at least two answers for that question. Number one is there's probably not a police department, even the smallest of police departments, who doesn't have at least one member who has an iPhone or a smartphone of some sort. So they're not going to have to go out and buy massive amounts of cameras, number one. Number two, and more importantly, this provision allows for, if you look at the definition of electronic recording, which is required, it says an audio recording or an audio and video recording. So it doesn't need to be a video recording. My personal preference is that's better, but there's a little give in this statute. So every police department already has equipment to tape make audio tapes of this. And as we heard from, for example, Paul Halverson, the Merrimack County attorney, his belief is virtually all the police departments in his jurisdiction already do this. So that's my explanation of the amendment. More than willing to answer any questions.
I have a question regarding what you just discussed, the unfunded mandate portion of it. Given, assuming arguendo that everybody has some type of a way to record, I'm more concerned with the storage and retention requirements and the possible cost that could put onto a police department in the manpower as far as managing this, because it could be quite voluminous. And so could you speak to that?
Yes. Most police departments that I'm aware of already have storage capability. Number one, a server or the appropriate hardware to do that. And police departments don't obtain that many confessions that would fall under this, number one. Number two, because of that, most police departments have already solved the storage problem. Number three, if they do an audio recording, that storage issue is just is a lot simpler. And cloud storage is a mechanism that is far, far cheaper. And my guess is virtually every police department, maybe short of a one-officer department, has cloud storage capability that at least I think of at least my belief with my iPhone, I don't pay any extra for the cloud storage up to a certain limit.
And for just a follow-up, how would that cloud storage, from a privacy perspective, guarantee that a person's information from an interrogation is protected?
My understanding is every police department, this comes from my recent experience in the Portsmouth Police Commission, where I had to take a, loosely called a security test before I could have access to data. Virtually every police department that I'm aware of has procedures in place now, given a lot that is occurring virtually rather than in hard copy. They already have privacy, confidentiality regulations in place so that not just anybody can access it. They try to make it, understanding that in the end everything is hackable. They do what they have to do what they can in order to have access to, for example, FBI data. So that's imposed by the requirements of FBI security. So I think it's a problem. It's a legitimate concern, but I think it's a problem most police departments are dealing with.
Go ahead, Representative Testament.
Thank you. Thank you for taking my question. Is there any issue with this interrogation or this interview being challenged and not standing up to all of the rigors of either confidentiality, or was this at the right time, right place? Is it tagged? Is it a valid copy of something? I mean, what kind of issues are we getting into?
Minimal issues, actually, because most police departments already pay attention to what they need to do to, the technical legal term is authenticate the copy of the confession in order to get it admitted into court. They do that with a written confession, or if they already authentication requirements, which is really a fancy word for, is what you're showing me in court what you just testified to? So that's procedure that they already have well developed.
I just, one more question occurred to me. Could you speak to the record retention requirements for a recording? I'm also thinking not only of confessions, but of possible exculpatory evidence that may be available to a defense attorney in one of these recordings. How could we ensure that I want to understand how that has to be held and recorded and turned over during discovery?
Well, it has to be held, and they have to turn over exculpatory evidence, whether it's in the recorded confession or in some other way. I am not, other than police departments who, for one reason or another, screwed up, most often unintentionally. Every police department I know holds on to evidence in a case until the case is completely over. In terms of some evidence, as this committee saw last year in the amendments to the post-conviction DNA statute that this committee passed and got made its way all through and was signed by the governor, there are, depending on the type of evidence, there are requirements that the evidence in a case be held for a particular length of time, even after the conviction is resolved. in case there is, for example, biological evidence that has not been tested in the case itself, and the individual asserts their innocence after the conviction, and there are already provisions in place in that post-conviction DNA statute for retention for a period of time.
Representative Panalakis.
Thank you, Mr. Chairman. I just wanted to know if the amendment replaces the whole bill.
The amendment makes additions to, I think they're all additions to the original HB 1540. Yeah, I don't believe it replaces anything, but it adds language that tends to the concerns.
Thank you.
Thank you, Mr. Chair. Thanks for taking my question. Does the bill have a provision to provide a copy of the interrogation to the detainee?
Not the detainee right after it's taken, but if it will have to be provided as a part of discovery, the natural process of discovery.
Follow up.
In the interest of preserving the actual data, wouldn't it make sense to have a copy made at that point of time to ensure that it's not manipulated in any manner?
Theoretically, yes, I would say. That said, it would be, it's a balance between how difficult it is in the moment after the confession is taken with somebody who may well be sitting in jail, and getting them an audio and video copy of it, and what might become of that in that person's hands. And you balance that against the interest in making sure the person has a copy of the original. To go back to an earlier question, I think that's what the authentication process is about. The confession will always be, the copy of the confession, audio or audio and video, will always be provided to the defense attorney in the case. And they will have the opportunity, you know, if they, to show it to their client or have their client listen to it, and the client said, I never said that, you know, that's not me on there, or, you know, they left something out there. And if they can make an argument that that's a problem, then it will fail to be authenticated. So there's a process in place. So, you know, in theory, yeah, it'd be great to give the person a copy, but you balance that with what a, to use the formal legal term, what a pain in the neck it would be to get a copy to the suspect right after the interrogation. I think it's at least okay to wait until the suspect's attorney gets a copy through discovery.
Representative Lynn.
Hi, sure. How are you?
Good. How are
Good
you?
to see you. So you know what, Professor Scher, as you know that the law in this area on custodial interrogation has been pretty well developed constitutionally by case law.
I was
And
just
I guess
teaching it yesterday, actually.
I'm concerned about the definition of custodial interrogation in that it at least is susceptible to a construction that would go beyond what I think we traditionally think of as custodial interrogation. So my question is this: what if we change the definition to read as follows? Custodial interrogation means express questioning while under arrest, or other actions or words by a law enforcement officer which are reasonably likely to elicit an incriminating response from an individual, and which occurs when a reasonable individual in the same circumstances would consider himself or herself under arrest or the functional equivalent of arrest.
My concern with that is, I understand, Representative Lynn, what you're asking about. The problem with just saying associated with arrest is there's any number, so I know you know, there's any number of circumstances in which somebody is in custody but hasn't been arrested. The term arrest is a Fourth Amendment term. It rises out of the Fourth Amendment, and it's defined by that body of Fourth Amendment case law. Whereas the term custody is a Fifth Amendment term created essentially for the purpose of implementation of the Miranda warnings. So to just say arrest, you know, what I would say, that the correct way to say it means express questioning associated with custody. You know,
Well, but isn't, may it follow up?
Follow up.
But I mean, the thing I'm concerned about, particularly with your reference to the word detention, is, I mean, when a police officer pulls somebody over, makes a traffic stop, the person is detained. They can't,
I agree.
They can't leave.
But that's not custody.
Well, I guess, but you talk about detention here, and I guess that's part of, as I understand the law, it's, you either have to be formally under arrest, or you have to be in the situation of the functional equivalent of arrest.
Yes. I agree with you on the issue of detention. You know, this language was initially put in here to distinguish those circumstances when a corrections officer or a parole officer is doing interrogation. And so we didn't pay attention, as good attention as we should have, to this issue. My preference would be to just put that definition in there, that is associated with a formal arrest, you know, the definition of custody, a formal arrest or a restraint on freedom equivalent to that of a form of an arrest.
Okay.
You know, I'm fine with putting that language in there. I think it cures the problem.
Thank you.
The committee appreciates that fine legal debate.
And the committee is all welcome to come to my class on Friday, which we'll talk about.
I am from a different perspective. From my remembrance of my days in the police academy, wouldn't it be better, instead of saying would consider themselves in custody, to say would where a reasonable person would consider themselves not free to leave?
No.
Your microphone.
Hopefully, Representative Lynn will back me up on this, but not free to leave is the definition of detention. Not free to leave does not mean you are in custody. It has to be a restraint on freedom that is the functional equivalent of an arrest, whether they've been told they're under arrest or not. So not free to leave would bring us back to the detention under the law does not count as custody, and not free to leave is the test if somebody's detained.
Okay, thank you. Representative Newman.
Yes, thank you. I was listening to your testimony, and I'm not sure if I heard you clearly, but I thought I heard you say audio or video in one of your sentences.
Yes.
Okay, could I just follow up then in line 23 in the amendment when it says by audio and video? Are we talking the same thing?
If you read the beginning of that, it says means an audio recording or audio and video. So you can do an audio recording, but if you do a video recording, there's got to be an audio component to it also.
Thank you.
There being no further questions, again, sincerely, thank you for your testimony.
Thank you.
Oh, well, hold on, stand by. Oh, I didn't see you. Go ahead, Representative. Orhan.
Thank you, Chair, and thank you for taking my question. I'm not sure, I'm trying to think of how to phrase this, but we're now into the video age where we're requiring officers to wear body cams and when they're dealing with people. But you are saying that somebody can say, I don't want to be recorded, and has to put it in writing. So what happens to the body cams?
The two things. One, not all police departments have body cams yet. Certainly, for example, Portsmouth doesn't, in spite of some people's best efforts. Number two, if they would have to turn off the body cam during a recording of a confession, if the individual who would be recorded doesn't want to be recorded under the provisions of this amendment. So they would have to turn the body cam off, and all the body cam regulations and policies I've seen allow for a request within certain limits to not have a conversation with the police recorded. And this circumstance would certainly fall within that.
Follow up.
So I could also say, playing devil's advocate, so if...
That's actually my job.
Well, I'm going to try it. So basically, anybody that reads this law could go to the last line and say, when they're being interviewed or interrogated, I don't want to be recorded, and so it would be useless for the police departments to have video and audio if everybody that's being interviewed or decides to invoke that requirement.
Yes, it would be, but I have to say, God knows I don't have any data on this, but I would be stunned if everybody chose not to be recorded. The huge majority of suspects would want the recording because they tend to be, in the first instance, very suspicious of the police. And they would see this as more of a protection than as something that would cause them trouble. There will be exceptions, and that's fine. My understanding from talking with the National Innocence Project is that there has that has not happened in jurisdictions. I think there's 26 states now that have some version of this provision. They have that has not been what has happened.
Representative Lynn.
Yes, thank you for taking my question. Just one other question in the section of the bill that establishes the exclusionary rule. There's a provision, if I recall correctly, that says if you don't record, if you interrogate and you don't record, and then on a second round of interrogation you do record, it's the exclusionary rule still applies. And this, in other words, it's a sort of
Yes.
cat out of the bag, and I understand that. My question is this: should there be some language in that section that limits it to the same subject matter? In other words, what I'm thinking about is, suppose the police, they arrest somebody, they interrogate the person, and they don't record it. And then subsequent to that, they get some information about a new crime, another crime that they had not asked about. And maybe, for example, maybe they interrogate somebody on some drug offense or a minor theft or something like that. And then they get some evidence that the person, let's say, was involved in a homicide. Now they want to, with a recording, they interrogate him on the homicide. Would that be precluded from admissibility under the way the bill's drafted now? And if so, should there be some language that says it shouldn't be?
Well, if they didn't record as I understand the sequence, interrogation on the drug offense, no recording. Interrogation on the homicide, recording.
Right.
The homicide recording will be admissible under this. The drug offense will not be admissible because they didn't follow this law, and there's unless the suspect said, I don't want this recorded, and met the provisions of that exception. But short of that, if the drug interrogation was not recorded, it's a violation of the law, and there's no real logical reason it should be accepted out of this. you know, and number two, I think part of the gist of your question, and I apologize to the rest of the committee because we're going to descend into legal stuff, you know, that's the Oregon versus Elstad sequence of cases about consecutive confessions. So number two. Number three, I don't, well, I'll leave it at that. I'm down to two now.
Okay, go while the getting is good. Thank you.
The committee now calls Cynthia Musso.
I think that's the right button. I'm Cynthia Musso. I'm a staff attorney at the New England Innocence Project. I appreciate you hearing my words today. I came primarily to be able to answer questions, but I did want to speak to a couple of things that were raised and just sort of to drive home the point about the importance of this bill in this case. I think it's important to know just a little bit of background about me so that I can explain sort of where some of the things I'm going to say are coming from, which is that I was a public defender in this state and in Massachusetts for almost a decade, and before that I actually clerked in the trial courts. Actually, Judge Lynn was there briefly when I was there as well. What I wanted to talk about today is the fact that it is virtually something that we've learned as time has moved on is how prevalent false confessions can be. It's not something that's necessarily intuitive. It's not something that necessarily sits with everybody. You always think to yourself that you would never confess to something that you didn't do. But the reality is that the data that we have from false confession shows us that in almost a third of the confessions with DNA exonerations, there's been a false confession in those cases. A third, meaning almost 1 out of 3 of those cases where DNA proves you couldn't have done it, there was a confession from somebody. That's actually a fairly concerning statistic. It's a pretty high number. And I was very surprised by that when I joined NEEP. And that was from a public defender who had been in practice for a really long time. This bill is something that it's almost virtually impossible for us to determine whether something is a false confession without having a recording. And that's not because the police lie, and it's not because our clients lie. It's because people just have differing perceptions of the same event. You know, they always, that classic maxim of there's your side, my side, and the truth, right? It's just hard to pull those things apart. And the subtleties of interrogation are something that really need to be viewed in person. It's really something that you have to be able to see and hear to understand and to pull apart. Our experts, when we consult with them on these types of cases with false confessions, always ask for a recording, and it makes it essentially impossible for them to give an opinion when there isn't a recording in the case. The only thing you can tell is the substance of the questions, not anything about the particular tone, the physical circumstances of the interrogation, sometimes the state of the person that's being interrogated. You can't tell that from a recording. You can't tell if they're tired, if they're hungry, if they're worn out, if they're, you know, laying down on the table. All of those things are missing when you don't have a recording. It's a pretty common sense bill, so common sense that 30 other states already have a recording bill in place. And so it really has a lot of importance for a fairly small ask, because the reality is that so much of New Hampshire already does this. I know that because I practiced in Manchester, which is one of the bigger jurisdictions, and there was never a case where I didn't get a recording from, you know, when we had like a confession case. And the practical reality is that eliminated litigation around that issue in court, because when you have the recording, you can check that out. It cuts down on coming to court and arguing about those things. In terms of, I heard a couple of comments about sort of like a concern over like the alteration of a recording, potentially. And I know we had a case in Massachusetts around a recording being altered, actually, by the police department. And because of the way technology is, we were really able to pull that apart. But the reality is this was a police department that altered this recording. If we hadn't had that recording at all, right, we would never even have been able to tell it was altered. And the version of events that was actually occurred was only ever going to be what was testified to. We would never have been able to pull that apart. There is tech that we can use to try and pull apart alterations as well. I hear that concern that you raised. I think that's a really valid concern, but we do have ways of addressing that, and I think it is a logistics issue in the end about providing recorded copies of things. The other thing I wanted to speak about was one of the issues that we've heard a couple of times is sort of an issue around the consent piece. And I mean, I think the state is so careful about consent and being recorded, right? We have this wiretapping statute in the state for a reason, and there are exceptions that are built into that statute. Some of them are for law enforcement, but they still usually require a warrant. And so this is still in compliance with that statute, and we're still trying to make sure that this statute wouldn't supersede or override that. So there would still be a wiretapping issue even if this piece about the consent piece wasn't there. These are in compliance with each other. So those are a couple of the issues I wanted to address, just to highlight a couple of things. And if anybody has any questions, I'm happy to take them.
Representative Marston.
Thank you, Mr. Chairman, for your indulgence on me. My simple question, I'm not 100% sure in my mind, are you in favor of the bill or opposed to the bill?
In favor. In favor.
Representative Muse.
Yes, thank you for taking my question. And you may not be able to answer this, but I would assume, and I may be incorrect, that police standards and training has some type of documentation around standards for recording like this, if police are actually already doing it. Do you know if something like that exists?
I don't think there's a requirement at this time. I'm not going to say I know specifically that the answer to that question. I don't think there's a requirement. There may be a sort of a suggested best practices, but I don't know that there's a requirement. There might be, I know Rep. Roy mentioned that he had gone to the academy, so maybe he would actually know the answer to that question, but I don't know. I think there's no requirement, although there may be a discussion for best practices.
And that was actually 30 years ago in Massachusetts. There being no further questions, thank you. Oh, sorry, Representative True, I didn't see you back there.
Thank you, Mr. Chair. And thank you for taking my question. I got a question on, you said 1 out of 3 confessions are false confessions. How does the recording prevent that? Because if a guy is if I'm being recorded and I say, yeah, I did it, but I didn't, how does that recording play into it?
That's a good question. So I think the reality is that what these things have shown us over time is when we have recordings, we have records. And when we create a record, we create things that we can learn from. So I think the reality is that there's been a lot of police standards and training that have actually changed. As you said, 30 years ago, this was how things were, and things change over time. So what happens is when we have these records, first of all, with the remedy that we've put into the statute, it keeps things out of court. So it encourages police to engage in the best practices, and it shows the folks that are being under arrest that everything is going to be recorded, and that they're going to have to also be honest about what's going on. And I think what ends up happening is we create sort of a data set, essentially, that says, this is how, here's the false confessions, here's the ones we know that are false because of these DNA exonerations, and here's the practices that we saw that were engaged in during those interrogations, and these are practices that we shouldn't engage in anymore. That's how we've actually learned over time. In the statistic that I cited, the almost 1 out of 3, that's how we learned that some of the interrogation tactics that were being used are not effective in terms of generating truthful confessions. So I think the reality is that the prevention is in the learning, and it's in the gathering, and it's also in the remedy that we've put in the statute.
Thank you.
Representative Lynn.
Can I just ask one question? I understand the section, which I think makes sense, in Section 2 of the bill that says if the person says they don't want to be recorded, then the recording doesn't have to occur. But I have some question about the proviso that says provided that this request is preserved by electronic recording or in a written document, because I guess what I'm concerned about is what about the person, if you say to somebody says, I don't want to be recorded, and you say, okay, we won't record you then, but just sign this, or just let me just record this, they may very well say, I'm not doing that either. And so that does seem to me to be a pretty big proviso that could undercut a lot of what you're intending to get at.
I think the reality is, and that obviously is a concern. I think the question in the first instance, is essentially, I agree with you. I think those are those would come hand in hand, right? You don't want to be recorded and you're not going to sign anything. Like, that would not surprise me that somebody that would say one would say the other. I think the reality is that that would then be something that would fall under the sort of generalized exception, which is like, this is what happened and I couldn't do it because, we have sort of a catch-all provision. I'm going to have to scramble around to find the exact number here. So it's just sort of the overcoming the presumption of inadmissibility. So the reality is that the statements are admissible under law, they're proven by clear and convincing evidence to have been made voluntarily, and they have a reasonable justification for why they didn't. So I think the reality is it would sort of be a catch-all there for that.
Just one
Follow-up.
Thank you. I'm just wondering, would an acceptable alternative to this be some kind of a provision that says that if the person says, I don't want to be recorded, the police officer conducting the interrogation has to make, has to sort of make a note of that and date and time it immediately, so that you have at least some record that is contemporaneous, that the person said, I don't want to be recorded, or I don't want to give a written statement or whatever. I don't want to be recorded, I guess is.
I actually think there was, when we were originally speaking about this, I think there was a discussion that if, like in this catch-all, for example, which is what I'm saying covers it, that there would be sort of a written, like contemporaneous, a written contemporaneous recording of that. So I don't have a problem with that.
Thank you very much for taking
Well, I'm going to ask one last one myself. If this is the law that they shall be audio be recorded, wouldn't it not be the case that every interview would start with the recording on, and therefore the suspect saying I don't want to be recorded would be captured, and at that point it would be terminated?
I think that's also the theory when you're going to be, in a custodial situation. I think that's exactly the theory, yeah.
Okay. All right, thank you. Representative Burt.
Thank you, Mr. Chairman, and thank you for taking my question. Wouldn't it just be easier if we could educate everybody to shut their mouth and don't talk?
That's not an appropriate question, so you don't answer that, please. There being no further questions, thank you for your testimony.
Thank you.
Is anybody else? I don't know. I couldn't hear. Yeah. Yes, go ahead. The mic. We can't hear you.
I drafted the change to the language in the definition of custodial interrogation that I talked about with Representative Lynn. I showed it to him, and he had no problem with that. Representative Welch is actually taking that down to get that into the amendment. I know this is an early bill and needs to be reported out, so I just want the chair to know and the committee to know that's in process.
We are so advised. Thank you very much. We are going to now close the public hearing on HB 1540. And I just want to say I think the members of the committee and the public is better served for having heard this debate. We are now going to stand in recess until 9:45.
Gary Hopper. Good morning. At this time, we are now going to open the public hearing on HB 1296. It's a hearing to discuss a non-germane amendment that is amendment number 2022-0264H. This time, the chair will recognize Representative Sylvia to discuss the amendment.
Thank you, Mr. Chairman, and thank you, committee members, for listening to my testimony again on this rather substantial amendment. We started out looking at the presumptions under the asset forfeiture section of 318B, and the chair, using his great skills as a lawyer, decided that the process was divided. So let me describe the process as it works now and what we're doing with this amendment just broadly. Currently, after 2016, we instituted the policy of criminal asset forfeiture, replacing civil asset forfeiture for in-state process. And when we did that, and Judiciary has worked on this for years, we set it up with two tracks: a criminal process for the criminal charge, if there is one, and then putting aside the civil prosecution against the asset that might be connected to the crime, if there is one. So there were basically two tracks. The civil forfeiture side was set to the side while the criminal process went on. And then after the criminal process was settled, then the state could move to the forfeiture side of the process, and that would be a civil process. And what we were looking at previously was the evidence standard, which would be applied, whether it's preponderance of the evidence or, as in a criminal case, thank you, beyond reasonable doubt. Okay, so we have those two processes, and this amendment brings them together. And let's see where I want to go with this. So page 1 is all of the current law. And then we get to the bottom of page 2, section E is new. And this has been added to protect small seizures. $200 cash, anyone going to get a bag of groceries these days that uses cash is going to have $200 with them. In vehicles, a $2,000 car is not exactly the drug dealer's favorite choice. Well, they might, and they wouldn't care, but someone that is of less means, that's their way of getting to work or the grocery store. So we've taken and put that outside of the reach of law enforcement. In general, in asset forfeiture, the vast majority of seizures and forfeitures are below $10,000 in value. So this is, it's fairly uncommon to come across the big dealers, which is what we're looking for. But so we're really trying to focus on the state process, the criminal asset forfeiture, and unifying those processes. On top of page 3, we make sure that the defendant does not waive their rights. They cannot waive their right. So it's Typically, if you have something, a car of $2,000 value, you're not going to hire a lawyer to try and get that car back. It's going to cost you more than $2,000 just for the lawyer. So you're basically out that. So we want to make sure that it's not just taking assets that are going to be waived, so that there is some protection there. Down at line 23 on page 3, this is where the current civil side of things begins, and it puts aside, and the Department of Justice would have to file within 60 days to lock in that asset so that it's becomes part of or tied to a criminal process. Going to page 4. So here we're adding the asset to the duties of the public defender because we're unifying this process. The court, all the lawyers involved, the prosecutors, they know all of the information having to do with all of this process. The asset that seized, it's got to be inventoried if it's connected to criminal activity. You certainly want to know that. So all of the information is there. This adds protection for those who are served by a public defender, and at a very minimal expense. You know, the defender is already looking at the case, prosecutors are already looking at the case. So this just unifies it so the process can be brought together, and in the end, that asset, if there is a conviction, will be part of the sentencing. And there's also in here protection for the constitutional right of proportional justice or punishment. So page 4 is laying out the process involved in all of the details, and I do believe the court will have some comments on that to perhaps tighten things up a little bit. The information about the asset is going to be separated from the jury so that they're not making a judgment based on that evidence and prejudicing the jury. Of course, we also have protections for innocent owners. If someone's mother lends a son a car and she thinks her son's a good boy, and well, it turns out maybe he's not, or he just gets caught up in it, and mom needs that car for herself to get to work, we want to have protections for folks that are innocent. Also, you know, if a car is on lease or there's a debt owed on it, the bank or the dealership would have the access to get their funds back on that. As I say, we've gone through this a lot in the Judiciary Committee over the years. So a lot of this is new to you, I understand that, and it's perhaps a little thick to get through. We've gone through it quite a bit. I'm trying to hit the highlights here for you, and I'm sure you're going to have lots of questions. I've also got Lee McGrath from the Institute for Justice, who has been working on this nationally for quite a long time, who will fill in the gaps from my testimony. Then we get into some of the current language on the division of the forfeiture. After the forfeiture has been secured, then the 45% of the monies would go to the department that seized the asset. 45% would go to the Attorney General's drug forfeiture fund, and 10% goes to the Health and Human Services for drug rehabilitation and such. Also included in this is, in the last section here, at page 11, no, that is not it. Sorry, all of my notes are tucked away. So instead of me rambling further, I guess I'll take questions, and if you have technical questions, you might save those for the attorney behind me. So with that, I'll conclude.
Representative Pantelakis?
Thank you, Mr. Chairman. Excuse my voice. Thank you for taking this question. Why are we digging into the forfeiture law so deeply?
I'm sorry, we're digging into?
Why we're digging into this law so deeply?
Well, because we want to provide due process to people who have their assets seized, and possibly unjustly.
Second question.
Follow-up.
They are coming into this state selling our kids drugs and killing them. Why should we give them any breaks?
Well, respectfully, the process assumes innocence until guilt is proven.
Representative Bourdonnais.
Thank you, Mr. Chair. Thank you for taking my question. So, someone has been convicted in court, their property has been seized, and they have filed for an appeal. Their appeal results in a overturn of their conviction. Is their property returned?
That is the intent. Until the process is done, their property is still their property, and we may need to look at the language here to make sure that that is correct, and Attorney McGrath would have a better answer to that than I.
Thank you.
Representative Muse.
Thanks for taking my question. I did have a quick question. You have an exclusion around contraband. For the purposes of this statute, what is considered contraband?
So contraband would be certainly any illegal drugs, drugs with no prescription. Contraband could be, I suppose anything that's not legal to have. Counterfeit money would be contraband.
Thank you.
Representative Conley.
Thank you, and thank you for taking the question. So my name is on this. Although I'm not, I guess that notwithstanding, I'm sympathetic to what you're trying to do with asset forfeiture and the changes you proposed. What I'm a little bit curious about, and I didn't hear a clear answer, is why take a one-page bill and come back with a 10-page amendment that does nothing but muddy what you had previously proposed?
Well, I suppose that my explanation probably muddies things pretty much. But we started out with a very simple bill, and admittedly, this is a rather grand expansion, and this came about with discussions with Chairman Abbas, who's much more familiar with the process in court, and it was basically his idea, and Maine has a process like this, which unifies the criminal and civil process, so that while it's hard to digest, no doubt, much more difficult than the simple one that we even had a fair bit of discussion about. This is a process that is seeking to protect innocent people from having their assets taken unjustly. And I don't mind criminals losing their assets. That's perfectly fine. They should. And they should be, balanced with our constitutional command that it be proportional. So these are some of the issues that this amendment addresses. Yes, it is a grand expansion from what you started with, but it's something that we've been working on. And when we instituted the policy within the state to have criminal forfeiture instead of civil asset forfeiture, that criminal process protects due process much better.
There being no further questions, thank you for your testimony.
Thank you.
The committee now calls Lee McGrath.
Mr. Chairman, members of the committee, thank you for the opportunity to testify in favor of this amendment and this bill. My name is Lee McGrath. I'm the Senior Legislative Counsel for the Institute for Justice. Crime should not pay. It is legitimate for the state of New Hampshire to confiscate the fruit of crime. Nothing in that bill changes the principle. What this bill does is improve upon the policy that you enacted in 2016. In 2016, you said it was important in Senate Bill 522 to have a conviction in criminal court as a prerequisite to people losing their property. What we've subsequently learned is that there's a better way of achieving that policy goal, of ensuring that no one acquitted loses their property. And the better way of achieving New Hampshire's current policy is in this amendment. It is to merge the criminal prosecution and the forfeiture litigation into one single process, in one single courtroom, with one single judge, defense attorney, and prosecutor. So the way in which you might conceptualize this is streamlining it into a single process in which all the evidence is introduced in the criminal prosecution, and then after conviction, with all that evidence introduced, the judge, as part of the post-conviction determination, can determine whether title should transfer, whether the car is an instrument of the crime, whether the cash is the proceeds of the crime, all in one process, all streamlined. So you might think of what this bill does as making the loss of title to property, taking it out of a civil process and making it look a lot more like a sentence, a post-conviction determination by the judge that New Hampshire rightly confiscates title to some property. This is not new. North Carolina has done it since the 1990s. New Mexico, Nebraska, and just last session, Maine adopted this simplification, this unification. There are lots of benefits to this. One is you ensure that an indigent person gets representation not only of himself, but also his property through the public defender. Two, by uniting the process all in criminal court, you avoid a big but relatively unknown problem. And that is in the two-track system, there are lots of people who don't pursue the civil litigation and they default. They may be subsequently acquitted, but because they have defaulted, they haven't answered the notices, they haven't answered the civil complaint, they haven't hired an attorney to represent them in civil court, they lose title automatically, regardless of what happens in the criminal prosecution. So by uniting these two, you avoid what we have found in other states that can range between 80 and 90% of the cases in civil court end in default. Maine doesn't have that problem. Nebraska, New Mexico, North Carolina don't have that default problem. It's all done in one single process. This bill is also very pragmatic in that the requirement in criminal court that triggers the loss of title can be achieved through a plea bargain, or it can be achieved should the suspect choose to help law enforcement, help prosecutors in exchange for a less dramatic incarceration. Title, it can be achieved. There's an exception for death, deportation, fleeing, and abandonment. And so the bill builds in the pragmatism that the prosecutor will want as part of the criminal prosecution as it relates to transferring title to the state through forfeiture. The second big benefit, Mr. Chairman, this protects spouses, wives, girlfriends, boyfriends, parents. It changes how they go into court and try to get back their property that their husband, their boyfriend used without their consent. It changes the innocent owner claimant and his ability or her ability to go into court and say, I've always had the keys. I don't want him to use the car. He took the keys, he took the car against my will. So this bill does that both as part of a prompt post-seizure hearing known as a crim-stock hearing, and it also does it by creating a process, a process for the girlfriend, for the wife, to go in and say, here's my title. I didn't consent to the use of his use of the car. Finally, Mr. Chairman, one thing this bill doesn't do, it doesn't change the distribution of proceeds. And so, when forfeited, when that car has title transfers to the state, and that car is sold, or the cash transfers to the state, it will still be distributed as current law distributes. So, in conclusion, Mr. Chairman, this is a more efficient process, a simpler process, and it is the process that realizes New Hampshire's policy that it has had for 6 years of first a conviction and then a discussion about transferring title. Mr. Chairman, I stand ready to answer the committee's, including the question about appeals.
Representative Green.
Thank you, Mr. Chair. Thank you for taking my question. What if the property was in a trust? How does this work?
Mr. Chairman, Representative, give me an example. So usually the example is someone's driving along the highway and they get stopped, the car is seized, the cash is seized. But give me the hypothetical that you're thinking of.
Well, the person's property, their land, their home, their automobiles is all set up in a trust.
Yes.
How would that be affected?
So it would operate the same, that the person, that this is principally a crime. So that person committed the person committed a crime. And then did he use that land? Did he use that land to make let me expand your hypothetical.
Right.
As a lab for meth. Then he loses, if convicted, he loses the title, and that trust is pierced.
Okay. Thank you.
Representative Marston.
Thank you, Mr. Chairman, and thank you for taking my question.
Yes, sir.
Which is a follow-up to his.
Yes.
Put the trust in two people's names.
Yes.
One is the criminal, one
Yes.
isn't.
Yes.
What happens?
So this is the innocent. Let's, for the sake of ease, let's say the criminal is the husband and the
Mrs.
is the missus. She can go into court. She can argue, look, I own this property. I don't own half of it. I own my 100% share of it. I did not consent for him to use the trust assets as part of the crime. I did not know he was baking meth in the basement. I haven't been to the house for years. She is an innocent owner claimant. She walks into court, and the burden is on the state to show that she did know, she did consent, she did have actual knowledge. And so her interests are protected whether they are in a trust or whether she owns them herself.
Follow-up?
Follow-up.
So I'm assuming, and that's the bad word, because I'm using my own particular situation.
Yes, sir.
My wife and I are in everything we own is in trust. And we both kind of enjoy each whatever benefits if something happens to either one of us.
Yes, sir.
So in that case, because the criminal side of that trust, which is equally in joint, everybody loses.
If you and your wife are Mr. Chairman, dare I extend the hypothetical? If you and your wife are both charged and you and your wife are both convicted, you and your wife lose the land that was an instrument of your crime. Yes, but the earlier hypothetical was one where she was completely innocent.
She still loses.
She, where she is a defendant, a co-defendant with you, and you and she are convicted, both of you lose the property when it is shown to be the instrument of the crime for which you have been convicted.
Follow-up.
Oh, let me just answer. What he's saying is that if she does not lose, if you are convicted and she didn't know what you were doing, she would be able to go to this hearing and say that I had no idea, and the state would have to prove she did. Does that answer your question?
I believe so, Mr. Chairman. Thank
Okay.
you.
Yeah, thanks.
Thank you.
Representative Ahern.
Thank you, Mr. Chair. Thank you for taking my question. How many forfeiture cases are there in New Hampshire yearly?
Mr. Chairman, Representative, New Hampshire has a reporting requirement, but unfortunately, the Attorney General has not met those requirements. So we do not have a fixed number on the. We do not know exactly how many forfeiture cases there are in New Hampshire.
You don't know exactly. Follow up. You don't know exactly, but do you have an average?
I'm sorry to use the word exactly, Mr. Chairman. No.
I'm informed we have a member of the AG's office who's going to testify.
So, Mr. Chairman, we do know the dollar amounts. We know that since 2000 to 2019, under New Hampshire state law, there's been approximately $3 million forfeited under state law. That's different from the $22 million that's forfeited under federal law. And so you could take $3 million divided by 20 years, and you have roughly $150,000 a year is forfeited, if I did the math correctly in my head, forfeited under New Hampshire state law.
Representative Newman.
Thank you, Mr. Chair, and thank you for taking my question. I'm looking at the original bill, and the second sentence follows up on Representative Marston's thing that takes who has to prove it. The claimant used to have to prove it, now the state has to prove it. Would that be a correct thing? And let me just ask a question, finish the question with the first sentence talks about whatever we are talking about as the property has to be in proximity. And I'm just wondering if that proximity requirement in the sentence that was taken out is covered in the new bill. Thank you.
Mr. Chairman, Representative, I do not believe that that issue of proximity is imported from existing law into the amendment. I'll need to check whether it was deleted or not from the amendment, and I will do that and inform Representative Sylvia to report back. The key component to this is that once convicted in criminal court, it's relatively easy to show that the car was an instrument of the crime and the cash was the proceeds of the crime. Because in that prosecution, evidence gets introduced. And so the sort of technicality that the original bill attempted to address, implicit, and I'll check to see if we deleted it, if it's deleted, but that it is implicitly addressed by the fact that that all of this is happening in criminal court.
Who's first? Representative Bourdonnais.
Thank you, Mr. Chair. Thank you for taking my questions. I need a little clarification on what happens if property is seized that belongs to someone else. For example, you're a drug arrest, the car is being used, is only partially owned by the defendant. And that car is seized. But the business that owns the car, it loses that property. Do they lose it forever, or what happens?
Mr. Chairman, Representative, so you're right. There are two types of property owners that this bill is addressing. One is the defendant, but let's focus in on the other type of property owner that your question addresses. And that is the lender, the fleet owner, the secured creditor, the wife, the girlfriend, the boyfriend, the parent, the grandparent, the neighbor. these are all taken care of in two ways. One is that person can go into court in a prompt post-seizure hearing and say, wait a second, I'm the secured lender. I didn't authorize him to or consent to his using the car. Or the wife, I didn't know about his using the car. So there's a prompt post-seizure hearing that can take place as few as in 10 days to get back, for the innocent owner claimant and the secured creditor to get back that vehicle that has been seized.
Follow up? What if there is no innocent party? And so they're waiting for months to a year for a trial, and they basically have lost use of their property.
So, Mr. Chairman, if I could, Representative, let me just clarify. We're back talking about the defendant.
Yes.
Okay. So the defendant is stopped, his car is seized, he's charged with a crime. Yes, that car sits in the impound lot unless there are some mitigating circumstances that he can go and ask for a prompt post-seizure hearing as well. But he will have a harder time. And so he does lose use of that car during the criminal prosecution. But if he could show in the post-prompt seizure hearing that perhaps the stop was wrong, unconstitutional, then he can go and have this crim stock, this prompt post-seizure hearing, and get his car back.
Just stand by. Quick question: is a third party able to intervene? For example, Bank of America owns the car; it's financed.
Yes.
Could they intervene and say, "We want to repossess this car"?
Yes.
Prior to waiting for the conviction.
Yes. So that's the prompt post-seizure hearing. Famous case, Crimstock, that gets Bank of America, gets the wife right into court very fast, doesn't have to wait for the criminal prosecution, everything that's happening to the defendant.
Representative Bournet, you're following.
Thank you. Thank you for taking my question. So now we're no longer talking about car. We're talking about land that was seized. And that land was seized as part of the drug offense. And of course, a lot of land is not owned outright by the defendant. It's owned jointly by them and a loaning institution. So, as part of criminal proceedings, the land is seized by the state. The defendant is convicted. He appeals his conviction, and the verdict is overruled. Meanwhile, many months have gone by. The bank, our lending organization, has missed payment. The defendant may have lost control of the land itself, so he has no other place to live. In fact, has no place to live. And after a year, 2 years, I don't know how long these cases drag on. They could, especially with an appeal case. The defendant has lost. He's no longer able to afford to pay the loan. The bank says, "I'm seizing this property, even though you've been found guilty, innocent." And what's the recourse?
Mr. Chairman, Representative, this is a good hypothetical. So we're focused in once again on the defendant. We're not focused in on the innocent owner claimant, the wife, or the the bank. And so banking laws exist and must be followed, and you must pay, and this bill does not change the authority or the power of the lender to reclaim the property when the regardless of whether the bank can still proceed under New Hampshire banking laws to take title when the borrower fails to pay. So there's in this hypothetical, and land doesn't happen a lot. Most of this is cars and cash, but in this hypothetical, yes, this banking laws are not part of this bill, do not get changed. If he fails to make his payments, the bank may exercise their right to take title to the land.
Representative Panalakis.
You say that a person, the wife or the mother or the father, are innocent people. But my question is are they benefiting from the drug money that has been seized?
Mr. Chairman and Representative, no. In that the state can show that the proceeds from drug sales by the defendant went, if the state can show that it went to the payment of the car, the periodic car payments, then then the wife is not innocent. And so the fruit of crime, the instruments of crime should go to the state. And that's the underlying concept of the bill. Crime shouldn't pay. Assets should be confiscated.
Follow-up?
Follow-up.
I think you're misunderstanding what I'm saying. I am saying if the wife or the mother or any of them is benefiting, like paying rent or food or anything else from this money, would you say that they shouldn't be, the car shouldn't be confiscated?
Representative, would you mind, the last part of your question I missed.
You're saying that the wife or mother or father is innocent and they should have their car, but are they benefiting, like getting food, rent, and whatnot from this drug money?
Mr. Chairman, Representative, the bill is focused on taking fruits and instruments of crime. It doesn't go so far as to engage in the moral condemnation of someone who may benefit from, who's not a criminal, who is not charged, but who may be able to buy food because the defendant gave them a few bucks. It doesn't go that far.
Thank you.
Representative Lynn.
Thank you, Mr. Chairman. Thank you for taking my question. The only question I have is this. Let's say we're focusing on the defendant. Is there anything in this bill that would require the state in the criminal trial of the defendant to prove the facts that make, let's say, the car subject to forfeiture?
Mr. Chairman, Representative Lynn, no.
Okay.
So all of that happens in a post-conviction hearing.
All right. So in other words, the state, if I may follow up, if in the criminal case itself, it's not particularly important to the state in proving its case to show who owned the car that the defendant arrived in and all that, and it would be sort of extraneous. They can not bother with that stuff in the criminal trial, and then deal with it later.
Mr. Chairman, Representative Lynn, yes.
Okay, thank you.
Representative True.
Thank you, Mr. Chair, and thank you for taking my question. I was pre-med, not pre-law. Talking on the amendment, the change, a big change that it's making to a current law is that once a person is found guilty in the court case or found innocent, immediately after that, the judge decides, what about all this stuff? What about the money? What about the car? Is that correct?
Mr. Chair, Representative True, you're very close. Indulge me for just a second, and then I'll say yes. New Hampshire in 2016 set a policy. It says conviction in 2000. It's not in the bill. In 2016, SB 522 said we want convictions to happen as a prerequisite to losing title. This bill takes that concept takes that concept and perfects it, improves it into the single process that you just described. So the answer to your question is yes. It's all happening in the criminal court, the criminal prosecution. The person must be first convicted. If he is acquitted, the case is over, the car gets returned, the cash gets returned. So the answer to your question is yes.
Follow up.
Thank you, Mr. Chair, and thank you again for taking my question. So now for something totally nothing to do with that. On page 2 of the amendment, starting down around line 30, it's talking about $200 or less, or a motor vehicle of $2,000 or less exempt from seizure.
Yes.
Why 2,000? I mean, a $2,000 car probably can't pass inspection. I mean, what about my car that's like brand new and like it's $10,000 or whatever? Why the 2,000? What's the purpose of that?
Mr. Chairman and Representative True, we had to pick a number. This is a be completely, this is an amount of minimal dollars, minimal car value that is so small that we're not even going to allow these assets to enter into the system. And so we wanted to make it so that it was to point out that there are some types of assets that are so small, so minimal, that it is cost inefficient for everyone, for the police, the prosecutor, the public defender, the criminal defense lawyer, to even bother with trying to link certain assets to a crime. And so the goal was to make it small, not big.
Thank you.
Representative Schultz.
Thank you, Mr. Chair. Hi, I'm a substitute for today. I'm Representative Schultz from Concord. Thank you for taking my question. Hearing the other questions leads me to think of one regarding that same section, and that is, how do I put this? Some ladies have really bad taste in guys, and they may not have any means, if everything is seized, to take care of themselves or their children. Why wouldn't there be a provision that would account for their financial well-being for at least a period of time while they transition? I hate to see children, families being punished for the criminal behavior of a spouse. And yeah, like I said, some ladies have really bad taste.
Just for the record, the chair would like to state that the opposite is also true.
I was waiting for that.
Mr. Chair, Representative Schultz, so you are right to focus on the innocent person and not the defendant. And love oftentimes isn't so rational. So what the bill rightly does addresses your concern. The bill rightly does two important things. One, it allows that wife, that girlfriend, that husband, that boyfriend, to get into court fast. And that's the prompt post-seizure hearing. I'm referring to Crimstock is the name of the case. That's her greatest salvation. The second thing that it does, to her benefit, it flips the burden of proof. If she shows up and says, here's my title, see, it's got my name on it, then the burden of proof flips to the government to show that she actually did consent and did have actual knowledge. And so her getting the car back is faster and easier under this bill by the prompt post-seizure hearing and the flipping of the burden of the burden of proof, yes.
Representative Muse.
Thank you for taking my question. I'm curious if this amendment effectively eliminates civil asset forfeiture in the state of New Hampshire?
Mr. Chairman, Representative, yes, as it relates to these crimes. And that's what we want. It is an unnecessary process that is inconsistent with the policy established by the state. And so there's no rewards, no extra rewards here for convicted drug dealers. Crime shouldn't pay. All we're doing is streamlining, unifying the process to protect those who haven't been charged, those who have been acquitted, and in this case, those who are innocent owner claimants. So the best way to think about that, Mr. Chairman, if you would indulge me for just a second, is when does civil forfeiture make sense? It makes sense in the Port of Boston. If Portsmouth has a port, the Port of Portsmouth. It makes sense when the owner of the property is in England or Ireland or Argentina, and law enforcement can't get personal jurisdiction over that owner of the property, and therefore in rem jurisdiction, litigation against the property in civil court makes perfect sense in admiralty law, because the state of New Hampshire has not gained personal jurisdiction over the human being. By contrast, this bill says, look, we do gain personal jurisdiction over the human being. So therefore, let's not engage in this artifice of litigating against a car and litigating against cash.
Representative Conley.
Question of the chair.
State question.
I have practical questions, but I'm wondering, do we have other witnesses who are intending to testify on this that maybe would be best suited to answer some questions?
Yes.
Thank you.
There being no further questions, thank you for your testimony.
Thank you, Mr. Chair. Thank you, members.
The committee now calls Attorney Richard Head, Judicial Branch.
Good morning, Mr. Chairman, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. I did want to take you through the bill or the amendment briefly. We haven't had a lot of time to digest it, so there's probably other things that we could talk about, but sort of big picture is there are a number of elements of this bill that will need to be worked on. It has sort of inconsistencies with either the current system of circuit court, superior court, and it also has fiscal impacts that I'll briefly talk about. With regard to the overall policy, of the judicial branch does not take a position. Some of these are just nits, but they're things that just need to be addressed at some point. So running through the bill, page 2, line 11, references municipal district or superior court. There are no municipal courts. The district court is a division now of the circuit court, so it's district division of circuit court. You can just reference circuit court there instead of either municipal or district. On page 3, starting at the top, line 3, is the waiver provision you heard discussed earlier. Just to clarify, at least what I think that means and what it's intended to mean, and this would be a policy of the committee that you would have to adopt, is that it says a document purporting to waive interest or rights in seized property shall be void and inadmissible in court. That would mean in the event, so for example, during a sentencing or a plea bargain, this would be a separate type of process that could not be waived by the defendant in the course of engaging in their plea bargain. At least we think that's what is intended by the way it's written, so that you would have to still have a separate proceeding, even if the party wanted to waive the interest. Continuing on down, page 3, beginning at line 16 to 18, which I think is current language, talks about the initiation of administrative or judicial proceedings against the property. Not sure exactly, we couldn't quite figure out how that ties to page 4, line 32, which talks about in a case in which the state seeks forfeiture of property, the prosecuting authority shall file with the court a notice of proposed forfeiture. We just were unclear as to how those two proceedings were being tied together in these separate sections. Continuing on, page 3, lines 21 to 22, talks about what would happen if the Attorney General's office determines that the proceedings probably cannot be sustained, and talks about making a written report of findings to the seizing agency, and if appropriate, authorize and direct the release of the property. There's no connection there to if there's to the courts and what the courts are told if these occur. There seems to be a procedural gap in that particular section. If we turn to page 4, sort of a significant shift in terms of some cost issues. So on line 8, talks about it being a part of the criminal prosecution and following a conviction for a felony, a conviction for felony violation of the chapter. And then it goes on in the next line, line 10 of page 4, if a defendant in a criminal matter is represented by a public defender, the public defender shall represent the defendant. That has the potential to have a significant impact on the public defender's office. I don't know if they were reached out to or the Judicial Council, which deals with indigent defense costs in terms of the ultimate fiscal impact of that type of a provision. Again, not weighing in on the policy, but that has a potential significant impact, not only on just fiscal, but also workload, which I imagine you've heard just the extreme workload pressures that the public defender is currently operating under. Continuing on, page 4, line 14 and 15 talks about giving post-seizure hearings a priority on the court's docket. There are a number of things that the legislature asks the courts to put as a priority. And the more things you put as a priority, it just means that other things are getting pushed. We have a limited number of judges, a limited number of ways in which cases can be managed. So the more that gets pushed towards a priority, other things, civil cases, get pushed to the rear of the line, just almost by physics, as you push more into the expedited or priority dockets. Looking at again, page 4, line 20 to 21. This is, I think, an issue that may not be, a lot of this is taken out of some national language, I imagine, where we have circuit court and superior court, and there's a bill that is currently in the legislature that passed the Judiciary Committee that would rewind felonies first. And this particular language in this bill, assuming the felonies first rewind occurs, has just a significant impact on the circuit courts, because under the rewind of felonies first, felonies would first be heard in the circuit court, and the probable cause hearings would be heard in circuit court. They're then bound over. They're felonies, they get bound over to superior court. So there's not sort of the same judge, same trial, same court in those proceedings. There's a bound over process where those go to the superior court, but the probable cause hearing is done in the circuit court if felonies first is in fact rewound under House Bill 1597. It's then also unclear in lines 22 of 23 of page 4 where the party may move for an extension of no more than 10 days. So again, is that an extension that would be, essentially when would that extension request be made? From a management of caseloads, is this occurring at the probable cause hearing stage, 85% of which are waived anyway? Is that occurring essentially on the day of the probable cause hearing, some number of days before? Exactly when is that happening? Because as a court management process, these cases are being scheduled, and as a result of what goes on the schedule, other things do not go on the schedule. So if we're learning about a request for an extension of 10 days on the day something is scheduled, that's a gap that we could have filled with other cases and other activities. And then it requires 10 days. Again, we're talking about management of an incredibly complicated docket process. So the circuit court, as of the end of December, had just under 200,000 cases pending. So we are managing a huge volume of cases on a day-to-day basis, and the clerks are doing just a remarkable job in doing that. Anytime you bump something 10 days, that ripple in the system sort of has an overall impact on the management of cases within the circuit court. So it's not, it reads very simply, it's just a 10-day extension. It has, and those types of things have significant just case management and docket management impacts within the circuit court. There's just some language we're unclear of. So if you turn to page 5, line 9, the prosecuting attorney shall serve the charging instrument amendment and notice as provided by the rules of the court. Not exactly sure if that means the indictment or a complaint or whatever. And by the way, throughout this, there's references to petitions. And if those are in civil cases at least, and some of this does seem to imply filings that are occurring outside of the criminal docket, those would be complaints, not petitions, for the most part anyway. But there's a certain amount of uncertainty as to when some of these petitions that show up later in the bill or in this amendment would come into play. And also, by the way, the reference to the court's rules, these are rules that we're going to need to create, and there's going to have to be some sort of a process in which these rules exist both in the circuit court and the superior court if we're talking about felonies that are going to get bound over, if in fact felonies first rewind does take place, and ultimately the legislature supports that. Looking at page 6 of the amendment, lines 5 and 6, the defendant may petition the court to determine before trial, at trial, or upon conviction whether the forfeiture is unconstitutionally excessive. Unclear again if that's being filed in the criminal docket, if that's a new petition that's being filed in superior court. Not a lot of clarity in terms of what is the intent of that petition, when it's being filed, and into what case it's being filed. Similarly, on line 30 of page 6, There's another opportunity for the court to be scheduling hearings on petitions within 30 days after its filing, or at the court's discretion. So we're assuming that that's a request for an expedited process, but again, somewhat unclear. And that point I made earlier about any time you put deadlines on something for the court, you're pushing something else out in a fairly complicated docket system. In terms of the innocent property owner defense on page 7, not a lot of definition is provided to that. It simply says what the innocent owner would have to submit, and then provides an opportunity for the court to hear the petition. Again, unclear as to what that petition is, where it's being filed, and we're assuming it's now a new civil case, but again, in terms of the outline of what's contained in the amendment.
If I may respectfully, it sounds like you have quite a voluminous list.
I'm done.
Oh, are you? Okay. What I'm going to ask is if you could submit that to us. You can send an email with that list.
I can sort of clean it up a little and try to send something.
And I would ask the sponsor to coordinate also as well with the representative from the court system if you intend on getting another amendment to us. And I'm going to ask the members to refrain from questions so that we can move this along, unless anyone has a really important question they'd like to ask. Representative Muse.
The original bill came to us without a fiscal note, and based on your testimony, it looks like from a cost perspective, we may be doing more than just shuffling the deck here. Can you quantify the additional cost or personnel that might be required to handle these additional process steps and additional hearings?
Off the top of my head, I can't quantify it, and in part it will depend upon where felonies first rewind goes. And then separately, there's a cost that would have to be associated with the indigent defense costs. So public defender's office and the Judicial Council would have to sort of evaluate how many additional cases would be generated as a result of this, and sort of what the additional procedures would trigger. So the short answer is I don't have an estimate today, and we haven't had really enough time with the amendment to sort of start to evaluate that level of it. But certainly there is a fiscal impact generally.
Thank you for your testimony. And
Thank you.
Look forward to seeing that list.
The committee now calls Buzz Scher.
I would ask the remaining 4 witnesses if they could possibly keep their testimony to 2 minutes, as we're running behind on another bill.
My name is Buzz. My name is Buzz Scher. For the record, I'm a police commissioner in Portsmouth, a law professor at UNH Law. My opinions are mine only and not of UNH Law or the Portsmouth Police Commission. I will be uncharacteristically brief. The concept behind this bill I'm very supportive of. Historically, the civil forfeiture process has been much abused. That said, I can't testify in support of it because the impact on the public defender program would be very significant. Appreciate that it's not simply a matter of giving them more money so they can hire the lawyers to staff the program. They are at a point now where they're trying to hire new lawyers, particularly lateral hires from within and without the state, outside the state, and they're not able to keep up at all with the number of lawyers that are leaving the program, given the already excessive caseloads. So it's a bigger problem than it is a problem that it would cost a lot of money to staff up the public defender program to handle this, but it's a bigger problem than that because even if they had all the money, they couldn't staff it up anytime soon. So with that, my testimony is over. I believe I came in under 2 minutes.
You did, Allison. No questions. Thank you very much.
committee now calls Jeffrey Ware and Danielle Sakowski from the AG's office.
Thank you, Mr. Chairman, members of the committee. My name is Jeffrey Ward. I am a Senior Assistant Attorney General and the Chief of the Criminal Justice Bureau at the Attorney General's office. With me is Danielle Sakowski, who is the Chief of the Drug Prosecution Unit at our office as part of the Criminal Bureau there. We are here with concerns about this bill and the sea change that it would create and how drug forfeitures currently occur, as well as, and I'll try not to repeat both what Attorney Head said and what Attorney Scheer said, but certainly those are concerns about both costs associated and an already overburdened indigent defense system that's well publicized in the media that's at a crisis point, and then would add this all on top of it, in addition to a court system that has been backed up for some time. But based on what I heard from both the sponsor and those that spoke in favor of this, we see this really as a solution to a problem that doesn't exist. And while we haven't had much time to go over the amendment as it came in rather recently, I would urge the members of the committee that are considering this to look at our asset forfeiture guidelines that are available on our website. Much of the things that this seeks to address, we've already addressed through our asset forfeiture guidelines and our policies when dealing with asset forfeiture. I would also suggest to you that the idea, and I think Attorney Head and from the court system gave just a preview of this, this is not a more efficient and simpler system by any stretch. This actually would significantly complicate the current system that we deal with. But what I heard in hearing the testimony earlier was that this is a bill with all of its machinations. It seeks to protect innocent people from having their assets taken. What you didn't hear is that that's happening, because it's not happening. If we, typically speaking, in this process, the forfeiture, unless waived or defaulted, doesn't occur until after a conviction. We haven't had an instance where there's been an acquittal and an asset forfeiture, and at least in our recent collective memory before you here. If that were the case, we'd withdraw the asset forfeiture, and that's generally part of our policies and guidelines. So it seeks to solve an issue, the protection of criminally innocent people from having their assets taken, that doesn't exist. In addition, as to the, quote, innocent owner, as it's described in this statute, which is not, again, defined or necessarily identified, I think it's important for the committee to be aware that with drug dealers that we're dealing with here, and I know there are a lot of questions about property. Typically speaking, and this is outlined in our guidelines and in our protocols, we don't take property. I can't recall having done it. I've been at the Attorney General's office for almost 10 years. Danielle's been there almost as long. Attorney Sakowski, excuse me. We haven't taken property. So again, it's dealing with issues that aren't actually issues in reality. We currently have guidelines that say we don't seize cash under $1,000. We currently have guidelines that say we don't seize vehicles under $3,000. So again, it's addressing issues that aren't really there in practicality. So those are some of the highlights. I'm happy. I know we have limited time to answer questions, and I hope there would be some questions either here or at a future date about how the process actually works, and we'd have the opportunity in depth to describe that to you. But I understand you're pressed for time as well, so I've tried to keep it short anyway, which is not easy for us lawyers.
And the chair appreciates that. Is there anyone that has a question of import that they would like answered? Who did? Representative Hurd, you had a question?
I think he answered it.
Okay, very good. Seeing no further questions, we appreciate your time and testimony.
Thank you, Mr. Chair.
The committee now calls Ross Connolly, AFP NH.
Thank you, Mr. Chair, members of the committee. I will be very brief since I too am waiting for the next bill. My name's Ross Connolly. I'm the Deputy State Director for Americans for Prosperity here in New Hampshire. Here to voice our support for the amendment. We also supported the underlying bill. Really, the top line issue for us is the current system, since it goes through that civil process after the criminal process. In that civil process, a defendant is not given representation. So therefore, if property was seized of a certain amount, that it may not be worth somebody actually challenging that and trying to get their property back, since the legal fees might exceed the property that they're trying to get back. So we consider this step. Obviously, there's some technical issues that the committee has to work through, and we'd be happy to provide advice on that as well. But we view this as a good protection of property rights, creating a more efficient system, and protecting granted staters' right to due process, especially if they are acquitted. So with that, I'd be happy to take any questions if there are any.
Seeing no questions, thank you for your testimony.
Thank you very much.
The committee now calls Frank Knack, ACLU-NH.
Mr. Chairman, members of the committee, my colleague Lee covered most of the issues about why we strongly support HB 1296. I appreciate just hearing from the AG's office that they have, guidelines in place. I think it would be prudent on the committee to think just back a couple of years at the federal level. Under Holder, they put under guidelines to restrict abuses under the Equitable Sharing Program. A couple of years later, then Attorney General Sessions rescinded part of those guidelines. And so the fact that we have good guidelines in place now, I don't think should detract from the fact that we need strong laws in place to protect property owners in New Hampshire. I think one issue that hasn't been touched on, and I know we're short on time, is just the notion of what forfeiture is about. Forfeiture was sold to the public as this tool for getting the ill-gotten gains of drug kingpins. Think Pablo Escobar. Think the cartels. In reality, the way it has been deployed in New Hampshire and across the country is to target low-level, low-income people, some of whom have not been involved in any criminal action. So fortunately, New Hampshire took some positive steps back in 2016 to require a criminal conviction. But then again, in this process we have now, as my colleague Ross just noted, folks who are then found guilty, if their property has no nexus and they are indigent, they can't hire an attorney to then prove that their property has no nexus. And so I heard a lot of talk about burdens on the system. I think, we should all think about where that burden should really lie. If the government is attempting to take the property of someone, just because there's some problems with the government's ability to hire enough people, that shouldn't fall on property owners to have to handle. And that we should be able to, as a government, ensure that we have the checks and balances in place to ensure that innocent property owners and people who have no nexus between the crime and the property are protected. So thank you.
Thank you for your testimony. Sorry, Representative Muse, I didn't see you back there. Go ahead.
Thank you. One quick question. There seems to be a disconnect between what you're saying and what the Attorney General's office said. Just to recap quickly, they said that this is not a problem in New Hampshire. This is not happening. You're saying that it is, and it's a serious enough problem that we should be passing this bill. I'm wondering, where is your information coming from, and can you quantify the level of the problem in New Hampshire?
Absolutely. So unfortunately, the AG, as Mr. McGrath noted, the reporting hasn't been conducted, so we actually don't have data in New Hampshire. We do know from numerous articles and stories that have been reported on that led to the forfeiture reforms back in 2016, that New Hampshire has had a pattern of forfeiture abuses. And so we would appreciate that the state would then come forward with records of what's happening on the ground now. But I've worked on this issue in a number of states. The patterns have been consistent, that forfeitures are abused and that we need to have these laws in place. And this is just the latest iteration of streamlining the process. We are ensuring that the process, that you don't have to have the judge retrained on the facts, that the counselor not have to be retrained on the facts. By having a streamlined process, I understood that that somehow it would create confusion, but when you think about it practically speaking, you have a single process where everyone is up to speed on the facts of the case, and that's the most streamlined way we could think about doing something.
Thank you.
Thank you.
Thank you for your testimony.
Thank you.
At this time, I'm going to close the public hearing on HB 1296, and I'm going to open the public hearing on HB 1476.
I'm liking this improvement in the chairman already.
The committee now calls Representative Ross Berry.
Thank you, Mr. Chairman and members of the committee. My name is Ross Berry. I'm a state representative for Hillsborough 44, which is South Manchester, wards 8 and 9, and the town of Litchfield. I come today to present HB 1476 FN. It is a bill addressing bail, which you guys have never talked about that here before, right? So the issue with bail in general, the state legislature passed personal recognizance bail, also known as cashless bail, a couple of years ago. The intentions of the legislator at the time were, I think, a noble cause that we could all get behind. No one wanted poor people to be held for minor crimes that they may or may not have convicted purely because they couldn't afford bail. I think that was the intention when this legislator did that, and I think to this day that is probably still the intention of this body. The problem is it has grown out of control, in my opinion. I represent, as I said, the city of Manchester, which has been particularly affected by this issue. It is actually the reason that I ran. Out of all of the reasons that I ran, this was it. When I went door to door as a candidate, I heard from the 4,500 doors that I knocked, I heard PR bail over and over and over again, which surprised me that my future constituents would be that plugged into a certain problem. It's a level of understanding that I bluntly didn't expect from the average voter. It's a more nuanced thing, after all. So when I got to Concord, I actually met with several stakeholders of this issue in my city before I was even sworn in. That was still in, I don't want to say it's infancy, but there was many people that were still in wait and see mode on the effects of PR bail on the community. And I think from people you'll hear with today, I think we've moved beyond the wait and see mode, and I think we're now at the point of we need some change. This bill will not fix all of the problems with PR bail. Some of the problems include letting out people who've been accused of violent crimes, you know, and you guys know this from the hearing on 92. I could sit here and I could list off the egregious offenses that have been given PR bail, but I don't think that would actually be productive towards the conversation. So the bill that I have presented is tailored towards people who are already out on bail. So it does not change the current bail system for people who are not currently out on bail. If you are not out on bail and you are arrested, this bill doesn't affect you at all. We are talking about people who are arrested while out on bail. So in my exploration or fact-finding mission with the stakeholders, one of the things that I found is that you have a group of people who are arrested again and again and again. And when I spoke with patrolmen from my city, and I'd ask them about PR bail, they'd say some not so nice things about it. But one of the things that they referred to it as is catch and release. And the problem is there's multiple instances of people being arrested in my city of Manchester who are released for an arrest before the police officer has actually finished the paperwork for arresting them. And I am one of the largest advocates for civil liberties and individual rights, but at a certain point, policy and philosophy don't always match. And I believe that if you are out on bail and you have been arrested, we need to take a closer look at you. And I understand the arguments. They haven't been convicted of the first crime. Maybe this is the second arrest and they're innocent of both. It's a fair point to make, and you're not wrong to raise that point. I won't refute that. But what I will say is we should exercise some state interest and take a closer look at you. So what this bill does is if you are arrested while out on bail, you cannot go in front of a bail commissioner. You will go in front of a judge. And I did that for a couple of reasons. When I met with people in the beginning, a lot of finger pointing was pointed at the bail commissioners. And I know that this body passed a bill that helped fund them and helped kind of bolster them up so that they can better do their job and better be funded for their job. But one of the reasons I wanted to have them go in front of a judge was because, let's say, and I do not believe this, but let's just say for the sake of the argument, the other side is right, that this individual is being targeted by the police. Once again, I don't hold this viewpoint, but let's just say you're right. Wouldn't we want that person to go in front of a judge and say, hey, I'm being targeted by the police. What can you do for me? A bail commissioner can do nothing for them, but a judge can do something. So we put them in front of the judge. The other thing it does is it puts the power back into the judge's hands. They cannot give PR bail for a second arrest. They can set that bail at a penny. Doesn't matter to me, but they're not going to get PR bail. So that is the intent of this bill. I did send a amendment to the chair yesterday morning because there's a 72-hour hold provision, and I was told that that's not legally allowed. So I did have a amendment to shift that 72-hour hold down to a 36-hour hold, which I was told is in line with the current constitutional requirements. And obviously, as with all bail, it doesn't apply to weekends and nights and that sort of thing, but that's standard operating procedure at this point. So with that, I'm happy to answer the questions to the best of my ability, but that is what my intent was, and I will say one other thing. This is a bipartisan bill. I actually went out of my way to find almost equal balance to it, and I believe some of my friends on the other side of the aisle are here to testify. But I am here today to advocate for my community. Manchester needs this. We need this. It doesn't undermine this committee's original intention of personal recognizance bail. But I am asking you to take a holistic view of this for people that are already out on bail. And when we arrest them again, we need to figure out what's going on.
Representative Conley.
Thank you, Mr. Chairman, and thank you for taking the question. So this bill reminds me of something we've heard before with some interesting differences, but one of the things that has come up in the discussion around efforts to reform this is the fact that people who could potentially be held for crimes that would not require them to be held at all under the current system, essentially very minor offenses, and I'm wondering if you'd address that point.
Yeah, so it's a fair point. I mean, if you can arrest somebody. That original argument is still there, right? They can be arrested for this crime to begin with, right? They can go to jail, and they can be held. So it's in the hands of the committee to address those minor crimes, if you will. One of the complaints about 92 was that it got into the business of listing crimes, which I know that gave this committee some consternation and I believe some representatives on the floor. So I tried to avoid that. It's admittedly by avoiding that, you cast a wider net or a broader stroke, but it is something that the committee should look at. But the underlying point is still there. You can still be arrested for that crime that you can't be held for to begin with. And once again, we're not talking about holding them indefinitely. We're talking about 36 hours. They have to go before a judge, and they just can't get PR bail. But I think that answers that question to your satisfaction.
Follow.
It does. I'm curious about the underlying thought behind this. And you addressed a very real problem in your city that is happening in mine on a smaller scale. Is this intended to provide some deterrence? Is that real the factor here, or is deterrence only part of it?
So deterrence is a factor in it. Speaking with the patrolmen specifically in my city, they've told me stories about when they've arrested people who are in the, as they say, once again, this is hearsay, but they say they're in the back of the squad car laughing at them because they know they're going to be back out on the streets before the paperwork's done. So I believe that if they know that they won't be back out on the street before the paperwork's done, that they might be a little more reluctant to do the things that they're being accused of doing. But once again, I think this is a balanced approach to, once again, the underlying purpose of PR bail, which is don't hold indigent people who are incapable of paying for bail for crimes, for minor crimes they might not have committed. I think this still lives in that spirit. But at a certain point, we as a society have to step up and say, what's going on here? And that's the purpose of this.
Go ahead. Got a question, Representative? Representative Bolden?
I don't have my name tag today. Thanks for taking my question. I was wondering, do you know of any law or policy which has historically tied the length of time that someone's held pre-trial to the length of time that is needed to complete paperwork?
I don't fully understand the question. I'm sorry.
May I clarify?
Yes, by all
I'm
means.
sorry. Let me try to find another way to word it. You've made many comments in your presentation tying the length of time that an administrative person needs to complete paperwork to the length of time that someone should be in jail pre-trial. And I was wondering if you could tell us about any law or policy which has historically connected those two things.
I think you're misunderstanding the point. So there's no minimum that they have to be held. It just says they have to go in front of a judge and they can't get PR bail, and you cannot hold them longer than 36 hours. If you take someone in and they're in front of a judge in 10 minutes and the judge says, here's your $1 bail and you're back out before the paperwork's completed, that's under 36 hours. That's perfectly legal. It's not constraining. It's not saying if you're arrested, we're going to hold you for 36 hours. It says we can hold you for up to 36 hours while we do our job, and that job is now including going in front of the judge. And the reason why you have to do that is obviously if you're shifting people away from a bail commissioner. Bail commissioners were established to basically relieve the pressures on judges, right? If you're shifting them into this system that is already more congested, you need more time. But if the system is running at 100% and they're in and out in 5 minutes with a $2 bail, that's a thing that can happen.
Follow up.
Sorry, I think that maybe my original question still isn't clear. You've indicated, or at least I've received the impression from your testimony, that you feel that someone who is being held, they haven't been tried, they're legally innocent, they've been arrested, it's time for them to be released so that they can go about their lives until trial. Mm-hmm. I've gotten the impression that you believe that they should be held until at least the length of time that the paperwork, that would be necessary to complete paperwork. Is that
was not
is
what
that what
said.
you intended to communicate?
No, my point is that we need to put them in front of the appropriate authority. In my opinion, that's the judge. I have a sneaking suspicion that will take longer than just filling out the paperwork and going in front of a bail commissioner, but I don't know that. I don't work in the court system, but I think a logical person would say that that's true.
Representative Panalakis.
Thank you, Mr. Chairman. This bill is just referring to second offense, right?
So that's while they're out on bail and arrested again. Right. So it's not first offense. It's underneath the current system. And as I said in my testimony, in my fact finding in Concord, I did not believe that the votes existed to go at the underlying problem. I've spoken about my issues with PR bail as a whole. It's not a policy that I would have supported, but I wasn't here, and at the end of the day, we're all one of 400, and our votes are all the same. And I thought that this was a measured approach that both sides could kind of look at and say, okay, if you are out on that second, if you're out on bail and we arrest you again, maybe we should get you in front of a judge.
Follow up. What you're saying is if you haven't learned your lesson the first time, we're going to take care of you the second time.
Well, we're gonna take a better look at you. I mean, remember, they're not adjudicated on the first crime.
That's right.
And I said in the beginning, it's a fair point to make. You have not been found guilty of the first arrest. But I do think the state has a compelling interest to take a better look at you. Going back to it, for all I know, this gets them through the system faster. But one of the complaints that I heard from stakeholders was that the bail commissioners don't do their job. When you speak with the bail commissioners, they say they're operating under instructions from the judges. In my opinion, the judges can be held accountable. They have internal review boards. I don't believe in, they are a co-equal branch of government to us, and they do have accountability measures within their own body, and I think that they need to be held to that versus saying, oh, well, that's just what the bail commissioner did.
Representative True.
Thank you, Mr. Chair, and thank you for taking my question. I understand the problems people feel we have with PR bail. My concern is a person losing their freedom because we feel that they've got problems with PR bail. You had mentioned that about people being released again and again and again. Don't you feel if somebody's being released again and again and again, that probably has nothing to do with PR bail, but that's a problem with the courts?
No, I believe PR bail is a part of that. That's my personal opinion. But once again, Representative and Mr. Chairman, I don't believe that there's the will of the body of Concord, unfortunately, to address what I think is the underlying problem. So I'm trying to find a middle ground forward for these most likely repeat offenders. Now, once again, they have not been adjudicated guilty. I acknowledge that in my opening testimony. And I'm not going to sit up here. For all I know, when they've been arrested 6 times, they're innocent 6 times. That's the standard that innocent until proven guilty we hold to. But we do know that there are compelling state interests, and I'm trying to assert that interest and fight for the community who is affected by the repeated release of sometimes violent criminals, but many times they're not. Many times it's, burglary or, vandalism. But it's if you're already out on bail, in my opinion, you should probably be on good behavior. But sometimes you're not. And to the representative's point from Dover, this will act as a somewhat deterrent.
Representative Muse.
Thank you for taking my question. Would you agree that if the second crime doesn't involve a jail sentence, there should be an exception for that?
So, no, because we're still arresting them. They're still going to booking. They're still going through that. They're just going through a slightly different process. So if you can be arrested, let's say it's the first arrest, right? For whatever this crime is that has no possibility of jail time, right? Mm-hmm. They can still be arrested and still go through it. They can still go through, get PR bail. They're still being taken to jail. Second arrest, we're still taking them to jail. We're just putting them through a slightly different process, which I believe is is set to a higher standard.
Thank you.
Representative Newman.
I'd just like some clarification on the number of hours that we've talked about detainment. I thought I heard 36 hours, and I look at line 7 in the bill as I got it off the table there. That says they shall be detained for a period of not more than 72 hours. So
correct. So I sent
some kind of difficulty with that.
I will give you the amendment number that I sent Chairman Abbas. It is amendment 2022-0589H. If I had not had left my computer in Manchester today, I would have had printed copies for you. But it replaces all references to 72 hours to 36 hours.
Thank you.
And the chairman has that amendment. And I would highly, if the committee sees fit to pass this bill, you must pass that amendment. Otherwise, it will not withstand constitutional muster.
And to be clear, by chairman, they mean the one who's not here, not me.
The one, yes, the other chairman. The other
Seeing no further questions, thank you for your testimony.
Thank you so much.
The committee now calls Buzz Scher.
For the record only, since I know you've heard this already, my name is Buzz Scher. I'm a police commissioner in Portsmouth, UNH law professor. The opinions I express today are my own and not those of either UNH Law, UNH, or the Portsmouth Police Commission. First, I apologize for what I'm about to say in some ways, but it bothered me deeply over the last 4 years. I've been involved since the beginning in bail reform. I authored the bail reform bill that was presented by Senator Feltus 3 or 4 years ago. So I'm very familiar with this area. It is offensive for anyone to talk about the problem here as catch and release. The people that we're talking about are human beings, many of whom have mental illness problems, many of whom have substance abuse problems, many of whom are homeless. They are not fish. And the term catch and release treats them like that. So I would ask everybody who testifies and on this committee to please do not use the term catch and release. It is immensely disrespectful. So let me clear up a number of myths that related to bail reform. The original bail reform bill was not a PR bail, or not a personal recognizance bill. It was a bill that dealt with two problems. One, the fact that judges were holding people effectively without bail, poor people effectively without bail, by setting bail at $100 or $50 or $200, with no attention whatsoever to whether they could meet that amount. And the original bill got rid of that practice and basically said, if you can prove somebody is dangerous, or if you can prove they are a risk of fleeing, you can hold them without bail. And it expanded the number of crimes for which, Class A misdemeanors and felonies, for which you could hold people without bail. And we got rid of the artifice, the false idea of using setting bail as a way to hold people. And we got rid of people being held on minor crimes on $100 bail because they were poor. That's what the bill was. It wasn't a PR bail bill. So I disagree with the ongoing reference to the original bail reform as PR bail bill. It resulted in, as one superintendent said at the first of the two bail commissions that followed, it resulted not only in poor dangerous people being held, it also resulted in rich dangerous people being held, which was a change from the pre-Bail Reform Act. I've got my numbers now, and I've lost my numbers. There we go. There's this misunderstanding, there's this myth that we're doing nothing under the current statute to hold people to pay attention to people who have been arrested on one charge and then while on PR bail are arrested on another charge. The current bail reform statute consistently from its first iteration 3 or 4 years ago through the practices recommended by the first bail commission adopted by this legislature, through the practices recommended by the second bail commission and adopted by the legislature, both bail commissions which had a majority of law enforcement on the commissions, including individuals from the Manchester Police Department, There are provisions in the current bail bill to deal differently with people who are repeat arrestees. It's not like this is, oh, here's a great new idea. Let's deal with people who are repeat arrestees. There are provisions in there, measured provisions dealt with through consultation with all the stakeholders. All the stakeholders includes not just members of the Manchester Police Department, not just members of prosecutorial authorities, but it includes defense lawyers, it includes civil libertarians, it includes bail commissioners, it includes legislators. That's what the bail commissions were about. This is yet another bill coming before this body that is a one stakeholder bill. This is a bill from that it serves the interests of the Manchester Police Department. There are different interests at other police departments. It's not the case that every police department would be in support of this bill, regardless of what the police chiefs would say. Number 4, it's really important that the people we're talking about here are the mentally ill, those with substance abuse issues, and homeless people. The huge majority of people who are arrested for a violent felony the first time, and if in fact they are released, which isn't normally the case, if in fact they are not held without bail and arrested for another violent felony, they're going to be held. Now, I'm sure you'll hear a parade of anecdotes that says differently, but they're just anecdotes, and some of those anecdotes predate the changes that the first and second bail commissions made. So what we're talking about is people charged with minor offenses who are, to use a colloquial term, a pain in the neck. You know, they're not committing serious crimes. They're on the fringes of the criminal justice system. They're likely homeless. They're either homeless, or they have substance abuse issues, or they have mental health issues. This is yet another effort to solve the societal problems of substance abuse, mental illness, and homelessness using the criminal justice system, and it doesn't work. Putting somebody in jail because they're a repeat misdemeanor, low-level misdemeanor offender, and they're mentally ill is a bad thing. It's not, they don't get the kind of treatment they need in jail. Jail is not a healthy thing for someone who's mentally ill or homeless or has a substance abuse problem. So this bill is much more of deals, the changes this make don't improve whether violent second arrestees are held. It makes it much more likely that somebody charged with a Class B misdemeanor, you know, a shoplifting of a mother who keeps shoplifting to get diapers for her kids, or that kind of crime. That's what this is targeted at. Practically speaking, there's no deterrence in arresting someone, not having them go in front of a bail commissioner, them having them go in front of a judge, and being released 36 to 96 hours later, depending on whether they were arrested on a Friday or Saturday. The people who are committing these crimes, get out of your minds, if it's there, this idea that these are these people who are horrible criminals. You know, the huge majority of people committing minor Class A misdemeanors and Class B misdemeanors are people who are really struggling in their lives. And this bill wants to sweep them off the street and put them in jail pre-trial rather than use other mechanisms for dealing with it. And it's just, I understand some of the frustration, but it's the wrong way to deal with it. I know at least one other person will talk about the data that's out there. But briefly, From the time bail reform was not in effect to a year to two after it went into effect, the crime rate in Manchester went down. So let's be careful in buying into these stories that things are out of control in Manchester. They are not out of control in Manchester. The Manchester Police Department does an excellent job, and we do not need this change.
Representative Newman.
Thank you, Mr. Chair. Thank you for taking my question. We don't. I don't have a copy of the amendment. I think it may be coming, but I've heard testimony. I think I heard testimony that said that it would keep people from being able to see a bail commissioner.
Yep.
And just for my benefit, could you kind of talk about what kind of impact that has on the people that you have not having ability to have access to a bail commissioner?
It keeps them in. Just to set the scene, when somebody is arrested, they go in front of a bail commissioner, and the bail commissioner listens to what the police officer has to say. There's no defense lawyer there. They go in front of they listen to what the police officer has to say, and if the individual has anything to say, they listen to them. Then they set bail. Then, if they're held, then an arraignment is scheduled. If they're held by the bail the police commissioner sets, then they see a judge, usually within a day or so. This bill takes that bail commissioner step out of the mix, so they get no initial screening of whether they deserve bail or not. They wait until they get to see a judge, and that that creates a large number of extra hearings for the court system and significantly increased costs, which I believe another witness will talk about.
Thank you.
Representative Burt.
Thank you, Mr. Chairman, and thank you for your testimony. It just showed up, the amendment. Have you seen it?
I have not.
What's that?
I have not.
Oh, okay. I just wanted to know what your opinion was.
Yeah,
so
my understanding is that instead of 72 hours, it's 36 hours. Is that what the amendment says?
I just got it. Follow up? Okay.
The problem is if you're arrested on Friday afternoon after there's not a judge available, you're held 24 hours to Saturday, 48 hours till Sunday, and then there's 36 more hours, another day and a half, so you might not get a hearing until sometime on Tuesday, even if you were arrested on Friday. So, I think that's still an issue. It puts a tremendous, and then it also puts, because of the increase in the number of hearings that are going to be required, it puts the courts, certainly the Monday and Tuesday docket of circuit courts and superior courts, under a lot of stress to handle everybody held over the weekend within the 36 hours period starting on Monday morning for a hearing. This is one of the problems that SB 92 that made it to the House floor had. It increased the cost to courts by millions of dollars, and this bill has that same problem.
Thank you.
Representative Panalakis.
Thank you, Mr. Chair. Professor, with all the problems we've had with the bail bill, from the seacoast to the North Country, would this not clarify the law a little bit for them, this one bill?
This won't improve the problems that are out there. I think we oversize the degree to which we hear that there are problems based on the Bail Reform Act. Crime rates around the state, not only in Manchester, are going down. I think what needs to happen is we need to gather all the stakeholders together and not have yet another bill from the police chiefs or from one police department. And we need to gather all the stakeholders together like we've done before to solve this problem. It's a complicated problem. It intersects with social services. It intersects with any number of issues. And to deal with this on a one stakeholder basis, I think is the wrong way to do it. I freely acknowledge the criminal justice system has got significant issues to deal with, and I would love to participate in any comprehensive effort, multi-stakeholder effort to deal with them. But this doesn't do that. It's trying to fix something that actually doesn't need fixing.
Second question.
Follow up.
This does not just pertain to Manchester.
I agree.
I have heard these complaints from Seabrook clear up in the North Country. And we've had 2 commissions meeting, and they have not resolved this problem. So wouldn't this law just classify it?
I don't, respectfully, Representative Panalakis, I don't think it will. It's using a sledgehammer to try and kill something that's closer in size to a mosquito than something bigger than that. And I agree there's a problem, but one stakeholder solutions are not the way to try and solve the problem, because the criminal justice system is complicated.
Representative Muse.
Thank you for taking my question. One of the things that we hear about anecdotally, and this is in Portsmouth and Manchester, and I think a lot of other communities, is the frustration that police have with dealing with folks who are shoplifters. And a lot of times there are gangs that come in from out of state and cars and things like that. There seem to be some real logistical issues around being able to hold people for crimes like that. So I guess what I would ask you is there a middle ground that's not in this bill that maybe we should be looking at?
Yeah, there may be. I recognize that problem. Practically speaking, if it's a quote-unquote shoplifting gang, if they're released once on PR bail, they're not coming back to the state. So I think this bill doesn't deal with that. Or if it does, it's already dealt with in the bill as it exists. It has repeat arrestees provisions in it. So, I think there may be other ways of making a dent in that problem. I don't think they're easy answers, but again, I think we need a multi-stakeholder problem-solving group to do that rather than one stakeholder problem solving.
Representative Testament.
Thank you, Mr. Chairman. Thank you for taking my question. Isn't there a purpose of the police department to keep the citizens safe, sane, and feeling comfortable? I hate to say, just feeling comfortable. And the kinds of crimes that we're talking about, or you talk about, the shoplifting that really aren't. And if you get a lot of people shoplifting, I don't feel safe going into a shop. I don't, I'm due a certain amount of respect and a certain amount of ability to go about my business. Doesn't this, this would stop some of the second or third time this person did that. I mean, I know you're enamored with this commission you were part of, and they did a wonderful job, but it isn't working.
I recognize your concern for safety and being able to go into stores without fear of getting in the way of shoplifters. But shoplifting hasn't, because of bail reform, shoplifting hasn't skyrocketed anywhere in New Hampshire because of bail reform. This has been an enduring problem that we continue to struggle with. And I want solutions to this. but I want good solutions, not just facial solutions that seem to sound good. I have to say, you look around the country and you look at those jurisdictions where there's been bail reform, and every single police department, regardless of the fact, and almost New York City is a good example, that bail reform went into effect in New York City. The crime rate in New York City has gone down. 98% of the people who were released under the Bail Reform Act that involved New York City and New York State, 98% of them did not commit another crime. So what we're talking about is issues where we need to balance civil liberties. We need to balance the desire of the police to deal with citizens' concerns with public safety. There's a whole bunch of complicated issues. I didn't get virtually anything I was interested in getting out of the Second Bail Commission. So I'm enamored of the process. I was not necessarily enamored of the result, but it's a better way to do it. We always screw up when we let one stakeholder decide the way we're going to do it.
There being no further questions, thank you for your testimony.
Thank you.
The committee now calls the Honorable Victoria Sullivan.
Thank you, Mr. Chairman, members of the committee. My name is Victoria Sullivan, and I reside in Manchester, New Hampshire, and I am afraid that my testimony is going to further anger the gentleman who preceded me. Just 6 days after being released on PR bail, Amari Diol was arrested for allegedly raping a woman for 2 hours at the Valley Street Cemetery. Diol has a criminal record dating back to 2011. I do not believe that being raped in a cemetery for 2 hours is anecdotal. Enrique Castro hit a child in the back of the head and threatened to hit another with a hammer. Despite having numerous interactions with the Manchester Police Department, Castro was released on PR bail. Most recently, just this week, Tanisha Ozuno allegedly went to a residence on Somerville Street to talk about the involvement of her significant other with another woman. Evidence presented indicates that the victim was attacked with some form of weapon while she was holding a young child. Although the child was not injured, the victim required emergency treatment to close a significant wound. Azuma was released on personal recognizance bail with several stipulations, including having a curfew and having her firearms removed from her address. I ask you, if this person was not viewed as a threat, why were there so many stipulations surrounding her release? In 2018, then State Senator Dan Feltus was the prime sponsor of Senate Bill 556, which changed the bail laws to allow for any person claiming they were indigent to be released on their own personal recognizance. This created a system whereby people were released with no known address, no financial reason to appear in court, no responsibility for their alleged actions. This in turn did in fact create a catch and release program, which has resulted in repeat offenders going on to commit violent acts. Let me be clear. No person should be held simply because they are too impoverished to pay their bail. All people are innocent until proven guilty. However, there is a clear pattern of systemic abuse of this bail reform, which is endangering our citizenry. This has been a frustration for police departments around the state who work to get dangerous people off the streets only to see them released within hours. I had the honor of serving with many of you. My voting record supports the fact that I am a liberty-minded person. I believe in bail reform, but I also believe in consequences for actions. Come spend some time in Manchester and you can see the direct impact to our community. When people are let out on PR bail, they often do not appear back in court because they have nothing on the line. They end up hiding in our growing encampments and go on to commit additional crimes, increasing the crime in our streets. My liberty is being stripped as a consequence of this bill. My neighbors' liberties are being stripped as a consequence of this bill, and it is significantly impacting our downtown businesses. Our law enforcement officers are using resources on repeat offenders that we need elsewhere. Now, there was a comment saying that this impacts Manchester and maybe some of the other cities. Well, first of all, Manchester is the largest city in the state, so it's going to be impacted more at a greater rate. However, We have a court in our city. When people show up for their court date, they come to Manchester. When they're released on PR bail, they end up in our streets. So it does have a significant impact on our city that you won't see in towns that don't have a courtroom. So I ask you to please support HB 1476 as amended to give our city some relief. We cannot carry the burden of the entire state. We can't. And our officers are working out there every day, fighting the opioid epidemic, fighting the crimes in the street, trying to help the homeless. And we are not doing it without a heart, as has been sort of referred to here. We don't say catch and release because we are heartless people. We have resources for people and we try to help them. But there is a line between helping people and hurting our citizenry, and we have crossed that line and we need to pull it back. So I thank you.
The witness, thank you for your testimony.
The committee now calls Ross Connolly.
Thank you, Mr. Chairman and members of the committee. For the record, my name is Ross Connolly. I'm the Deputy State Director for Americans for Prosperity here in New Hampshire. And this will be a bill that the two Rosses diverge on, unfortunately. We are in strong opposition to HB 1476 as it is currently written. The way we view this is really, there's been multiple iterations now that this committee and others have gone through with trying to address issues when it comes to bail reform in New Hampshire. We view this bill to be the most threatening to the due process rights of Granite Staters. It puts every defendant in one-size-fits-all boxes. It has no discretion to the type of crime, the seriousness of the crime, and we view that as a mistake. I will point out that we did provide the sponsors of this bill with suggested language that we would be totally comfortable with. It addressed violent crime, reoffenses, and especially the issue in Manchester of continually some folks continually being charged at the same location with trespassing. We did provide language for that, but unfortunately it was not adopted by the sponsors. We would be happy to send that to the committee if members are interested. Really, we understand the concerns from the proponents of this legislation and others like it. The intent of the 2018 law was never to result in violent criminals being released. In fact, in the law, it plainly states that if an individual is suspected to be a danger to themselves or the community, they shall be held. Our language, our proposed language, was to really clarify that in statute and show that these, XYZ violent crimes should not be considered for release. Really, what we worry about is misdemeanors, areas of criminal code that don't actually aren't actually a direct threat to the public, and again, putting everybody in a one-size-fits-all box, we just believe is not the correct way to address some of these very targeted issues. There are a lot of anecdotes. They should not be happening. To the previous speaker's point, those anecdotes should not be happening under current statute. We're happy to work with the committee to try and address those anecdotes, but they are just that. They are outliers in what's happening in practice, to Attorney Scher's point. So we urge the committee to, as this bill stands, to move this bill in expedient to legislate, but again, happy to work with the committee on any improvements that you may be looking to do. And I'd be happy to take any questions.
I'm going to recognize myself for the first question. You said you found that this was the most dangerous of a slate of bills that were addressing bail reform, and I'm curious. It's kind of ironic that this bill actually mandates someone be able to get in front of a judge to plead their case. which is the nature of habeas corpus. It's the nature of our law system to put them in front of a judge who has the power to make decisions versus a bail commissioner who's got very limited authority. So what makes someone being able to get in front of a judge so dangerous?
Thank you for the question, Mr. Chairman. It's because they shall be held. So they will be held in detention until they see that judge. And we view that as a threat to due process rights for granted staters. And we understand, again, the going to see a judge is a good thing. One, we have a backlog already in our judicial system. A lot of these crimes are nonviolent crimes. Addressing violent crime is perfectly appropriate in our mind. We should not be releasing people that are a threat to the community. However, prison, jail are not solutions to drug crime, to mental illness, to the previous speaker's points. These are not solutions. If anything, that sometimes they exacerbate criminal activity. There's the famous George Jung quote that he went to, before he went to prison, he had a bachelor's in marijuana, and he graduated with a doctorate in cocaine. It's not really the solution for every single crime, and treating every single second offense in this one-size-fits-all box is not appropriate in our mind.
Representative Lynn.
Yes, I wonder if I could ask you, in your view, if somebody commits a shoplifting and they get arrested and they get released on bail, and the next day they commit another shoplifting, maybe at the same place, maybe at another business, and they get arrested and they get released on bail, and they do it a third time and a fourth time, and at what point, if any, in your view, do they become a danger to the public?
Thank you for the question, Representative. I would agree that those people constant repeat offenders, in this case shoplifting. I know the sponsor had a concern about trespassing. That's what we provided language for. But I don't know of specific examples. I've seen in other states this happening, the sort of crowdfunding of shoplifting that's happening. That would not be appropriate. We would not want to see those people continually released. So again, we would be happy to provide language that does still protect due process, but in specific cases of concern, we're willing to work with the committee to sort of address those, especially when it comes to shoplifting, trespassing. Repeat offenses should not be constantly happening.
Follow up.
Can I ask you a follow-up? Just, you talk about due process. I mean, I assume you're talking about sort of your view of what due process should be, because I haven't heard anybody, including Professor Scherer, say that being brought before a judge within 24 hours to have a hearing somehow violates due process, and I'm not aware of anything that would say that does violate due process.
Thank you for the question, Representative. Our big concern is this is going backwards towards criminalizing people for being poor. And if you just can't afford bail, we don't think that should be a reason to hold somebody. When it comes to the repeat offenses, again, we're willing to compromise on those issues. When it comes to due process, we believe that you are innocent until proven guilty, and that should be respected. Unless in some of these anecdotal circumstances of crimes happening on a repeated basis, that people shouldn't be held just because they can't afford it.
Thank you for your testimony.
Thank you very much.
The committee now calls Richard Head, Judicial Branch.
Good afternoon, Mr. Chair, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. As you may not be surprised, I'm here to talk about the potential impact this bill would have on the circuit courts, not so much to address the policy behind this bill. I've had multiple conversations with this committee with regard to a number of bills. When Senate Bill 92 was before you, we talked about the potential increase in cases in the circuit court of around 3,000 cases. That bill, by the way, does exist again this session as Senate Bill 294, and that issue is still going to probably be brought before you again. What I don't know, and I can't tell you, is how many cases this covers, because we sort of know how many of the misdemeanors that would be at issue under the Senate Bill 92 scenario. What we don't track is how many times somebody is rearrested, because we don't really know that. We don't have that data. It doesn't come to us. So I can't tell you, this will result in X number of additional hearings before a circuit court judge. But what I do know is the scope of the bill, which is all felonies, all misdemeanors. Class A misdemeanors, Class B misdemeanors, all felonies, all misdemeanors. And just judging from the testimony, it could potentially be a number of cases, maybe even a significant number of cases. And when we're talking in circuit court, what I'm talking about is 3 divisions, because virtually all judges in circuit court hear from all the divisions. So they're hearing probate division cases, they're hearing district division cases, and family division cases. So in any particular day, their docket can be filled with these types of cases. And then on top of that, with really no notice, are bail hearings, because they're coming in probably being either transported from a county jail, or there's a video arraignment that's occurring, depending on whether or not there's video time available. There's an actual hearing that has to occur in front of a judge, because these would otherwise have been handled in front of a bail commissioner. So we now have another hearing event that is occurring in front of a circuit court judge who already has a complete docket. All I'm suggesting is that these bills have a significant impact on the circuit court judges, and probably even more especially on the staff in these circuit courts, because they're involved in the paperwork, the scheduling, and keeping everything moving. And the burden is incredible these days. As I said, relative to the last hearing, there are approximately, pending at the end of 2021, just under 199,691 cases pending. There are 46 full-time judges in circuit court. There's 2 senior judges and 1 marital master. It is a huge volume of cases. So every time there is a change in the system that puts more cases in front of those judges, you're pushing into a system that is full. And the more that happens, the greater the chance at some point we're just going to hit that point of one too many. And so all I suggest is, 1, this will have a fiscal impact. It will need some additional resources, especially in the 4 busiest circuit courts: Manchester, Concord, Nashua, and Keene. Those are the ones that are probably going to see the greatest impact from this type of bill. Currently, it has a 60-day effective date. What I would suggest, 1 is, and I've mentioned this statute before, RSA 14:9-A addresses effective dates and talks about any bill or any law that affects judicial process and procedure, establishes or eliminates criminal prohibitions, civil causes of remedies, or limitations of actions shall take effect January 1 of the following year. At a minimum, we would ask that the January 1 effective date be implemented. But really what we would be asking is that give this bill an opportunity to be heard as part of the budget process also, at least not the bill, but the fiscal impact, because we're not in a budget year. So we are going to see impacts occurring if this becomes effective sooner within the circuit courts, which are already overwhelmed. And you're just going to see, that those cases that can get pushed. Civil cases will get pushed, other things get pushed, and there's delays in the system. And our goal is to try to keep things moving, to keep things expedited. And these types of bills require resources. So one other ask is, at a minimum, a January 1 effective date, but really, if we can push it to after the budget is passed, as an effective date, even if the bill passes. That way we can address those resources needs, as well as the sort of cumulative resource issues that are seen in the bills that are in front of you this session. Not only Senator Bradley's SB 294, but the bill that was heard in Judiciary, which would rewind felonies first, that'll be heard on the floor of the House. That's about roughly another 6,000 cases that would be coming into the circuit courts that are not currently in the circuit courts. You know, this cumulative effect of these bills is having a significant, as the likelihood of a significant negative impact on the circuit courts that will require resources. And I think to be able to do some of that in the budget process is really the most reasonable way of trying to approach it. Thank you very much, and I would be happy to answer any questions.
I have a question. Prior to the bail reform bill of 2016, has there been a significant cut in judicial staff so that adding this, in other words, this isn't really, unless there's been a significant cut in judicial staff, this isn't adding anything more than was already on the plate in 2016, is that correct?
Truthfully, I didn't practice criminal law and wasn't in the court system back then, so I actually don't know what the balance was in terms of post, pre, sort of that sort of, I don't know what the difference was, truthfully, and so I couldn't answer that. I think the other aspect of it, though, is other burdens that have been added since then also, because every legislative cycle, there tends to be some additional changes that are implemented.
Thank you. Representative Bourdonnais has a question.
Thank you, Chair. Thank you for taking my question. If we were to have no more arrests in the state, no more new cases put before us, how long could you give me an estimate how much time it would take for the court systems to clear?
A little over a year.
Thank you.
So we roughly get 175,000 filings a year. It really depends on the case too. So some just by their nature take longer, some are very quick. So if we get in 175,000, we're up to around 200,000 now. So 175 new ones, we're pending around 200. There's about a 25,000 increase gap between those. Some of that is COVID related, but really the circuit court has worked down a lot of its COVID backlogs. So, you know, more than a year, how much more than a year, I don't know.
Thank you.
And actually, let me take one step back. And that's just criminal docket. You know, with that 175, the 200, that's all of the circuit, all of the districts. So that's district division, probate, and family division. So if we're just cutting out the criminal, which is the highest number within circuit court, you know, those tend to get cleared out and could get cleared out probably within a year. Essentially, no new ones were coming in.
Representative Muse.
Thank you for taking my question. On bills like this that are framed as fixing flaws in the judicial system, one of the things that we hear a lot is about the importance of fixing those flaws regardless of the impact on the judicial system. What are some of the unintended consequences that happen, in your opinion, when we take that kind of an approach, and in particular, if we were to take that approach with this bill?
So thank you for the question. The impact any time of adding, especially in the criminal context, which has certain constitutional overlays and statutory overlays in terms of timing and processing, is it simply means other types of cases get pushed later. So civil cases, small claim cases that don't have the same type of statutory or constitutional requirements get filtered in where they can, but they don't have the same deadline. They're not driven by the same deadline, so they just get pushed to later. So it just may be a significant period of time before a small claims case gets reached. It also is, increases, the stress on staff is tremendous in terms of, they're managing, 200,000 cases, scheduling, getting them in the docket, putting them in front of the judge, getting notices out. Mistakes happen too, and you just increase the rate of error. To the extent those happen, they do just a remarkable job. But I think the primary one is you just move a certain class and certain types of cases to the back of the line, so that it takes a very long time to get them reached.
Thank you for your testimony.
Thank you.
The committee now calls Stephen Andres, Merrimack County Attorney's Office.
Good afternoon. My name is Stephen Andres. I'm an attorney with the Merrimack County Attorney's Office. I've been a prosecutor for a little over 20 years now. I've appeared in circuit court pretty much every day from November 2003 to the start of the pandemic in March of, I don't know if that was 2019 or 2020 now, but listening to Representative Barry's comments about this bill, the takeaway to me is that he said when a person is rearrested who's out on bail, they shouldn't be brought before a bail commissioner, they should be brought before a judge. And I absolutely agree with that, and I think that's a fantastic idea. We've talked a little bit about shoplifting, and when a person's arrested for shoplifting, they're brought back to the police station, they go through booking, a bail commissioner is called, the bail commissioner would come meet with that person and make a determination of whether or not that person is a risk of flight or danger to the community. If they're not a risk of flight or a danger to the community, they'd be released on personal recognizance bail. And in my opinion, that's appropriate. But personal recognizance bail comes with some conditions. And one of those conditions is that you remain of good behavior, meaning that while you're released on personal recognizance bail, you don't commit additional crimes. If you're released on personal recognizance bail and you do commit an additional crime, you've broken your promise to the court to remain of good behavior. So it absolutely makes sense to me that instead of having a bail commissioner come and perhaps set PR bail a second time, that you should have to go in front of a judge. And the judge may set PR bail, the judge may set cash bail, the judge may set preventative detention, depending on the facts of the case. But it certainly makes sense to go back in front of a judge. With reference to these hearings, we do bail hearings in circuit court every day. It's not uncommon to have hearings within 24 hours or 36 hours under 594-20A. So this isn't something that we're not used to doing. If we don't do the hearing within 24 to 36 hours and the person's released on PR bail by the bail commissioner, we're still doing an arraignment, but it may be 30 days down the road. One of the, and I'm sure if you spoke to any prosecutor, any law enforcement officer, all of us could tell you stories for hours about people who have been arrested, released on PR bail, arrested again, released on PR bail, arrested again, released on PR bail, and it continues to happen over and over and over again. When we talk about the number of filings in court, I can't help think that maybe if a person is arrested and released on PR bail and arrested a second time and then brought before the judge, maybe there won't be a third time they're arrested when they're on PR bail. Maybe there won't be a fourth time they're arrested when they're on PR bail. Maybe those filings would actually go down. The difficulty that I have with House Bill 1476 is I actually really like this section of 597(2)(8), the way it currently is written. And I can certainly answer questions about why I like that or why I think this section exists. I think if the issue is that the bail commissioners shouldn't be setting bail on people who are released already on bail, bail commissioners have statutory authority under 597(18), and I would suggest that perhaps amending the bail commissioner's statutory authority under 597(18) to indicate that bail commissioners are unable to set bail on a person who's already out on bail. And that's not an unprecedented thing in New Hampshire law. If you violate a protective order under 173, the bail commissioner has no authority to set bail. You have to go in front of the judge. We've been doing that for years. We could certainly mirror that with people that are currently released on bail so that they do, in fact, go in front of the court, which, again, makes sense to me that the judge would be the person to decide what the subsequent bail is. I'd be happy to answer any questions. Yes. Oh, I'm sorry.
Representative Bordnay.
Thank you, Chair. Thank you for answering my question. I'm not sure this bill is necessary. I'm looking at RSA 597:7-A, which does talk about detention and sanctions for default of breach of conditions. So if a person is does break their terms of condition, they are brought before a judge. Is that not true?
That is not necessarily true. Under 597(7)A, the detention for sanctions for bail, we can file an additional charge of breach of bail if you violate your bail conditions. So the way that potentially works is, going back to the shoplifting example, a person shoplifts, they're released on PR bail. They shoplift a second time, they're again released on PR bail. The second time, I can not only file a shoplifting charge, but I can file an additional breach of bail charge. But they would still potentially be released on PR bail by a bail commissioner. That person could go out a third time, and I've certainly had this experience, where after being charged with breach of bail, they violate their bail conditions again by committing a new crime, and again are released by a bail commissioner on personal recognizance bail. Under 597(7)A, I can file a motion asking that their bail be revoked. My experience with that, though, is that those motions get scheduled in the regular course in court. So I may file a motion to revoke someone's bail, but I may not get a hearing on that for 30 to 45 days after it's filed. I've had the experience that during that 30 to 45 days, while my motion to revoke bail is pending, the person is again arrested, and I was shocked that they were released on personal recognizance bail, despite the fact that there was a motion to revoke their bail pending.
Follow up.
So I'm looking at paragraph 5 in this RSA, or paragraph 1, and it says, the accused will be brought before a justice for a bail revocation hearing within 48 hours. Isn't that a judge, or is that another bail commissioner?
You're looking at 597(7)A, paragraph 1?
Yes.
You certainly could bring the person before a justice. However, there is the provisions of the statute and now the rules of criminal procedure which indicate that a person's entitled to a bail commissioner. So I believe most of the police, when they're arresting people for crimes that they've committed while out on bail, still see bail commissioners.
Go ahead.
Additional follow-up. Thank you. So maybe rather than writing a new section of law, we should look at paragraph 1 and make it required that it is a judge in a court that has the hearing.
I certainly think there's other statutes you could amend. As I said earlier, in terms of amending the bail commissioner statute, you could certainly amend 597(7)A to strengthen those clauses. But I do think there are certainly other statutes you could amend to accomplish the goal that if a person is arrested while out on bail, they see a judge instead of a bail commissioner.
Thank you.
Representative Conley.
Thank you, Mr. Chairman. Thank you for taking the question. We've heard testimony that these individuals who tend to fall into the category of offense that's really at issue here tend to be committing victimless crimes, or that or that they're extremely minor. And I'm wondering, in your experience, do these crimes have victims? And I'm also curious if you could address what the victim might share with you when they learn that this offender is out on bail.
With reference to whether these crimes have victims, I think that you could have an academic debate on that. If I'm the manager of McDonald's and I have a homeless person, for example, who comes into my restaurant and sits down at a booth, doesn't purchase anything, and falls asleep, and I politely ask that person to leave and they refuse to leave, and I call the police come, ask the person politely to leave, they refuse to leave, they're arrested for trespass. They're released on personal recognizance bail and they come back to my store. I think I'm the victim as the owner of that McDonald's or as the franchisee, that I can't control who's coming in and out of my premises. So I certainly think some of these repeat crimes like trespassing or shoplifting absolutely have tangible victims. We've certainly also had the experience where I can think of a gentleman who is out on personal recognizance bail, and I would agree with Attorney Scher that this person probably was suffering from mental health issues. He felt that somebody had walked past him and knocked over his coffee, which my understanding is that his coffee fell over while this person was walking past him, and he proceeded to violently attack that person and send them to the hospital. I don't know if I personally care if the person who's beating me up has mental health issues or if they're just a jerk. If I'm being beat up by someone who's out on bail, that's not right. And we certainly have experienced input from members of the public with frustration. Why is this person out to begin with when we have repeat offenses from people on bail? Thank you.
Representative Newman.
Thank you, Chair. Thank you for taking my question. And it seems to me that this whole discussion has to do with this one word, shall or may. One gives discretion and one eliminates discretion. And it seems like the testimony that I'm hearing is that bail commissioners just always give out personal recognizance bail, and that when they go before a judge, that won't happen. I'm just confused why, if both of them are, I guess they're both judicial officers, why we're addressing this problem by taking away discretion, I think, for both judges and bail commissioners. If you get arrested on a Friday night, you could be there for up to 72 hours, even with the exclusions in the 36. That's the concern I have.
I agree that both judges and bail commissioners have discretion. Not to give anecdotal evidence, because I don't know that that's necessarily appropriate, but it's been my experience that people are more likely to get personal recognizance bail from a bail commissioner than a judge. But again, that's just my personal opinion. I don't think that this statute would take discretion away from judges. And I think that we all want judges to have discretion to set bail as appropriate. The shall in this amendment means that the person shall be detained to be brought before a judge. So it would take the discretion away from the bail commissioners, not necessarily the judges.
Thank you.
No further questions. Thank you for your testimony.
Thank you.
The committee now calls Paul Halverson, Merrimack County Attorney.
Good afternoon. I'm Paul Halverson, Merrimack County Attorney. Attorney Endress covered many of the items that I was going to address, so I'll defer to his testimony. I do have some additional comments, though. One of the reasons bail exists in its current format is to address the issue of public safety. When you're looking at individuals that are released on bail and reoffending while out on bail, albeit 1, 2, 3, 4, 7 times, the issue becomes one of public safety. As Attorney Enders pointed out, the proper venue, in my opinion too, is that when you violate a promise to the court, the person to address that should be the judge of that court. The amendment that Attorney Enders mentioned, moving the change under 597.18 to limit the powers of a bail commissioner, frankly, I believe is a much easier methodology to attain what I believe is the goal of the proponent of the bill, and that is to have a serious look by a judicial officer, namely a judge, on someone who's already been released on some sort of bail, yet continues to violate the terms of that bail and the promise to the court. And I do think that's appropriate. The harsh reality is that there is a small group of people which commit a larger number of crimes. Certainly, I think the default setting, I think we can all agree, the majority of people comply with the orders of the court out on bail. The vast majority do. But you have that small population that becomes a risk to society, and I think you can argue through that risk to society or risk to themselves when they repeatedly offend. And by limiting the ability to be released on bail by a bail commissioner, forcing that individual to go to the court to account for their actions in a bail and public safety arena is appropriate. And as I said, the best person to do that is indeed a judge, not a bail commissioner. There have been several anecdotal comments throughout today's testimony. In my preparation coming today, over the last couple of days, I've had some telephone conversations and some email conversations with other prosecutors throughout the state. I don't speak for them individually, and so I'll not use their names, and they shared with me some individual cases that are currently open, so I'll not share the specifics of the cases. But I will share their generalized concerns as I understood them. In one location, a prosecutor mentioned to me that an individual was finally held after a fourth domestic violence charge. Now, I guess as a public policy measure, what are we telling a victim of domestic violence or multiple victims of domestic violence when a person who reoffends while they're out on bail is not being held or not being reviewed by a judge and may be released by a bail commissioner? What kind of public policy is that? And that's a question that you as a committee and you as a legislature have to address. Another prosecutor mentioned that there was a defendant in court who was appearing on multiple failures to appear from several jurisdictions. Again, as a public policy matter, what are we saying when an individual is released on bail and not appearing and is released so many times that he now has several prosecutors from several jurisdictions in court on the same day to address his behavior in society and his threat to the individuals within in society? That's the bigger concern. As I said, I agree that limiting the issue under 597.18 is probably a more appropriate place to place this. Attorney Scher made a good point, and I think there'd be several of the prosecutors that would agree with me that, generally speaking, the bail statute as it's currently written generally works. It really does. The issue becomes with these several individuals, the small group of individuals that commit the most offenses and repeat offenses, and it's that small population we need to address. And I believe one of the ways to address that is to limit the ability of a bail commissioner to set bail and for that person to appear in court as soon as possible. And under the current statute, that would be well within 36 hours. Attorney Enders commented about circuit court issues hearing cases. I too practiced in circuit court since 2000. Up until I was elected as county attorney, I appeared frequently in several counties and probably 4 counties and 7 or 8 circuit courts. And the job I had before I was county attorney, I was in an office where we had upwards of, give or take, a couple thousand, 20,000 scheduled hearings a year. So the attorneys are already addressing these issues, and as was mentioned in prior testimony, in multiple hearings often and hopefully an amendment to 597-18 to affect the change that I believe the committee is looking to affect, or the sponsor of this bill is looking to affect, would be a better way to accomplish that. I'll gladly take any questions.
Representative Bourdonnais?
Thank you, Chair. Thank you for answering my question.
Yes, sir.
So it seems to be, the issue seems to be that we have a lot of people with mental illnesses that are committing and recommitting crimes. Is there a better solution than putting them in jail or rearresting them over and over again?
Well, if I knew the answer to that question, I'd certainly share it, but I don't think there's any one answer. I can tell you that throughout the state, I believe there are multiple initiatives to help people navigate the myriad of services that are available. I also understand there's been multiple discussions throughout the state that many of the service organizations are underfunded. But that's a question for the organizations and the legislature. I would note that in Merrimack County, the county just began and just funded in the budget process a position within the county to help those with substance abuse and mental health issues navigate the myriad of services that are available. And I was part of that discussion and happy to be part of it. In fact, we shifted of some of the opioid settlement money that was under my office over to assist in hiring individuals just to accomplish some of those goals. So, I think there's a number of people, including myself, that are working towards that goal. What the right answer is, I don't know. I wish I did.
Thank you very much.
Thank you.
Representative Newman?
Thank you, Mr. Chair. Thank you for taking my question.
Yes, sir.
Would judges be available, or are they available on the weekend to hear these kinds of bail cases, or would they not be able to do that?
And I know the courts have on-call judges for search warrants and items such as that. I don't believe they're on call for arraignments. Frankly, I wish the state did have a 24-hour arraignment judge and to handle arrests and arraignments on a rolling basis. Many states, many jurisdictions do. And if they had a 24-hour pool of judges just for arraignments on a 24-hour basis, individuals can be in front of judges within hours. We live in an electronic world, and we're able to move paperwork seamlessly throughout the state. But then again, that's a matter for the courts to address and the legislature to fund. Frankly, I think it would be a great idea. There are many prosecutors that really do think it would be a great idea, and frankly, that protects the individual's rights to a greater extent than I believe than current statutes do. I would support that.
Follow up. In the anecdotal testimony that we've heard about arrested, released, arrested, released,
Yes, sir.
arrested, released, are those people released both by bail commissioners and judges?
I'd have to give you only my observation. I would say more so with bail commissioners, but I deal in just the superior courts for the most part now, the Superior Court in Merrimack County for the most part now. So I couldn't comment on how the trend has changed in the last year with the lower courts, other than to say that I do have several individuals that are the prosecutors within the county that are telling me that folks are still released and rearrested several times.
Thank you.
No further questions. The witness is excused.
Thank you.
Thank you for testimony.
We now call Chief Aldenburg, Manchester PD.
Good afternoon, Chairman, members of the committee. I will be, you have my written testimony, Mr. Chairman, I believe, but I'm not gonna read that word for word, out of respect for everybody's time. People are probably already dwindling out of the room. Prior to the attorney from Merrimack County speaking, I come to you, let me first start as the Chief of Police for the City of Manchester. And there's been a lot of comments today, which some I agree with on both sides. I just want to clear the record that as a chief of police of Manchester, I did not ask the sponsor, as was insinuated by the UNH professor, that I asked for this bill. That is not a fair assessment. It's not accurate. So I'd like to clear the record on that. We've heard about impacts on the judicial branch, impacts on the offenders. Prior to the gentleman from Merrimack County, I haven't heard any discussion about impact on victims. And why aren't we having that discussion as a community, as a legislative body, as law enforcement? We have it every day. So I think that needs to come more to the forefront. Victims of domestic violence, child abuse, merchants, store owners, people that are losing money, domestic violence victims that are being offended over and over. It's time for that discussion to come to the forefront. You know, along the lines of the bail commissioner, under the statute of 597-18, I believe he said, maybe that is the right place to do this. The bail commissioners do not work for me. They work for the court, but they lack training, they lack expertise, they lack that subject matter expert on the laws that the judge has. So getting these people in front of a judge within 36 hours, our repeat offenders, is probably more appropriate, and I can tell you is more appropriate than having the bail commissioner take on that responsibility, put it where it belongs, in the courtroom. There are times where this current bail law does work. Judges do hold people. Judges do hold people on preventative detention. There are times when they don't, but they're the judge, and they're acting within the purview of the law. I may not always agree with somebody being released on PR bail out of a court, but at the end of the day, that's the judge's decision, and we respect that. And I'll end with, 36 hours doesn't seem like a lot of time. To me, it's not. And if that's one less victim or one less opportunity for somebody to reoffend, I worry about what's it going to take in this state. And this just isn't Manchester. We have a tendency in our society as a country we wait for that horrible, horrible moment. And then we say, you know what? Now we got to really do something, and let's name this bill after this victim who was gunned down or murdered as a result of a domestic violence incident. We see it all the time, do we not? We name bills after people. And we don't do that until something serious happens and we all go, oh, now I gotta really take this serious. Do I have people reoffending in my city? 100% I do. I can give you anecdotes upon anecdotes. I'm not gonna do that because you're all smart people. You all watch the news and read the newspapers. But quite frankly, this is very difficult on law enforcement. It's a drain on resources. It's a drain on the mental health of my police officers when they have to arrest the same person within 36 hours for some violent offenses. And I don't want to stand in front of an officer of one of my officers' families or one of your families and say, hey, we're sorry that your loved one was killed by gunfire or whatever other means, because we didn't want to wait for the offender to be held for 36 hours to go see a judge. It's time to start talking about victims, and I'm sorry for my tone if I get a little aggressive. Just getting a little frustrated with the quality of life and all the other impacts that people that are reoffending are having on our society, and it's just not fair to the good people of this state, quite frankly. I'm happy to take any questions.
Representative Lynn?
Yes, Chief, I wonder, I think you'd be probably in a very good position to comment on this. What would be your view, and I know it's really beyond the scope of this particular bill, but what would be your view on the idea of just doing away with bail commissioners altogether and saying everybody, when you get arrested, you go before a judge?
No, I don't think we have to go that far. I mean, bail commissioners serve a purpose in our system, because you have those people that may be arrested for that minor shoplifting, no criminal record, first arrest. PR bail is probably appropriate. They have connections to the community. They have a job. They made that one mistake. Okay, PR bail there is appropriate. So eliminating bail commissioners is not something that I would be in support of.
Okay.
I just think maybe what I think they need is some more training and more education, and maybe some attention should be paid to that, because they come in well-intended to do the right thing, but sometimes things get cloudy for them, and I can't, and my officers can't tell a bail commissioner what bail should be. We cannot do that, all right? We can only present them the facts of the arrest, and then they have to make the decision from there.
Thank you.
Representative Bordnay.
Thank you, Chair, and thank you for answering my questions, or taking my questions, should I say.
Absolutely, sir.
I'm going to refer you to RS 597 7A.
Yes, sir.
Paragraph 1A. And it actually does refer to a person that violates restraining orders or protective custody. They can be, a warrant can be issued and appear before a justice within 12 hours.
Correct.
Do you ever use that?
Yes, we do. And at 597.7, we also use that when it comes to violation of bail or breach of bail, like the attorney prior to me has spoken about. That's something that's a practice that the Manchester Police adheres to. So if you're out on bail, and you reoffend, we will file a motion to revoke your bail. But does that necessarily mean that they're held? It does not.
Representative Bordnay.
Thank you. With that, so what is this bill needed? Since this particular section of law really allows you to have them for a judge.
That's on domestic violence related offenses, right? Did you not say 173? RSA 173?
Yes.
Those would be domestic violence related offenses.
And this also refers to 458:16. It is talking about violating a restraining order as well as protective custody.
Representative Bordnay, just before you continue, just understand that the witness does not have the RSA that you're referring to.
I can lend it to him.
If you'd like to. Yeah,
Well,
but
he actually says he's familiar with it.
what you're referring to is 173, is you're referring to domestic violence related offenses, violation of restraining orders, those type of, particular violation of restraining order, somebody will be held pending to see a judge. But,
We should be recognized for a follow-up.
Thank you. I only brought up paragraph 1A because that is the issue you were brought up. But paragraph 1 also talks about any particular crime that is being committed by someone who's violating their terms of their release.
correct. And you can file a motion to revoke their bail,
Right.
which
And
we do as a matter of practice.
so, why do we need this bill?
Is not, I understand where I think I understand where you're coming from, I think. The importance of this is getting the offender in front of a judge as opposed to a bail commissioner. And I think there's, we may have better outcomes if the judge is hearing these cases within 36 hours as opposed to a bail commissioner setting bail when it may not have been appropriate. But some jurisdictions don't, there's some jurisdictions that don't exercise filing a motion to revoke bail. Some do and some don't. So I think this would add, doing it this way would add more consistency across the board.
Follow-up question?
Thank you. So I'll read a sentence from the paragraph 1. The accused shall be brought before a justice for a bail revocation hearing within 48 hours. Now, are you telling me that that justice could be a bail commissioner as well as a judge?
I don't think that's it. I don't think that states bail commissioner, does it?
No, it does not.
Okay.
It says justice.
Mm-hmm.
So,
Representative Bordnay, although it's a healthy back and forth, you only permitted to ask members of the public testifying questions and just be specific. And again, the witness does not have the RSA in front of him. So just a reminder.
thank you, Chair. Thank you for answering my question. Thank
Happy to have that discussion offline if you'd like.
Be glad to.
All right.
Representative Newman.
Thank you for taking my question.
Absolutely, sir.
When somebody is arrested on a Friday afternoon in Manchester, and this bill is in effect in the future, and they don't have a process, they don't have the availability of a bail commissioner any longer, what happens to them? Where do you detain them, or do they go to the county jail, or what happens to that person?
Well, they would still have access to the bail commissioner if they were arrested on a Thursday morning at 4 o'clock in the morning or Friday afternoon at 2 o'clock. They would still have access to a bail commissioner. And then bail would be,
No, I'm talking about if this bill, if bail commission, this bill.
oh, within the 36 hours?
It says within 36 hours, but it also does, it also says notwithstanding something else. It means that they would not be able to go, as I understand reading the bill. Maybe I'm wrong.
They'd be transported to the county jail.
To the county jail, okay.
Weekend, and then be arraigned within that 36 hours, weekends and holidays excluded.
Right, so they would not be.
But in Manchester, I can tell you that if they're arrested on that Friday afternoon and we can't get them in front of a judge on Friday, then they'll be in front of the judge on Monday afternoon, either in district court or in superior court. That's how we handle it.
Follow up.
Representative Newman, you recognize for a follow-up?
Thank you. And I know that I listened to your testimony, and you thought that bail commissioners should not be eliminated. Do you feel that there could be something better where they might be trained and be brought up to a standard that would be?
That would be helpful. It would, and I think they would welcome that, because I've had those discussions with the bail commissioners that they wish they had got some type of further training and education.
Thank you.
Thank you for your testimony.
Thank you, Mr. Chairman.
The committee now calls Frank Knack, ACLU, New Hampshire.
Mr. Chairman, members of the committee, thank you for the opportunity to testify today. My name is Frank Knack. I'm the policy director with the ACLU of New Hampshire. We are here in opposition to 1476. And so I guess you all have my testimony, or you should have my testimony soon. I think it's important to note that we are talking about taking the liberty or depriving the liberty of potentially thousands of granite staters. And the entire discussion today has been based on anecdote. And I think that should be worrisome to everyone on this committee. And so, while proponents have not brought data, I thought it was important to bring some data to the discussion. And so, as Police Commissioner Scheer noted earlier today, when bail reform went into effect in 2018, so I went to the Department of Public Safety website, looked at crime data from 2018, 2019, and 2020. There's no 2021 data available yet, so those are the most current years we have. Crime in New Hampshire is down 14% during that time period. Again, we heard a lot of talk about Manchester. So between 2018 and 2020, crime is down 10.6% for Group A crimes. Arrests are down 38.5% for Group A crimes. And for Group B crimes, arrests are down 28.7%. We also heard a lot about shoplifting and concerns about shoplifting. Shoplifting between 2018 and 2020 is down 21.2%. And so while I'm not going to sit here and say crimes are down because we did bail reform, the notion that bail reform is making our communities less safe is not supported by the data. And so I think it would be prudent for this committee as a first step, if there is some alleged concerns, that we would actually have a data collection as a logical first step before potentially depriving thousands of people of their liberty. Again, this bill is based in fear, not evidence. I think it's also important to note that this bill does not make our communities safer. Again, as has been noted before, existing law provides the authority to hold people who pose a danger to their communities. It's an individualized assessment. That is a proper way to do it. We should not be grouping everyone together and then depriving groups of people of their liberty just because it's more convenient for the courts or more convenient for law enforcement. And again, I think we also just heard someone testify that 36 hours isn't a big deal. I think, for folks who are working, everyone knows that 36 hours is a big deal. If you're a parent, if you have a job that's a shift job where you can't miss work, If you have other responsibilities, you can lose employment, income, your house within 36 hours. This is a big deal for a lot of people, and I think it's important that we don't underscore that. And finally, we're talking about a bill that would literally allow people to be incarcerated pre-trial for an offense where the max punishment, if convicted, carries no jail time. I mean, that to me is just something that should be deeply concerning to everyone on this committee. So I appreciate the opportunity to discuss these items with you all today. I know a lot's been already discussed, so I will hope you all will read my testimony. I think actually one final point. We've talked a lot about solutions, and so we do know that there are solutions to a lot of the problems plaguing society. I think there was a question about mental health earlier. We decarcerated the institutionalized mental health facilities 60, 70 years ago and didn't provide any wraparound supports. That is the problem. That is the thing that we need to address. We know from social science data that if we want to reduce crime and make our community safer, access to housing, access to living wage, those are things that actually make our community safer and actually address crime. Policing is inherently reactive. It doesn't reduce crime. Again, social science studies have shown that time and again. So when we're talking about depriving potentially thousands of people of their liberty, I think it's important. And again, we've tried this with zero tolerance policies in schools. We've tried this with mandatory minimum policies in the adult context. Again, they don't work. Individualized is the proper way to go, and so I urge the committee to oppose this bill and to engage in some robust data collection, because that's what we need to be doing. So thank you.
Representative Pantelakis.
So I guess you can look at the pre-pandemic years. So from 2018 to 2019, overall crime went from 8404 per 100,000 to 7856. So a reduction. We saw a steady reduction over all those years. And so if you're just looking at the pre-COVID years, you also see a steady reduction in crime. And that follows a general trend that was even before bail reform. Even 2017, it was higher than 2018.
Representative Scholz.
Mr. Chair, are you discouraging questions? Is it okay? I don't know if we're trying to keep time.
Are you making a parliamentary inquiry?
Yes, sir. Thank you for clarifying.
You're recognized for parliamentary inquiry.
Are we in need of less questions?
I've not stated that there's any restriction on the amount of questions any member can ask. When we run behind schedule, the practice in this committee has been I would normally limit members to 2 questions per witness.
Okay.
But nothing's in place right now.
I do have a question.
So you wish to be recognized for a question of the witness?
Yes, please.
You're recognized.
It'll be quick. It'll be quicker than I wanted it to be. I really appreciate the point that you made about what I would call the social safety net that could fix this in a less expensive way. I'm curious to know, because I've heard that from Concord's police chief, and I represent a lower income part of Concord. Do you have data that could be helpful to that continuing debate that this bill and others fit within? Because I think that financial and practical discussion, that would be very helpful data for all of us to have.
Yeah.
I'm not on this committee. I'm a sub,
Okay.
but I would love to give you my email address and probably would benefit everybody.
Yeah, no, there is substantial data, and I'd be happy to circulate that. And in addition, there's also lots of new emerging data around violence reduction and effective solutions to violent reduction. And part of that includes not policing low-level offenses. And so like Manchester, again, 84% of the arrests in Manchester in 2018 were low-level nonviolent. That means only 16% of the arrests they made in that entire year were for serious matters. And so again, the research shows that that is ineffective police work.
If the chair can inquire with a question, and thank you in advance for taking my question. At least the original draft of this has to do with someone who's arrested while already out on bail. So my question is, what if this policy, I take it you don't support,
what policy would you support where you actually can hold people accountable for violating the conditions of their pretrial release?
We think the existing statute has mechanisms in place to ensure that people who violate their conditions are held responsible, and that there's an individualized assessment in those cases, and if they pose a danger, they should be handled. But again, where housing using our jails as a solution to people experiencing mental health crises, substance use, et cetera, is ineffective. It's cost prohibitive if we actually maximize that. And so we would urge investments in actual, reducing investments in life-affirming services that are actually going to address the underlying causes that are creating discord in communities.
Thank you. Representative Pratt?
Hello. Sorry about that. I know the ACLU looks out for the rights of people. We have heard today of rape, attacks with pipes, injuries by people out on bail. What is your position on the rights of the victims from people that are repeat offenders and people that are out on bail?
Yeah, no, I appreciate that question, and I think the existing law has mechanism in place to ensure that those people can be held. It's incumbent upon law enforcement to make the case to the bail commissioner that the person should be held, but the existing law clearly states that someone can be held if they pose a danger to the community. And so again, that's the individualized way that we think is most appropriate to maximize reduce the likelihood that we are holding people who don't need to be held, but again, have a mechanism in place to hold people who do pose a danger to their community.
So at that point, they have an assessment. They don't really have an assessment of a person to be able to do that. They were charged with a crime and been let out.
Well, if they were arrested, they would have the facts surrounding that arrest to then bring to the bail commissioner to make the case. And I think, one of the things that I think it's also important to remember in this context is that we heard, a number of the proponents continually talk about these people as offenders. And again, these are people in our criminal justice system, which I think is most appropriate, who have not been convicted of any crime, who are then alleged to have been done something else. They have not been convicted in any context. They are not offenders in any context. They are merely people who are out on bail, who are alleged to have done something, and so we have a mechanism in place to ensure that if they do pose a danger, the law enforcement can make the case and the bail commissioner can hold them.
Doesn't this bill make that easier to do?
This bill would mandate that they're held, and so I think that is, I'm not sure how to put this. This is, it's a blanket approach to something that will catch in it, potentially thousands of people who pose no danger to their communities and who have families that rely upon them, who have jobs that will be taken away, who have houses and income that will be lost if we do this.
Okay. Thank you.
Representative Pantelakis.
Thank you. Thank you for taking my question. You just said that these people would be losing their jobs and their homes and everything. If they've committed a crime, why does that matter?
Well, they haven't committed. They've alleged to have committed a crime, but in our, as you know, in our legal system, you're innocent until proven guilty. And we think, particularly for people who do not pose a danger to their society, we know that jail is an ineffective solution to making our communities safer. And so, we also know from social science research that people having employment, that people have steady housing is more effective at reducing, the likelihood of people committing crimes. For people who do have criminal records, the likelihood that they will recidivate. And so we think it's, most important to actually follow the social science data and the data in terms of what's more effective in terms of making our communities safer. And in that case, it would be trying to ensure that folks have housing, have, and if they have kids, that their kids are, not put out on the street.
Thank you.
And thank you for testimony. The chair has a question, and thank you again in advance for taking my question. There was a bill, it was SB 92, passed in this committee as amended. It was ultimately tabled. Comparing that to this, and I'm not asking you to go line for line through each one, but from a policy perspective on really addressing violating conditions of release and whether or not to bring someone in front of a judge as opposed to a bail commissioner. Is there any, I guess, can you compare the two and any thoughts on which policy may have been more tailored towards a specific issue?
Yeah, no, I appreciate the question. I think, in SB 92, I think one of our main concerns was it had the 13 offenses that mandated detention. Again, not individualized assessment, but just because you were alleged to have done something. And I think we all know in New Hampshire that charges are brought, and then once the prosecutor gets the case file, they may rethink what those charges are and whether they were appropriate, and they could be reduced. And so again, you're going to be incarcerating people pre-trial for something that the prosecutor could then reduce before they even get to trial, and it's inconsistent with, I think, the best practices of a judicial system should be. I think, from our perspective, the existing law works. The data shows that it's working. We've had substantial reductions in crime and in arrests in New Hampshire since bail reform went into effect. We would, of course, be willing to be a part of any collaborative project to discuss more effective solutions and ways that we can make our system stronger. And I think, as Police Commissioner Scheer noted, I think that discussion should include stakeholders, broad spectrum stakeholders, social service providers, mental health practitioners, substance use experts, folks who work in low-income housing and people experiencing lack of housing. I think we need to have a cumulative wraparound response to how we can make our communities safer.
And thank you for taking my question. And one last follow-up. I understand that there's no objection to holding a person or detaining a person till they appear in front of a bail commissioner. Why is there an objection to holding that person till they appear in front of a judge?
I think our concern is the timeline. And so if the judge would get them right away, but we need to ensure that there's a mechanism in place that we are not holding people unnecessarily. And so the mechanism we have in place now is the bail commissioners, that they can see it pretty much right away. And that's an effective way. The data shows that it's working, and that the bail commissioners have the authority to hold people if they are a danger.
Thank you for taking my question. Seeing no hands raised, the witness is excused. Thank you for your testimony.
Thank you all.
The committee now calls Rusan Chester.
Thank you, committee chair. Thank you, committee members. I am a citizen of New Hampshire, specifically the town of Bedford, New Hampshire. So I am very near to Manchester. I was born in Concord, New Hampshire, and have lived my entire life in New Hampshire. I've listened to everybody's come forward, and I've heard about the antidotes. Just give you a little bit of experience. A little bit about me. I was a community outreach worker prior to COVID for a number of years. I also worked for the state of New Hampshire for over 15 years. What I will tell you, and my background is psychology and social services. When bail reform first came up, I thought it was a good idea. However, I have learned that people who are committing crimes repeatedly have learned how to circumvent the system. So, what happens to someone who is homeless and it's cold? They commit a crime before bail reform. They committed a crime on Friday night, so they would be warm till Sunday or Monday before they could get in front of a judge. What they're doing now is they are trying to, so what's happening, and I know this because I volunteer in Manchester. I volunteer with our homeless, I volunteer with our mental health folks, and I volunteer with our substance abuse folks. And I'm telling you that this bill is very much needed. And the reason for that is these folks are being brought to the bail commissioner. Oftentimes the bail commissioner only knows that instance. They don't know that they have, sometimes they don't know that they have multiple things in their background that they have not been held accountable and responsible for. We teach our children actions have consequences. By putting these bail commissioners in a position where they may not have all the information. Even the officers don't always have the information. It's not always the same bail conditioner. The bottom line is that we need to start holding that percentage of the population accountable for their behavior. And it's not a, I looked up, what is the legal definition of a victimless crime? It's no apparent victim or no apparent pain or injury. Any crime has pain or injury to some extent, even if it's violating your First Amendment rights. So you have someone that's tagging the side of the highways with gang messages. That's a victim. That crime has a victim. Not just the fence, not just the public property. The victim is the perpetrator is sending a message. Every crime has a victim. Shoplifting. You know who the victims of shoplifting are? Us. The taxpayers and people who are spending more now because they're not prosecuting shoplifting anymore because it's just too difficult. I heard about the crime has gone down. Well, okay, crime's gone down, absolutely. I would argue that's because people are not being arrested. People are not being held accountable and responsible, and they can say, well, I'm homeless, or I have mental illness. It's not a catch-all. People should be held accountable and responsible. I believe this bill also provides some kind of protection for all of us as citizens, but also it provides protection for our law enforcement officers. Because you look at the number of studies that have been done. When a person breaks the law and doesn't have a consequence for it, they're going to continue to break the law, and they're going to increase the potential to have a victim. So if their first victims are just tagging the sides of the road with gang stuff, what's their next crime if they weren't held responsible for that one? I heard about unintended consequences. To be honest with you, a bill like this would provide transparency. It would develop a level of trust that has been lost, and it would bring the community more together. Because there is a huge divide right now. There are a lot of people in even Bedford, New Hampshire, that are fearful of the homeless, are fearful of the mentally ill. Why? Because that small fraction that they've heard about is scary. That's not okay. I heard about the statistics. We're going to violate thousands of people's rights. So I took that, and because one of the first things I learned in psychology is how to lie with statistics, statistical psychology. So based on the figures that the last presenter gave me, we would be, by holding someone in jail until they could get in front of a judge, we would be affecting less than 1/4 of a percent of the total population of New Hampshire. And he said thousands. But I also heard someone else say, of those thousands, there's only about 2% that are repeat offenders. So it would be affecting a lot lower subgroup. That would mean that we could potentially be infringing the rights of, if they really truly were innocent, of everything they did, so the first crime and the second crime. We would be impacting less than 0.03% of the population in New Hampshire. What's more important, that 0.03% or all the citizens, the children, the business owners that we pay for our government to protect us? Now, coming from a social worker's standpoint, you would suspect me to say, oh, but they have mental illness and they have substance abuse. Unfortunately, I have seen it. I have seen, it's a joke. Criminals that are going to commit crimes and going to keep upping the ante know it's more important to commit a crime on Friday night when I know this bail commissioner's on because he lets everyone off. Would you believe that? Because that's what's happening. So something has to be done. Is it providing more education and providing bail commissioners with more consequences if they continue to do this? Maybe. But this is a nice, easy, clear-cut thing. We get them in front of the judges and we allow them to, it would help, in my opinion, it would help deter the weekend crimes. Because that's also one of the things that happens, is everyone says, don't ever do this on a long holiday weekend because you're not going to get a bail commissioner. Do you know sometimes it takes more than 3 days to get a bail commissioner to sign your PR bail? It's happened. So the fact that I've sat here and heard we're worried about the thousands of people with mental illness and substance abuse and homelessness, I care about them too. But I care more about the people that are complying with our laws, the people who are not violating the rights that our Constitution and our Declaration of Independence provided for us. So that's all I have to say, and I'm more than open to any questions.
Representative Newman.
Thank you, and thank you for taking this question. Could you go back to your numbers and your statistics again? There's about 1.4 million people in New Hampshire. I think you, can you just go over your numbers again?
So, 1.4 million. I
Okay.
put by the census of 2020, I had only 518,000. So, if I do 1.4 million, that 0.25% is significantly reduced. So I was doing it back there while I was listening. So it would be a lot less than it would be like 1/10 of the population, or 0.001 if we were to take the only 2%. So instead of 0.03, it would be 0.001.
Follow up.
Yes, I'd like to work with real numbers here. So if I just looked on 21 census showed 1.38 million. So are we talking like 300 people?
1.38.
1,400?
Yeah. 1,400 would be the number that would be affected by this.
Okay, and 1,400 is your 1%.
0.001.
Okay,
Correct.
thank you.
I think. Let me see. I can do it. Actually, it would be 0.007.
Point, and just quick follow-up. So 0.007 reflects 1,400 people
Out of the figures you gave me, yes.
out of the population. Thank you.
There be no further questions. Thank you for your testimony.
You're welcome.
There's anyone else in the audience wishing to testify who has not testified? There being none, I will now close the public hearing. When's the next? Oh, the committee will stand in recess for 10 minutes.
At this time, we will now open the public hearing on HB 1335 relative to the parole board and the procedure for medical parole of prisoners.
And the committee calls Representative Murphy.
Ready? Good afternoon. Thank you, Mr. Chairman and honorable members of the Criminal Justice and Public Safety Committee for allowing me the opportunity to present House Bill 1335 relative to the parole board and the procedures for medical parole of prisoners. A special thanks to the chairman for postponing this hearing from last Friday, as I suspect the weather may have prevented me from this opportunity. Childcare. For the record, my name is Jim Murphy. I represent Grafton 12, which is Lyme in Hanover, where I have lived for over 40 years. I'm a first-year representative, having previously practiced orthopedic surgery in the Granite State for nearly 40 years at both Dartmouth-Hitchcock and New London Hospital. House Bill 1335 is a bipartisan bill that revises portions of Section 651-A:10-A of Title 62 Criminal Justice Code, Chapter 651A, dealing with the parole of prisoners. This bill came about in response to a review and audit of the medical parole process in the performance audit of 2019 of the New Hampshire Adult Parole Board. These revisions promulgate rules for medical parole and codes that medical parolees have equivalent levels of scrutiny for parole, track and review medical parolees, and establishes medical parole conditions. There are basically three changes to the current medical parole statute. First, it revises the membership of the Adult Parole Board and makes terms gender neutral. Second, it revises criteria necessary for determining if an inmate qualifies for medical parole. Third and lastly, it renames the position of Executive Assistant to the Parole Board to Adult Parole Board Director of Operations. Section 3 of this bill was created to clearly and unambiguously determine eligibility and process criteria for medical parole. If one were to look at the original bill, and specifically I will point out Section 3, Roman numeral 1 on page 2, the language as written is very broad, without essential details, and is extremely brief. It states as criteria, quote, terminal, debilitating, and incurable medical condition or syndrome, end of quote. The proposed revision is significantly more detailed, clearly stated, and consistent with current medical practice and issues, and is clear about process. House Bill 1335 now specifies 3 categories for medical parole, within which all the criteria for medical parole must be met in order to qualify for parole within each of these 3 separate categories. This bill outlines specific criteria for each category, and as such is more consistent and aligned with the vast universe of potential qualifying categories which may exist. It is no longer one size fits all. From a physician's perspective, clear rules, criteria are critical and welcomed in the care of patients. These specific qualifying categories recognize that medicine and complex care of patients change over time and has evolved regardless of one's status, either as an inmate or not. For example, the treatment of many complex medical conditions cannot be managed in a correctional facility beyond simply consideration of cost. We no longer institutionalize certain patients as a means to isolate them from society and who may not be appropriate for housing in a correctional facility. Hospice and palliative care are now recognized specialties with many up-to-date treatment options available for the terminally ill and for whom specialized settings for their care are needed. The scope of medicine has expanded and times have changed, and these statute changes are better aligned with these changes. Mr. Chairman and committee members, we believe that House Bill 1335 clearly updates and specifies the processes of medical parole with more specific criteria for consideration of medical parole. It clarifies rules of medical parole. It tracks and reviews medical parolees. It establishes up-to-date parole conditions consistent with and recognizing changes in medical practices. And it makes clear parole board responsibilities for medical parolees, risk assessment, and monitoring while on parole. We therefore encourage you to vote in support of these important revisions to medical parole. We also have here members of the New Hampshire Adult Board to present their own detailed testimonies regarding parole criteria and processes, board membership, and renaming the executive assistant position. I'm happy to take any questions now if the committee wishes. Thank you.
Thank you for your testimony. The witness is excused.
Thank you.
The committee now calls Horace Enriquez.
Do I just begin? Thank you. Good afternoon, Mr. Chairman and members of the Criminal Justice and Public Safety Committee. Thank you for hearing and considering my testimony as to the medical parole portion of House Bill 1335, specifically the medical parole portion. For the record, my name is Horace Enriquez. I'm a member of the New Hampshire Parole Board, starting my 3rd year of service. I'm a retired transplant and trauma surgeon, having practiced in New Hampshire at Dartmouth for the last 25 years, or 30 years now. As Dr. Murphy mentioned, this legislative effort is in response to the performance audit of 2019 of the New Hampshire Parole Board, ordered by your committee. The overarching criticism of the Parole Board were its lack of definitions and inconsistent applications to rules. The concept of cost as it applied to the Parole Board was unfavorably viewed. What you have before you is our response to the audit's 16 specific points of concern. As a starting point, I would like to emphasize that the New Hampshire Adult Parole Board is an independent and separate entity from the Department of Corrections. We are a continuum from the courts through the DOC to transition inmates into society, but we are still functionally and administratively separate from the Department of Corrections. As another perspective, we currently have about 2 to 4 cases we hear a year and only currently have 1 active medical parolee. But we do have an aging prison population and with increasing medical concerns. In the past 2 years, as I mentioned, we've heard 4 cases, and they would be slotted into each of the 3 buckets, which I'll explain in a moment, of a hospice type care, a permanently incapacitated type care, and what I call the serious and complicated medical condition, which is what we wrote in our thing. I think the serious and complicated medical conditions highlights the real difference between what is medical parole and parole. In that, while on medical parole, the parolee was on house arrest, which would not allow him to go to the grocery shopping or into the community to attend church, as these activities would not have be allowed in the prison. It is, we consider this a prison sentence gaining medical care that is needed. I do realize the DOC has raised concerns about the proposed legislation. However, what is not challenged is the proposed concept of our definitions of the 3 buckets, if you will, for medical parole to be considered. I would also really emphasize, and I'll emphasize again, that the concept or the application of medical parole is through the Division of Medical and Forensic Services. It is not initiated by an inmate. It is reserved for those who have not yet met their minimum sentence, so that we can't even consider parole. And I think this is an important concept, and I think this is a concept that the Department of Corrections would agree with. As to the terminally ill, this would be, the concept here would be someone who is a cancer patient in hospice care. The concept of terminally ill and hospice care is easily definable through Medicare and Medicaid rules. The permanently incapacitated, the situation here is the person who's had a debilitating stroke, who's paraplegic of some sort, cannot care for themselves, needs care for their routine hygiene, bathing, toiletry, eating, feeding. It is just beyond the capacity. It may be, it may not be beyond the capacity, but it is a bucket in which the Department of Corrections has a choice. And the last one is the serious and complex medical care. And the best example we have, which is our most recent one within the system, was a paraplegic who had bed sores, required extensive plastic surgery, special beds, rehab issues, reoperations, and required a litany of steps in their care. This was also an inmate who came back to us to be considered for parole when that was available to them. The specific revisions within our system, which Dr. Murphy has alluded to, is that these would have equivalent levels of screening. In other words, if they are a serious threat to society, would they get paroled? No. I think two of these categories are quite easily defensible because the inmate is so incapacitated as to hardly be a threat. Any concerns by the DOC to the medical proposal have been or we will be addressing, and I have a meeting with the Department of Forensic Services tomorrow to work on these issues. I believe our differences are minor, essentially perceptions of vocabulary definitions, and because we are separate entities, we have different sort of concepts of definitions, I guess is the way I would say it. I think added to the turmoil of COVID and the quarantine rules, we have been distanced a little bit further, and I think we can solve this problem quite quickly. But there are nuanced and important practical differences between the prison medical systems and the university medical systems, which I was raised in. I'm just learning about these nuances, but tomorrow I have every belief that its terminology issues will be resolved. I believe our face-to-face discussions the next few days will be comfortable, and we will comfortably resolve separate entities so that separate entities understand each other, administrative rules, and practice documents. Mr. Chairman and committee members, we believe that HB 1335 clearly updates and specifies the present processes of medical parole with more specific criteria for consideration of medical parole. It clarifies rules of medical parole. It tracks and reviews medical parolees. It establishes up to date parole conditions consistent with and recognize changes in medical practices and is based on best practice models. And it makes clear parole board responsibilities for medical parolees, risk assessment, and monitoring while on parole. It also maintains the origin of a medical parole request with the Division of Corrections, Department of Corrections within the Division of Medical and Forensic Services, and again, only applies to those parolees who have not met middle sentences. As a representative of the New Hampshire Adult Parole Board, I ask your forbearance. We would like to have some time to collaborate with the DOC and return to you with an amendment. I'll be meeting with the Deputy Director of Forensic Medical Services this week and hope to have an agreement ready for the committee's consideration following that. For the amendment, I would encourage you to vote ought to pass in its reconciled and mutually supported version. I am happy to take any further questions.
Representative True, you're recognized.
Thank you, Mr. Chair, and thank you for taking my question. You had made reference to if a medical parole was granted, it would be a house arrest.
Yes, sir.
Bear with me. So, I mean, whether it's in a hospice care building or a hospital or your physical house, that's all considered house arrest?
Yes, sir.
Thank you.
Seeing no hands raised, the witness is excused. Thank you. Thank you for your testimony.
Thank you very much.
The committee now calls the Honorable Donna Sitek. now call Jennifer Sargent.
Thank you. Good afternoon, Mr. Chairman and honorable committee members. I'm here as the chairman of the New Hampshire Adult Parole Board to ask you not only to vote in favor of the medical parole statute once Dr. Henriquez has had the opportunity to go back and work the vocabulary issues, the meaning issues of certain terms and certain principles through with the Department of Corrections, but also to understand the non-medical parole features of this bill. The first part that is in the bill is the amendment of the word executive assistant to director of operations. It neither changes the salary grade nor the definition of the job. The term executive assistant is inappropriate in its colloquial sense and also, I believe, in its professional sense regarding the job that the person in this role actually does. And I do have, of course, a list of a variety of the tasks that the person engages in our office, if you would like me to read those to you. On the back page, the last page of the bill, it just follows that the name would be amended to the Director of Operations, again, without cost or task change. We have a CEO, COO type of model in the parole office, with me as the chairman in the CEO-ish role and the COO role going to the director, hopefully the Director of Operations, but now what is named the executive assistant. That person really does direct all of the internal operations, how things are going to proceed, how information comes in, all of the operations. I do not direct the operations. I am the policy and hearings procedure person, but in terms of all of the things that happen in the parole office, and there are so many, that person, our current executive assistant, Jay Mackey, does all of that. So it is the most appropriate name for the person, title for the person in this position to be Director of Operations. And in that regard, it is a definitional technical change. Additionally, we have in the center of the bill, in terms of under paragraph 1 and 2, the 2 paragraph simply cleans up the membership and is more concise. 2 attorneys who are a member of the New Hampshire Bar in good standing and who are in an inactive status. We have to maintain 2 attorneys on the board because we have to always have an attorney at our parole revocation hearings. So since we have to have 2 in case to switch off and in case one is not available to have the other there, it just makes sense to add 2 attorneys and then say there are 3 additional members and take out 1 at-large member. This change shortens things up and just cleans things up. And chairperson, obviously the gender-neutral statement of the chairman, because chairperson is obviously can be male, female, non-binary individual. And so we think that it makes the most sense to just have it explained in a gender-neutral way. That's all I have to offer on the non-medical parts of the bill, and I'm happy to take any questions.
Thank you for your testimony. Seeing no hands raised, the witness is excused.
Thank you.
The committee now calls Jeff Streslew. Did I mispronounce that?
Hi, good afternoon. My name is Jeff Strelzen. I'm an Associate Attorney General at the New Hampshire Attorney General's Office. We agree with the comments that you're going to hear from the Department of Corrections regarding this bill. We think it makes sense to consider the language of the bill further and to study it further before it's passed. These are very significant changes that are being made to this bill. And it's important to note that the bill applies to any inmate regardless of the number of victims that they've hurt or killed, the number of crimes they've committed, or how little of their sentence they've actually served. The way medical parole works, if you have somebody who happens to be sick and they commit serious crimes, or older when they commit serious crimes, they could conceivably serve very little of their sentence and turn around and walk out the door because they have medical issues. These are very difficult concepts for victims to understand, and it's very hard on victims to find out that that kind of consideration is being given to people who victimized their family members. So we would just ask that you consider the Department of Corrections proposals and study this bill further, given that it has very far-reaching consequences in cases. That's all I have, and I'd be happy to take any questions any of you have.
Representative True, you're recognized.
Thank you, Mr. Chair, and thank you for taking my question. And I don't know if you're the right person to ask, but the bill as proposed versus the criteria they use to grant medical exceptions paroles now, what's the difference?
So this, in our view, is more expansive, and we think if we're going to consider revamping this bill, we should consider other aspects of it, including the fact that, again, it's without limitation. So in most instances, when an inmate tries to leave prison, for instance, if someone wants to suspend their sentence, they have to serve 2/3 of that sentence. This bill has no such requirements or limitations. And, you know, not every offender is of perfect health or necessarily young. We have offenders of different age groups, different health conditions. Just because an offender is older or has certain health conditions shouldn't mean that they would escape the consequences of their actions. And there's no doubt that giving someone medical parole is not the same as having that person be in prison. And I can tell you what family members have said to me is, you know, my loved one didn't get to die surrounded by friends or family. Why does the person who killed my loved one get to do that? And obviously there are other concepts here at work, but that is something that resonates with family members. And so we think it just makes sense to consider the whole package, including that piece of it. Maybe it would be that people would have to serve a certain portion of their sentence before they'd be eligible for medical parole, because that's certainly how it is in any other instance where an inmate would get to leave prison early. So we just think this is an opportunity to consider all that together.
Thank you.
Thank you for your question.
Representative Lynn?
Yes, Mr. Shrilton, I think your points are very well taken on this. But let me add, as I read the language of the bill as currently proposed, a person would be eligible under this language to be released on medical parole, even if the condition, the medical or psychological condition that they suffer from was one that they had at the time of sentencing and was known to the judge.
That was pre-existing.
It was a pre-existing condition, so they could. And then the other question, may I ask a follow-up? Yeah. The language of the current law, as I understand it, just talks about it has a terminal, debilitating, incapacitating, or incurable medical condition or syndrome. And I note that in the permanently incapacitated section of the new proposed language, it talks about not just a medical condition, but a mental condition. And I'm wondering if, has the current law been interpreted to allow someone to be released because of a mental condition?
I don't know the answer to that. I think the Department of Corrections could possibly have that answer. I can tell you that the most recent case I had concerning something like this had nothing to do with a mental condition. It was purely a physical condition only. So I have, to my knowledge in our office, we haven't run into a request for medical parole involving a mental condition.
I mean, it would strike me that that would be a much more difficult issue in terms of proof and things like that.
It would, and again, you know, none of us are perfect. Not every offender who commits a crime is perfect. This is a significant avenue for someone who may have committed some of the most serious crimes that we have to leave prison relatively early into their sentence. So again, we just think this is an opportunity to consider all those factors if we're going to significantly revamp this bill. You're welcome.
Representative Pratt?
Some of the conditions that are explained here, could they be handled in the infirmary or the jail?
I have spoken with people at the Department of Corrections on a case I had recently, and they did describe to me their capabilities. And again, my guess is that Commissioner Hanks could probably answer those questions far better than I can. There's certainly some that can be.
Okay.
Again, I'm not fully aware of their complete capabilities, so I apologize.
Thank you.
You're welcome.
Seeing no hands raised, the witness is excused. Thank you for your testimony.
Thank you very much for letting me speak. I appreciate it.
The committee now calls Commissioner Helen Hanks.
Good afternoon, Honorable Chair, members of the committee. Helen Hanks, Commissioner of the Department of Corrections. For the record, I thank you for the opportunity to speak on the proposal before you today and to triage some pre-existing questions and any follow-up questions. Understandably, our Director of Medical and Forensic Services, Paula Mattis, did send her testimony in advance, and I am assured I know you will read and review that. The concerns we had under the current proposal were the areas around a mental condition and some other specificities that ironically cause some vagaries. And for that matter, with our experience in corrections, we have individuals whom have clear diagnosed medical conditions that they're, in the current formulation of the law, are high cost to the state of New Hampshire, that are high utilization of our nursing resources and become a challenge in the environment, and traditionally have been terminal or debilitating in a way that mitigates any risk to the community if we find an appropriate healthcare setting that would take them. And that appropriate healthcare setting historically has been hospice care, sometimes a nursing home setting, and in rare instances, a home setting wrapping hospice around that person because they are eventually going to be terminal. And the age ranges have been from a young person with terminal cancer to elderly individuals with other comorbidities associated with their care. So we do appreciate the Adult Parole Board, and we certainly were part of that audit as referenced in 2019, and look forward to moving and resolving some of those things in an iteration of new reform of law under your guidance, obviously. But we want to make sure we don't open the door to individuals who will actually intend to abuse this law in an attempt to go home, be non-compliant with their mental health care. And I know this committee knows the actual numbers of prevalence of mental health and substance use disorders in those incarcerated, and I know you wouldn't be surprised that some people would be non-compliant with their treatment when in an attempt to achieve medical parole. And as much as I appreciate having those requests come to my office, I want our time to be meaningful together. So I certainly support working with any members, both of the Adult Parole Board, this committee, and the Attorney General's office on some mediated language that reduces potential abuses, but recognizes other medical diagnoses such as dementia and Alzheimer's that could be deferred to a community-based setting safely, as long as the person's conduct and course of behavior is not such that it would be adverse to the other patients in those settings. So we appreciate the progress that is attempted in the iteration before you, but would ask the committee to create a subcommittee so we could work on an amendment together that would be more measured, balancing the concerns expressed in the testimony sent prior to today. I'm sure there were other key areas, but again, I don't want to dwell into the testimony too deeply. I know you've read it. And again, is it compassionate release? Is it cost-related release? What is the state's intent in this update? Because cost is completely excluded in the proposal before you. And I'll tell you, the average cost of incarceration is $45,000 right now. We generally and historically have only put cases forward that are significantly higher in cost. So with that, I certainly am open to any questions that the committee may have of the agency.
Representative Roy?
Thank you, Mr. Chairman. Thank you for taking my question. My question is regarding, there's a whole list of possible ailments and conditions. How does the department deal with chronic pain patients currently that require opioids or things of this nature in the facility?
Representative Roy, thank you for that question. With regard to chronic care associated with chronic pain, the treatment plan for those individuals are going to be truly individualized. And balancing people's risk for opioid addiction, we will look for non-opioid interventions to help that person plus wrapping around mental health groups, managing your pain before it manages you is a common group methodology. We have a multidisciplinary team that actually vets and evaluates people with chronic pain. It's an interesting question because the way the language is written, that's a debilitating condition that's not reversible in many cases. But if that came to my desk, I wouldn't be recommending them for medical parole, but I would have hundreds of individuals who may attempt to seek medical parole just under that one condition.
Representative Muse?
Yes, thank you for taking my question. I'm curious about how the Department of Corrections handles inmates who need palliative care or hospice care. My guess is not all of them are applying for medical parole.
Representative Muse, that's an excellent question. We actually created a hospice program using residents who are trained in I would call benign activities, not healthcare related activities. And we actually conduct hospice in our infirmary settings for individuals who have not risen to the current statutory provision for medical parole. Sometimes hospice is rather sudden, and sometimes we know in advance. And I do balance the voice of victims involved in many of these cases. If I have an individual who's incarcerated with, and I have seen this, upwards of 10 counts of aggravated felonious sexual assault, and we have a terminal condition and that person needs hospice, I'm not likely to ask for medical parole because the costs can be actually contained within the current budget of the agency under the current algorithm and statute.
Thank you.
You're welcome.
Representative Burt?
Thank you, Mr. Chairman, and thank you for taking my question. I did some work for a lady that, it was a Scarsdale diet murder back in the late 80s or 90s. And she was the person that killed the guy. But she got out on a medical exemption, like what we're talking here today. What would this bill do with somebody like her that got better? Because she's out living in Monroe, New Hampshire, and now she's, I think she has passed since, but you know, there was many years she got better. So what would this bill do if you get better? Would they bring you back?
Representative Burt, that was an excellent question, and it's almost like you read the 2019 audit, because there was no, there is a provision in the current statute that says if the person is better, the adult parole board, field services, our probation and parole staff should tell the adult parole board the person's better, they don't meet the criteria of the statute, and the adult parole board would then have a hearing and then revoke the privilege of parole. And in that case scenario, we have had individuals whom did well under that type of medical parole supervision, and the timing of their sentence actually afforded the agency to put them out on administrative home confinement. That was a specific, unique outlier associated with someone's sentencing and serving that sentence.
Thank you.
You're welcome.
Representative Newman?
Thank you, Mr. Chair. Thank you for taking my question. On page 3 of the bill, it shows the current language that's lined out, and says all these conditions apply. And then starting on line 17 or 18, it says the inmate falls into one or more of the following categories, and then lists the following categories that have been testified to so far. Could you just kind of give your impression of how the lined out version compares to the lined in version, and what kind of problems it might cause for you, and what's maybe left in or not left in or needs to be left in? I know you're going to have other discussions in some detail, but just kind of a 30,000-foot explanation.
Thank you, Representative Newman. Under the existing provisions, cost is a factor. So again, and I trust wholeheartedly the adult parole board's research that many states have balanced cost as a driver to medical parole with compassionate release and things of that nature. And I would defer those decisions to the legislature, and then I would act on them. So that is one obvious, clear distinction in what's being proposed today. The parts in the new proposals, it's really the new proposal that creates a differentiation, because it's clear right now for the department that it's a terminal, debilitating medical condition that causes a reduction of risk, so much so that the person's not going to be a threat in the community, and that's in cost. And then looking at the proposed language, using terms such as you see before you, mental condition, mental ability, things of that nature. That creates a lot of broadness for us with a large prevalence of individuals with mental illness. And we just want to work on refining those areas of the bill so that we really are looking at individuals whom, and I will use dementia as an example, have dementia, have needs that at this point could be served better in a healthcare setting outside of a correctional environment, rather than a person who has, and as written, it would be challenged by people incarcerated that they have a major depressive disorder and they're not compliant with their medications and it's not reversible. And I think we can do this in a mitigated way to be successful in the intent.
Thank you.
You're welcome.
Seeing no hands raised, the witness is excused. Thank you
Thank
for your
you.
testimony.
Committee now calls Donna Sitek.
Thank you, Mr. Chairman and members of the committee. I can do 0 to 60 eventually. I want to respond to some of the issues that have been raised. Attorney Strelson talked about, gee, what if some really dangerous criminal asked for medical parole? I would remind you that under current law, there is no limit on who is eligible. The current law is on page 2. You can see that it's crossed out. Starting on line 10, the criteria are on lines 10 through 15. So even if you don't pass this, that doesn't change. That there is the possibility that somebody who committed a violent crime, who otherwise met the criteria, might be eligible for parole if they met all the other criteria. Right now, as a former 10-year member of the parole board, I can tell you that medical paroles are very few and far between. This bill doesn't try to open the doors. It just tries to specify with some detail what the criteria are. Right now, the general terms, terminal, debilitating, incapacitating, or incurable condition. What is that? The other thing is that it's determined that the cost of their care is determined to be excessive. Now, for years, the board has been trying to get a definition of what's excessive cost. We would ask, and they'd say, well, we know that their drugs cost this much. Is that excessive? There was no definition. And the audit asked us, they dinged us on that. They said you don't have any definition of what's excessive cost. And for years, we have been trying to work with the department to develop a definition of cost. The reason that's in there is that a person who is behind the walls and needs medical care, the state has to pay for it. If they're on medical parole, they go out on Medicare, Medicaid, private insurance. So there's an incentive to get them out the door because it's costing the state too much. The way that that issue is addressed in the bill is on page 3, line 3. It says that their care requires resources that exceed the department's medical capability. So that's what's really driving this. If you can't provide it behind the walls because it's too expensive, if you have somebody who's on dialysis, for example, there's the cost of the dialysis, there's the cost of a corrections officer who has to accompany them 2 or 3 times a week. We were never able to get numbers on that. So we wanted to address that issue in a general way by saying that they require treatment and resources that exceed the department's medical capability. The commissioner, in the letter from Paula Mattis, talked about the concern about including mental conditions. The board is very agreeable to taking out any reference to the mental conditions. That it was not our intent to expand eligibility. The intent of this bill is to clearly define it and to set up a process for tracking them once they've been released. The audit noted that we required some to report back to us that there are any changes in the medical condition every 3 months. Some were every 6 months. We don't know whether the reports came back. It wasn't clear who had to file them. This bill clarifies all of that. That's another reason that this bill is better than the current law. And I remind you that any of these medical paroles are initiated from the commissioner's office. So if somebody is too high profile, too dangerous, too whatever, the parole board would never even get to see it. There was a question about if somebody who is released on medical parole and gets the care they need and recovers. Well, the bill requires periodic reports. And if they no longer meet the criteria for medical parole, they come right back to the prison. And as Dr. Henrica said, we recently had a case like that, where somebody was released to the community, was treated in the community, he got better, he came back to the prison to complete up to his minimum, and then he has a chance for a hearing on a regular parole. So I hope that I would allow the stakeholders to sit around the table and come up with an agreeable amendment that satisfies the specifics that the audit required from the parole board and makes it very clear about eligibility and the process for tracking people who are released on medical parole. So I would thank you for your attention and take any questions you may have.
Representative Roy?
Thank you, Mr. Chairman. Thank you for taking my question. I'm curious, because you just mentioned there was a case. Does the time while the person is out on medical parole toll against their...
No. The clock keeps running, and when they reach what would be their minimum, had they not been released on medical parole, they are scheduled for a hearing for regular parole. So somebody who is on medical parole who's still sick and didn't come back meets the date for his regular parole. He gets a hearing, and we decide whether he can continue where he is, but without the restrictions of medical parole, perhaps. Okay.
Representative Newman?
Could you just elaborate a little bit about a person who's released on medical parole to an outside entity as opposed to being cared for medically within the prison? Who pays for that, or how it's paid for, or who's required to pay for it,
When
and
they're
what
behind
happens
the
if
walls, when they're behind the walls, the state is on the hook for the complete cost of their care. If we release somebody on medical parole who meets all the other criteria, and they are on Medicare we pay. Many of our inmates are eligible for Medicaid, and we have released people who had private insurance.
Representative Newman, recognized for a follow-up.
Thank you, Mr. Chair. And what would be the condition, or what would happen for somebody that just does not have access to medical care under any of the things that you mentioned?
Well, before they're released, they have to demonstrate that they have a place that they can go to that will provide the care. And if they don't have any funds and there's no way to pay for it, they're going to have trouble finding a place. But if they can find a facility that will take them.
Thank you.
Representative Lynn?
Yes, thank you, and thank you for taking my question. I'm just curious if, do you have a view on whether there should be some language in this that would require that the condition that provides the basis for the potential parole be one that arose after the sentencing? Because I guess my concern would be, if you didn't have that, then you could have a situation where, for example, a judge, knowing all about the condition, nonetheless decided, let's say, that someone should receive a 10-year sentence, and then, almost immediately the the person could apply for medical parole, and the parole board could essentially sort of, you know, undo what the judge did by saying, no, we think the person should be paroled.
Well, the parole board only considers it if the Commissioner of Corrections recommends it. And there is no limit on how long they've been in. Attorney Strelson talked about other areas where sentences are modified after they serve 2/3, for example.
Right.
We never considered that, I can tell you.
Okay.
It is so rare. I've been on the board, I just completed 10 years on the board, and there was never a situation like that. I think in the 10 years, maybe I've seen 15 or 20 medical paroles. So it's very rare, and those kind of scenarios are nothing I've ever seen.
Thank you.
Representative Pratt?
Hello. Earlier, we talked about mental health, and that's going to get worked on. But is it possible a serious mental health person could end up in a nursing home for medical, Medicaid, Medicare to take care of them? And they would be in a nursing home with the regular population.
The thing about mental health is that the department has the capacity to deal with mental health. We have a secure psychiatric unit. So I would say that the board is very receptive to the idea of eliminating any of the concerns about broadening the application of this by applying it to mental health conditions. That was not our intent.
Good, thank you.
Seeing no hands raised, Madam Speaker, thank you for your testimony, and you are excused. Are there any members of the public present who wish to testify that have not testified already? Seeing no hands, we can now close the public hearing on House Bill 1335. And I'm going to assign 1335 to a subcommittee. Representative Welch, I'm going to appoint you the chair of the subcommittee. Representative Byrd? No. We'll put Representative Testament, Representative Bourdonnais, and Representative Muse. Yes. All right, this time we'll close the hearing on HB 1335.
At this time, we are going to go ahead and open the public hearing on HB 1105 relative to earned time credit. And the chair recognizes Chairman Abbas to introduce his bill.
Thank you, Mr. Chairman, and thank you, members of the committee. I'm Representative Darrell Abbas. I represent Rockingham County District 8, which covers Salem. And just to be clear, just to be clarified with members of the committee last year, I know we've heard a lot about the Earned Time Credit Program. And I've received a lot of comments already and a lot of communications, both in support and in opposition to HB 1105. Now, if you look at RSA 651A 22-A, there are various programs that an inmate can complete in order to reduce time off their sentence. We've, over the years, have expanded that list. It includes getting a high school diploma, you can get a bachelor's degree, even a master's degree. There's vocational programs, there's participation in family connection programs, and there's also on-the-job training that they can receive, and mental health treatment. Any inmate is eligible to receive up to 21 months off their sentence. What HB 1105 focuses on is simply subsection F, which does exclude sections A through E, which I just discussed. And what that section would apply to, it really allows, it's kind of a catch-all section where really any program that's approved by the commissioner could allow an inmate to be eligible for up 60 days off their sentence. It can be used an unlimited amount of times up until the point at least they reach the 21 months. And although I don't have any issue with the underlying policy under subsection F itself, there was no limitation or otherwise criteria for what any program would be and how that would actually, how that can be used and applied. I've been there before, it happens. That's why I'm not upset. What I looked at is, and please don't mistake my testimony or my intentions. I'm not in any way implying that the current policy under subsection F is being misused or misapplied. My concern is simply that it is something that, without any criteria, what would really qualify in terms of the curriculum, how many hours the program would be. It seemed to me that there could be situations where people would raise questions about whether that program is sufficient. So I thought it was worth, at least at the time being, to put a limitation on the catch-all provision by limiting it to a single eligibility for a single-time use. Similar how if you got your high school diploma, you couldn't get more than one, and under subsection A, so therefore you are limited to one-time use. And I'll answer any questions.
There being none. Oh, well, there's one. There you go. All right, Representative True.
Thank you, Mr. Chair, and thank you for taking my question. Looking at section F, which is what your bill deals with, for that program that section F is talking about, you could only get no matter how many you completed, you could only get one 60-day off program.
Thank you for your question. As written in the current law, a person can complete the program, by my math, it was 10.5 times. Each time they complete it, they would be eligible for they would get 60 days off their sentence. So what I'm explaining is that there is no criteria of how that program makes you eligible other than it's approved by the commissioner. So there's no guidance beyond that point. But you can keep repeating that program up until you reach the 21 months. And what the bill would do would mean you only could complete the catch-all provision one time and receive just a single 60 days off your sentence. You couldn't keep re-entering taking a different program one after another and continuing reducing your sentence.
Thank you.
Representative Muse.
Thank you for taking my question. You had said your reason for submitting the bill was because of the lack of qualifying criteria in the current statute. But what your bill appears to do is to just limit the amount of credits as opposed to actually changing the criteria. Would changing the criteria be another way to address this?
Thank you for your question. Without having a clear criteria of what would qualify under the catch-all provision, to me, limiting the amount of times it's applied was, I thought, the best course to go. Because what I believe is an appropriate criteria, I can imagine, and I love working with everyone on this committee, but I know we may have all difference of opinions on that. But if the criteria was really specific, I don't think there would be as much of a motivation to reduce at least to one time. I mean, maybe it would be 2 or 3 times that they can be eligible, which might be reasonable, but having a criteria for, I think, would benefit the concern that I have.
And one of the other things that I'm curious about too are the types of programming that are currently offered as part of this catch-all. So I'm wondering, you know, what's offered, what the advantages of taking it are, and if there are advantages to completing multiple programs instead of just one, from the perspective, I guess, of both the DOC and the resident.
Thank you for your question. In some circumstances, and assuming that the programs that I'm speaking of don't fall under subsections A through E, which does cover a lot of ground, and this is part of the problem with creating a criteria without knowing, because it's a kind of a catch-all, without knowing what the program is, it's really hard to articulate what the criteria would be. So think of like if you're getting your real estate license, there's a certain amount of hours in the course you have to take in order to complete the program. I'm just saying, as written now, it's not really clear. I just don't know, without knowing what the program is, it's hard to actually put that all together. So that's some of the concerns that I have as well.
Thank you.
Representative Bourdonnais.
Thank you, Chair. Thank you for taking my question. So I'll go back and read, because I love to read. Oh, good. But it says here in F that a prisoner who meaningfully participates in any program that is authorized and approved by the department that the commissioner deems to be valuable. So someone is making an evaluation that hopefully we can trust, and that is the Commissioner of Corrections. And I'm sure that the Commissioner of Corrections is not going to approve a program repeatedly for the same person unless they're getting something from it. So is your bill really necessary?
Thank you for your question. And first of all, I wouldn't file a bill unless I thought it was necessary. But with that being said, there is the criteria for what the commissioner would evaluate is that they believe it will meaningfully assist that person, the inmate, in rehabilitation. What I'm saying is that there's nothing actually articulating what the in-depth of that program is, whether it's course hours, and for a person to be able to get 21 months off their sentence. I mean, in theory, they could attend a lecture on an iPhone or an electronic device that's 20 minutes long, and that could satisfy. Now, I'm not saying that that's happening frequently, but it's certainly a concern that could happen in the future. And again, I'm not suggesting that it's currently being taken advantage of, but it seems to me like something worthy of clarifying.
Follow up.
Follow up.
So right now we are relying on the judgment of the Commissioner of Corrections to evaluate whether it is valuable for the rehabilitation of prisoners, just like we value the judgment of judges on assigning sentences. Is there a question? Yes. Shouldn't we be relying on the judgment of the Commissioner of Corrections?
Well, I thank you for the question. I certainly don't think you should take all the discretion away from the commissioner, especially I don't see any reason why the commissioner wouldn't be involved in this process throughout whether it's A through F altogether. I think the commissioner is obviously going to play an active role in that. But like judges, we create sentences. There's sentencing criteria, but when we pass legislation and create a penalty, there are sometimes limitations on what that sentence can be, whether it's shortening a term or making it a life sentence, or even beyond that. When it comes to fines, it's the same issue. The judge sometimes has discretion to waive a fine, reduce the fine. It could be a fine up to a certain amount. So there is a lot of discretion that can be taken into place. But in this scenario, I'm just explaining that there really is no set criteria for someone who's been convicted of a crime to be able to reduce their sentence by 21 months. I would just think that there would be some structure to, especially with the catch-all provision, because that seems to be more, it's less directed at a specific topic, like some of what you see in subsection A through E.
Thank you.
Thank you for your testimony.
Thank you.
We now call Pamela Kiley.
Good afternoon, Mr. Chair and members of the committee. My name is Pamela Kylig, and I am the Public Policy Specialist at the New Hampshire Coalition Against Domestic and Sexual Violence. The Coalition is the umbrella organization for our 12 community-based crisis centers who provide free and confidential services to nearly 15,000 victims of domestic and sexual violence each year. I'm here in support of HB 1105, which would provide guidance on the number of applications submitted for earned time credits in New Hampshire correctional facilities as it pertains to the other programs category. Thank you so much for the opportunity to speak today. And I apologize for being nervous. This bill makes a simple yet important amendment to the number of applications that an inmate can submit to receive earned time credit within the other programs category. As an organization that advocates on behalf of victims of crime in this state, we see this change as necessary to ensuring that the balance is maintained in the criminal justice system, that meaningful rehabilitation and community justice can take place. The change will not restrict the opportunities for incarcerated individuals to participate in rehabilitative programming, but instead will insert an important guardrail to limit any insincere use of this well-intentioned program. Just to give you some background of what we've seen over the last couple of years, the pandemic opened up online programming, making programs more readily available and being completed at a much more rapid rate. While this was a necessary change given the circumstances, it has also had unintended consequences, including a flood of applications under this other programs category that we are addressing today. As the Earned Time Credit program is implemented now, these applications are being submitted at a frequency that has had negative impacts on victims and their families, especially around their mental health and their safety. And I think it's just really important that we all, whenever we're making these decisions, that we're considering victim input. Victims and survivors in New Hampshire have experienced some of the most unthinkable and traumatizing events. The nature of domestic and sexual violence is deeply personal, where the offender intentionally uses forms of abuse to maintain power and control over another individual. Unfortunately, this abuse continues throughout a victim's engagement with the criminal justice system. And I want to just note that we are incredibly grateful for the work of the Department of Justice's Victim Witness Assistance Unit and Victim Services at the Department of Corrections, who provide critical support to crime victims and their families. These services help ensure that criminal justice system minimizes further harm through these supportive services. This is important because I think we really need to remember that behind every person going through these rehabilitative programs is a victim or a family of victims that are trying to heal. And to kind of further illustrate this, according to the Department of Corrections website, victim services staff documented over 9,000 contacts with more than 3,800 victim survivors and their families in 2017. That's the most recent data I could find. And there were also 351 new requests for victim notification during that fiscal year. So victims can remain heavily involved in the criminal justice process long after the trial occurs. We hear from countless victims, families, and victim service providers about the ongoing trauma that victims experience even after a person who has harmed them has been incarcerated. And this can take on many forms. One of that is being notified that their abuser has received earned time credit, which lessens their sentence and often makes them eligible for parole long before someone even anticipated that happening. When a victim chooses to engage in the criminal justice system as a way to hold their abuser accountable, they are seeking safety, security, and a sense of closure. This is immediately disrupted when a victim or their family learns that the abuser has had a reduction to their sentence, which can be extremely painful, stress-inducing, and re-traumatizing. I say this all just in context of this bill, that an inmate's rehabilitation cannot occur in isolation. It should be in response to and acknowledging the particular harm that was created through an effort to learn from and move beyond that incident. But it requires mutual understanding as well as recognition that harm was committed in the first place. This bill really helps maintain that by establishing guidelines that balance the opportunities for inmates to apply for earned time, while also ensuring that victims are granted the space to heal and not have their safety jeopardized. So I just close by saying I hope you consider having this conversation around this bill, and I really urge the committee to consider passing this legislation. Thank you so much.
Thank you for testimony.
The committee now calls Nicole Kaput.
Now it's on. Okay, thank you. All right, good afternoon, Mr. Chair and members of the committee. My name is Nicole Kippett. I am the administrator of the Victim Services Unit at the New Hampshire Department of Corrections, and I am here today in support of this House bill. I want to just thank you ahead of time for hearing my testimony. My goal here today is for you to hear the victim side and to see this bill from that lens. So at the Victim Services Unit, we do strive to empower victims, support them, and provide them with information pertaining to their case as they interface the criminal justice system. So every year we are providing thousands of notifications to victims of crime on case status, whether that be about a transfer to another facility or as a resident transfers out of the prison system. A lot of our notifications do revolve around earned time credit because it is impacting the resident's sentence. Earned time credit is one of those types of notifications that we provide, multiple on a weekly level, and I want to share how that has impacted victims today. So just to give you a background or just to give you a little bit of context of how those notifications go out. So when a resident applies for earned time credit within the New Hampshire Department of Corrections, and that is approved by the Commissioner of Corrections or denied by the Commissioner, my office receives that notification, and then we provide that notification to the victim who is signed up to receive notification from my office. So a notice will go out at that time. So we will be informing a victim that the application was approved and this is the sentence reduction, or it's denied, or it's approved and now the offender now has to submit a motion to the court. Receiving those notifications or multiple notifications on earned time credit, as you can imagine, can be disheartening and re-traumatizing for victims. And that's what I really want to hone in on today, is the re-traumatization that this can cause. And today you'll hear firsthand, and hopefully you all receive some testimony from victims as well, who will articulate very well how earned time credit has impacted them and how it has been re-traumatizing. And one thing to note is how it can certainly have an impact on their healing process. So whether that halts their healing process or makes them take steps back in their healing process. So I just want to make a few points. Like Pamela already said, it's really important to acknowledge that the victims have already been through a very traumatizing experience, just having been a victim of crime, having to go through the rigorous criminal conviction process and then start to understand post-conviction, and then to be faced with the realities of earned time credit and sentences being reduced up to 21 months for an offender's rehabilitative efforts to get time off and hopefully correct some of their behavior. A lot of times when an offender is sentenced, that gives the victim time to heal and time to allow themselves space to feel safe and to work towards full healing. So when earned time credit is granted, that can often compromise that healing process. Additionally, with earned time credits, this can result in a victim not just being informed about the process, but having to talk to multiple advocates at my office, at prosecution, the prosecutor, and oftentimes having to go back and relive their trauma in a courtroom. So some other victim-related concerns that I want to point out quickly. So a lot of times earned time credit was not part of the underlying sentencing or plea agreement. If the resident was sentenced prior to September 2014, that would not have been part of the sentencing. So a victim would not necessarily have agreed to those terms. You'll hear from a victim today who that was the case, that was not an agreed term. So then an offender can do the treatment, get the earned time credit, and then they have to motion the court to then go before a judge to have it either granted or denied. So the victim who never agreed to it now has to go back to court to either give input or talk to prosecution about what their options are in giving input and possibly living with the reality of earned time credit being granted regardless of. And then earned time credit can be added in addition to already time suspended for other programs completed. So if a sex offender, for instance, was granted 2.5 years off of their term for sex offender treatment, they can still apply for earned time credit for behavioral health services as well. There was also the other programs expansion from legislation in 2020. This definitely created an influx in the other programs category where multiple residents were applying. I think Pamela alluded to that as well. And then the other part I really want to hone in on is the level of safety. And I've touched base on this a couple times, but just to go a little bit deeper. So when earned time credit is granted, say it is granted to the full 21 months off of a minimum and maximum. Oftentimes as part of sentencing or as part of parole conditions, a victim can request for no contact orders or travel conditions. So when earned time credit is granted and those sentences are reduced, we're actually reducing certain levels of safety with no contact orders or travel conditions that could be in place for longer but are actually reduced because of earned time credit. So I think that's where I will move on from and kind of come to a conclusion at this point. I don't want to take too much of your time. But in conclusion, I don't think that victims are necessarily against the rehabilitative intent of earned time credit. In fact, I have worked with plenty of victims who have been in support of earned time credit and their offender getting the rehabilitative services that really are necessary for them to be productive members of society. I think what it comes down to is weighing and balancing the victim's level of safety and their input with the rehabilitation of the resident who is incarcerated. And that's really what I wanted to present to you all today. And if you have any other questions or questions for me, I'm happy to answer. And again, I appreciate the time that you've given me to speak and hear from a victim services lens of things regarding this bill.
Representative Bourdonnais.
Thank you, Chair. Thank you for taking my question. It seems to me that notifications to the victims from the prison concerning things that have changed in the inmate seem to traumatize the victim again. And I'm wondering if these notifications, which I've just heard people have signed up for, is really such a great idea.
I appreciate your question. It is their right to have notification and to be kept aware of the resident's status. So it is part of their healing process oftentimes to be informed and involved and to have input in that process.
Thank you. There is another program called Earn Time Off for Good Conduct. Do victims get notification of those credits as well?
Thank you for your question again. Are you referencing the 150 days that they receive as part of their sentencing structure?
I'm referencing credits for good conduct in 651A22. 2.5 days a month for good conduct a month.
We do not provide notification on that, no.
All right, thank you very much.
Representative Conley.
Thank you, and thanks for taking the question. forgive me if this was clear to others in your testimony, but is your concern the amount of total time that could be earned, or is it the fact that anyone can earn any time credit at all?
Thank you for your question. It's not that, it's not opposed to the amount of earned time credit that can be given, the 21 months. I think it goes back to the amount that is being applied for under the other category.
Thanks for that clarification.
Sorry, and just to
Oh,
show
sure.
the impact that it has on victims in general.
Thank you.
There be no, oh, there's one more. Representative Muse.
One thing I'm kind of a little curious about is how the notification comes to victims. So I was a victim in a credit card case, and I get notifications from the Department of Justice, and they're about the status of the trials of the people, whether or not they were imprisoned, when they'll be getting out. They're very short, they're very clinical, they're a little scary. And I'm just wondering, is the problem the earned income credits, or is it the way that these notifications happen? Is there a better way of setting expectations maybe with victims, that this is part of the process and this is something maybe they should expect as opposed to be alarmed about?
Thank you for your question. I think that, I guess to answer a couple of your questions, that I don't think there's any perfect system for notifying a victim of any change of status. I do think that our letters are very, as best as we can, victim responsive and sensitive. We try to provide them as much information and education as possible. And we have tried to do a lot of education to prosecution around earned time credit, just so that they are aware how many sentences are being impacted, so that victims can be properly educated on earned time credit. And again, we are doing education as best as we can. We've created a sheet that we hand out to victims as soon as we get an earned time credit application, so that they can be aware and see firsthand what a resident can get earned time credit for and how it works. But I do appreciate your feedback on that.
If I could ask a question, just so the rest of the committee has kind of an idea, your office doesn't handle credit card fraud, for lack of a better term. Could you give us an example of some of the crimes that the victims are suffering from?
Sure. Thank you for the question. We provide notification and services to any felony level survivor of crime. So whether that's identity theft, burglaries, robberies, homicides, death resulting from drug overdose, sexual assault, and domestic violence, any felony level crime where someone is incarcerated, the victim of that crime can sign up for our services.
So under identity theft, that could actually involve credit card theft.
Correct. If that included a prison sentence, yes, that is the case.
Very good. Thank you very much.
You're welcome.
Representative True.
Thank you, Mr. Chair. Question of the chair. Do we have anyone else coming from Department of Corrections to testify?
Yes, we do.
Thank you.
There being no further questions, we appreciate your testimony. Thank you.
And I do have copies, so I'll hand these out.
We now call Aaron Brown. And you have written testimony? And maybe you could shorten it up from 15 minutes? Thank you.
You put 15 minutes?
Good afternoon, Mr. Chairman, honorable members of the board. My name is Aaron Brown, retired Manchester police detective. I come here before you today as a victim of attempted murder. In the written testimony you'll get, it delineates pretty much what happened. I'll sum it up real quick. Essentially, back in April of 2013, while on patrol, I had an encounter with an individual during a car stop. This individual provided fake identity, ultimately fled on foot from the stop. While chasing this person, as I closed in to grab him and take him into custody, he turned on me and fired at me with a handgun. the encounter being so close that, my uniform was burned from the gunpowder discharge. You could feel the heat on my face. I lost my hearing. I had eyesight problems, and so on. After an exchange of gunfire, the foot chase continued. I eventually caught up to this person and arrested him. It was only afterwards that we found out the scope of the criminality this individual had been involved in. That particular day, he was in possession of not one but 3 fully loaded semi-automatic handguns that he was using to, insulate and protect his criminality. He was in possession of hundreds of oxycodone tablets, which eventually transformed into what we're seeing now with the heroin and the fentanyl epidemic. He was already inserted into the Department of Corrections. He was on probation, however, he was listed as a fugitive because he just decided that he wasn't going to obey the terms of his probation, and they kind of lost track of him, due to his efforts to be not seen or heard from. At any rate, he faced several felony charges that day, obviously the most serious being attempted murder of a police officer. This person would go to court and ultimately plead guilty to all those charges. It was sentenced to 20 to 80 years at the New Hampshire State Prison. As a victim of the crime, I was in agreement with his plea and sentencing on the condition that he waived any ability to reduce his sentence. So, in the simplest terms, there was nothing that he could do the day of his plea and sentencing that he could do once in prison to reduce spending every day of the 20 years incarcerated, nor could he do anything to reduce the remainder of the 80 years once out on parole. So he was to do all of that time within the correctional system. Fast forward to 2014, you had the passage of RSA 651A 22A, and essentially it threw this young man a lifeline in terms of a sentence reduction. So all he had to do basically per the RSA, as you know, is get permission from the Commissioner of Corrections and then perform the courses, and then once completed, he would have to petition the court to have that applied to a sentence. So currently, this individual, if I remember right, has accrued 180 days worth of earned time credits under that statute. He's petitioned the court. Of course, I objected, and now that matters before the court. Hasn't been decided yet, so I anticipate there'll be hearings and so on and so forth with respect to that. As it relates to the House Bill 1105 we're here for today, I'm obviously in support of the changes that would make regarding the special courses or the other courses in terms of the unlimited amount of time currently that inmates can get. I see no reason why they should be afforded the opportunity to get unlimited credit for, right now unspecified courses. As someone mentioned, they could essentially accrue the 21 months maximum time under that portion of the law, whereas obviously the bill today would limit that to 60 days, which, I think is appropriate. I understand, the passage of that law, a lot of times there's a lot of nuance in other things regarding sentences, and someone spoke to it earlier, the truth in sentencing here in New Hampshire. It's just little things like that, as the victim of attempted murder, if I knew today what I knew today in terms of this law and his ability to reduce his time, I obviously wouldn't have agreed to the sentence. That was basically the sticking point for me agreeing to the 20 to 80. And so, I can attest when I get the letters from the victim's office in the mail, my first reaction is, now what? And then to open that letter and read that, this person is not only eligible, but now has completed courses and is slated to get, at this point, 180 days worth of credit. I guess you can imagine how upsetting or troubling that would be to someone in my position. So I think I can leave it there. I thank you for allowing me to speak. I can answer any questions if there are any.
There being none, thank you for your testimony.
Thank you, I appreciate it.
Thank you. The committee now calls Thomas Adams. CCJR.
Good afternoon, members of the committee. I'm Tom Adams, a Concord resident and executive board member of the Citizens for Criminal Justice Reform, a membership organization registered as a New Hampshire corporation, nonprofit. Our members are seeking a system of justice that protects our communities while promoting the rehabilitation of offenders, that also prepares an inmate for reentry into civil society, a reunification with their families, communities, and possessing the knowledge and skills for obtaining and maintaining gainful employment. Since our formation, CCJR has advocated for programs which rehabilitate inmates and prepare them for a successful reentry into society. We have in the past collaborated with legislators, the Department of Corrections, to institutionalize vocational training programs such as high school diplomas, college degrees, mental health courses, and on-the-job training. We do support specialized programs, and this is the instant case we're dealing with in this amendment, proposed amendment. We do support specialized programs tailored to individual needs of inmates. We oppose the enactment of this amendment because it will eliminate individualized programs that the commissioner, quote, deems valuable to a prisoner's rehabilitation, end of quote. HP 1105 proposes to delete section A22AF and limit those specialized programs to a one-time reduction of 60 days. Our current Helen Hanks, the commissioner, is a prudent, thoughtful, and focused administrator. Trust me, you know that by experience. I know that by experience. She is guided by the DOC's mission and core values. Along with her staff, she is committed to reduce recidivation, providing safe, secure, humane supervision, and clearly evidence-based rehabilitation to enhance what? The public safety in New Hampshire. It is evidence-based, individualized programming. That's key. That's in the mission of the department and its core value. Section 651A to AF of the current law allows the commissioner to create individual plans that address an inmate's specific needs. In this sense, these experiences are akin to individualized education plans which are used in New Hampshire public schools. These are plans focused on the individual based upon their needs determined by assessments. This section helps accomplish a DOC core mission, namely to provide evidence-based rehabilitation to enhance public safety, and reduce recidivation and engage in progressive rehabilitation. I've noted the mission and core values as an appendix to this document. I think it's extremely important that this committee, who knows all about that, probably should reread it again when you take a look at this proposed amendment. Research has documented that a key to reducing reincarnations is improving the physical and mental health of inmates, providing educational and vocational programs that will prepare them for a congenial life in the family, gainful employment, and participation as informed citizens in civil society. That's what we need. These evidence-based programs do not coddle inmates. They are not like a free lunch. They're not a form of recreation. They require work in a classroom, and they require homework completed in an inmate's cell. This is not being soft on crime or punishment. The department demands tenacity for learning while inculcating a love of lifelong learning. Because if this doesn't stimulate growth in the future for these inmates who are released, then they may return. So the department's well aware of that. That's why it's evidence-based. These programs are focused on recovery and rehabilitation. The DOC staff is creating programs and experiences to stem recidivation and future victimization. When an inmate reenters society, they often do not possess work skills, knowledge, and mental health stability, which limits their employability to menial, low-paying jobs. Many become homeless and live on the fringes of society, where their need to survive lures them into committing crimes again. National research has shown that former inmates who complete some high school subjects have a recidivation rate of 55%. And vocational training cuts recidivation or reentry back to prison, if I get the word right, to about 30%. Possession of an associate's degree reduces the chances of reoffending to 13.7%. Earning a bachelor's degree, the rate drops to 5.6%. It's amazing. And I would ask you to take a look at the link that I provided that gives the research behind those statements. Now, those are national statements. Take a look at what's happening, and I'm sure that Helen Hanks will provide you with this information. See what happens to the reentry rate in New Hampshire over the past few years. It's declined, but you'll see that. Now, I also want to point out to you that Bard College Prison Initiative and the support program for after release from prison is extremely successful. The rate of return is less than 5%. It's below the national average. Bard has partnered with many colleges and universities, including the University of Vermont and Yale, as well as many, many other universities and colleges throughout the country. I've also provided you a link with the Bard College Prison Initiative's annual report. This is very important because it's just chock full of information that this committee needs to use, and it's simple, it's down to earth, straightforward. You need to use in terms of understanding some of the importance of ensuring less crime after being discharged from prison. This earned time opportunity is based on incentives. Research has shown that behavioral modification does facilitate change in behavior. These incentives are used to encourage inmates to improve their lot. Many of them have a fatalistic view of life. They lack a positive outlook about themselves. Many have a defeatist attitude. They've hit the gutter and can't climb out. I'm not sympathetic to criminals. I'm hard on punishment, but I'm hard on rehabilitation. I think it's important in order to preserve society. The obstacles to them seem too high. I've fallen so low. Why try? I'm going to end up in the same gutter all over again. They are discouraged by peer pressure in the prison by other prisoners. It's difficult to take that homework into your cell and work because some prisoners don't like it. And that can be tough on those who want to change. Earned time credit is an inducement for them to learn. It is a form of behavioral modification. Reducing recidivism prevents more crime and accompanying cost of return to prison. You know, I used to teach. I'm amazed at myself. I've deteriorated in my old 80 years. It is a self-interest of our state to reduce the numbers of reoffenders, thus reducing prison costs. It will provide safer communities, and that's what Ms. Hanks is going to be talking about, I'm pretty sure. That is why the mission of the DOC resonates with our membership. Our membership urges this committee to determine that this amendment is inexpedient to legislate. And as I said before, you'll find the department mission and goals at the bottom of this, because it's important that we focus on what its intents are. Thank you.
Representative Bourdonnais.
Thank you, Chair. Thank you for taking my question. According to our laws, the earned time off is limited to 300 days, which do inmates ever take more than enough courses to make over 300 days off?
I don't know that fact. You could ask Helen about the statistics. I don't want to put words in her mouth.
Okay, thank you.
Representative Panelakis.
Thank you, Mr. Chairman. Thank you for taking my question. Could you tell me who pays for the courses that these people take in college?
You'd have to ask Helen that. I don't know what the current status is. We've debated that question over and over again. And may I assure you that before COVID, the department, DOC, had started working with some area colleges, which our organization wants to participate in. We're very encouraging by the BARD program. And so the costs were discussed, but I don't know the current situation.
Thank you.
I'm going to recognize myself for a question. We've talked about the rehabilitation and the necessity to rehabilitate, and I agree with all those things. But we also heard from victims, and there's definitely a balancing act that the legislature has to look at. And so we heard from a police officer who was basically shot in the face, and he's got PTSD for the rest of his life, I'm quite sure. And someone who was sentenced to 20 to 80 years in prison. Do you not see anywhere in there where there are certain levels or certain crimes so heinous that there should be a limitation on what they can whittle away at the time they have to serve? Is there no punitive aspect at all in your mind for incarceration?
As I think I said that I'm hard on crime. I am hard on crime. Absolutely. I'm not a pussy about crime. Trust me. Trust the students I taught.
We will
So
pardon the P
I
word
would
because of
say
your
to you-
age.
I'm sorry. I didn't hear you. Maybe I shouldn't have. Crime and punishment is a balancing act. The mission of the department is to punish. The state wants to prevent future crimes. And the judicial system is the one that makes the decision of how long. And they can put conditions on that sentence, okay? I also believe that it's in no matter what the heinous crime may be, that person might change, and that's the goal. If the person is not changing, trust me, the penal system will keep them in place, and the parole board will. This is based on evidence-based information and research. This is tough, and I agree with you. I would say to the victims groups, we all should be advocating for education of those who are victimized, because there's a concurrent need for the people who have been a victim to be helped. We can't, their sentence with this memory is devastating. I don't care if it's someone taking money out of the bank, as they did with me from Russia, or it's a person of sexual assault. You still have grief, and that has to be dealt with. I think the state has a responsibility to do that. And I certainly would consider legislation that deals with that.
Thank you for your testimony.
Thank you.
We now call Joseph Lascasse, ACLU-NH. Okay, that brings us to Helen Hanks.
That's a tough act to follow, but.
Well, I won't, never mind. Helen Hanks, Commissioner of the Department of Corrections, for the record, and not intended to confuse the committee. You did hear from our Administrative Victim Services, because the mission of corrections includes supporting victims' rights as well. But on behalf of the agency, we are not in favor of the amendment in HB 1105, and I've given you a twofold an opportunity to provide you a comprehensive packet of information, both to demonstrate the effects of earned time credit since its inception and obviously moving forward. I'll start off by just clarifying some what I'll call misinformation, not misintended, but misinformation. No one is awarded earned time credit for completing the same program over and over and over again. It is a one-time consideration for the completion of that one program that's deemed eligible. And we have an internal policy that I also attached to the testimony that is specific to what's allowable. So I wanted to be clear there. And to Representative Pandalakis' question on pays for courses. As we went through the budget process, I appreciate the legislature for restoring most of our educational funding, but I was also provided a mission and a charge, which is to find a path to education as well, and we've continued to do that. So in many instances, as we even testified in 2014, individuals who are working to attain an associate's degree or higher are paying for that out of their own pocket. The department provides opportunity for a high school diploma, and individuals who are working toward their high school equivalency certificate have to pay $60 for that certificate program. I've taken that charge from the budget process seriously, and we're moving forward with some partners in the Pell Grant area now that the federal government's provided that opportunity, as well as a recent approval of ARP dollars to create the IT infrastructure for make those things possible. To the numbers of people, to Representative Bourdonnais' question, that have hit 21 months, you can only hit 21 months. You may not achieve more than that. That's a rare instance since earned time credit's inception. And one thing people haven't talked about is I actually deny people earned time credit as the commissioner, because the earned time credit they're applying for is not indicative of their prisoners' rehabilitation. And I think one very mindful element of the statute is it's not prisoners, it's individualized. There is an apostrophe S, rehabilitation. I have individuals whose primary need is sexual offender treatment who have remitted applications for other earned time credit, and I have declined them because they're not willing to engage in sexual offender treatment, and their primary criminogenic behavior was sexually deviant behavior. I wanted to make those points readily clear. I want to talk about what has happened since earned time credit, and some of the things as this agency has done, as many of you have done, is surmounted a pandemic in a corrections environment in a way that if you had asked me in 2017 to become the commissioner and become the commissioner of corrections through a pandemic, I would have politely declined. But with that said, balancing COVID quarantine, medical isolation, having our 1,900 plus individuals who are incarcerated today have to be quarantined, in some cases up to 28 days. We did leverage our tablet technology, and through that tablet technology is a learning management system. So we both facilitated coursework through our Granite State High School, as well as two programs under other, a combination of what's called the Peace Education Program, and 10 Correctional Rehabilitation Institute programs, as well as a Breaking Free from Substance Use Disorder. I've included all of that information in this packet and the origin of the foundation for those decisions. One nuance that has only come to my attention since Donna Sitek brought it to my attention, so I appreciate her for that, is there's a report that comes out from those other programs that has a time to completion. And it was articulating that in some instances they were completing things in 8 minutes. Well, that seems not equitable nor accurate. So I'm working with the vendor to say, is that numeric correct? And they said, actually, it's not. It's not counting everything that they're doing. So I just want to share that as a piece of information. So if I go backward, the Department of Corrections and quite frankly the state of New Hampshire should be quite proud. For the last several years, U.S. News has seen us in a positive light, twofold, for a reduction in crime in our state and for the positive way in which we manage corrections. And that's the balance between the penalty associated with a criminal act and the rehabilitation and sentencing efforts we've moved forward on. We should be honored and proud of that because that is the mission that my National Corrections Commissioner partners engage in every day. And so taking the person who's incarcerated, because most of them are returning to a community near us, and finding a rehabilitative path is our mission, our primary mission each and every day. And earned time credit has created an opportunity for people to be incentivized to engage. But it also has created several layers of opportunity for that earned time credit to be forfeited. So I also forfeit earned time credit post-award if they engage in a major disciplinary action during incarceration, or if they join a security threat group, I forfeit their earned time credit because it is a privilege on top of an incentive. Those instances do happen. When I, during the height of the pandemic, needed to create appropriate rehabilitative opportunities, we measured deploying and using that tablet learning management system and did a study 12 months prior to that implementation and looked at our major A offenses and then looked at them after 12 months. And there was approximately a 21% decline in adverse A offense behavior. And balanced with, we still had the same number of quarantine and medical isolations, because one would say they weren't going anywhere, what could they do? Well, that was all balanced. So that did make a difference as far as change in institutional conduct and rehabilitative value. The other part in my testimony, and I apologize for the size, even I'm struggling to read it, is what is happening in our Department of Corrections is because of the development of other programs is things that don't fit into the other sections of the statute. So we've deployed those rehabilitative programs, and the recidivism rate 1 year post-release is going down. It's going down significantly each year. That's a great sign. And then the following year. So starting in 2018, 2019, and 2020, people are not in New Hampshire returning to incarceration, and we continue to measure that. That's rehabilitation. I want to drill in other programs as deemed by the commissioner. Yes, as deemed by the commissioner, but vetted by national science, if you will. Moral recognition therapy is a copywritten program. We deploy that. You can earn credit for that. With Breaking Free from Substance Use was actually designed in the UK specifically to work in corrections environments. We deploy that. I actually sometimes deny people, sometimes approve it. It depends on if they're actually meeting the level of participation associated with their LADAC assessment. Thinking for a Change, I think this committee has heard of that program. It is a nationally recognized intervention for rehabilitation to change your criminogenic thinking. The other part on earned time credit is the actual, and I provided you a copy of the state sentencing document, and I 100% empathize with individuals who went through the justice system before the deployment of this law, because I do struggle when I have those applications and it's not on their sentencing minimus, how that affects the history of the decisions made at sentencing. But I also trust the judiciary process and that vetting process. And that happens in other instances of state statutes, such as someone seeking a 2/3 reduction and other elements of state law that allow someone to even their own independent motion to suspend portions of their sentences, all trigger those communication events and touches with the judiciary system. But I've highlighted that in the testimony that on the minimus, the education at sentencing, if that box is checked, should be to the people who are participating, that you can experience up to 21 months of earned time credit notification, that those might happen if that box is checked. And what would happen if that box is not checked, that they would then try to solicit that through the judiciary process post-incarceration. So I included a copy of that. The other thing I put in here is there are 3 basic principles associated with determining if a program has rehabilitative value in a corrections environment, and that the treatment is provided to people who assess for the risk for it. So you need it to change. We assess that in our organization, both through our risk assessments with our case managers, our clinicians, and so on and so forth through the incarcerated process. And that the treatment program actually targets those criminogenic behaviors that have resulted in the incarceration. So it's antisocial attitudes, substance use disorder, anxiety, self-esteem, or feel-goods, but it's a combination of all of those things. And finally, that it's delivered in a responsive way to the person's style of learning, using cognitive behavioral approaches and changing attitudes, and ultimately teaching concrete skills that change how they respond in the future. I bring that up, and I'm headed to a close to let you ask me questions, because I think one thing we've not talked about is the average grade level of a person who's incarcerated is 5th grade. So if we wrote all of our programs at a associate's, bachelor's degree level, we would not be rehabilitating people. So some of the things you see in here seem maybe middle schoolish. It should, because they have to translate to the audience participating in them. And I include those statistics for you. So as we charge forward to improve the literacy of those incarcerated in New Hampshire, we also have to provide a balance of how we deploy information so it's actually absorbed, understood, processed, and adapted. I assure you, and I appreciate the comments made about the prudency in which I move forward on this, and I do, that we look at rehabilitative programs, we do take feedback, we obviously make adjustments. I've also included our application. It's just the cover sheet that never arrives to my office alone. It comes with numerous documents attached, and with that, I'd be happy to answer any questions of the committee.
Representative True.
Thank you, Mr. Chair, and thank you, Commissioner, for taking my question. As I keep warning people, I was pre-med, not pre-law. Looking at other programs, I don't know if you're familiar with the RSA. I'm sure you are.
Yes, I am.
Okay. Looking at other programs, I don't know how many there are. I'm going to say there are 10. 10 other programs that you have come up with. The way the bill reads, do you read that even though there are 10 programs, 4 might be appropriate for me, but only one of them is going to get me 60 days?
That's how I interpret the proposal.
Thank you.
You're welcome.
Representative Bourdonnais.
Thank you, Chair. Thank you for taking my question. How much time do you spend a week evaluating earned time off?
Representative Bourdonnais, I spend a surprisingly lot of time a week. I, in fact, have, I think, 20 applications on my desk for this week.
So over 50%?
I will spend at least 1 day's worth of, I don't really work 8 hours. You get a lot of good time out of me. So let's just say roughly 8 hours at a minimum of reviewing those applications.
Thank you.
You're welcome.
Representative Marston.
Thank you, Mr. Chairman. Thank you for taking my question. I'm assuming you're in favor of us passing this bill.
I would recommend you ITL this bill and leave the law as currently stated.
Thank you for that clarification.
You're very welcome.
Representative Newman.
Thank you, Chair, and thank you for taking my question. I'm up here. We have testimony that listed a whole bunch of programs that looked like they were all started on the same day and ended up maybe 3 days later, and I just don't, is there anything like that in the, or if there is there anything like that? If there is, how does it affect you? Do you know anything about that? It looks like maybe they're online programs or something like that?
I have not seen that. I can only assume that has to do with what we deployed in December of 2020. Obviously, mid-pandemic, trying to continue to deploy rehabilitative programs, we used our tablet learning management system. And again, Donna brought something to my attention, I don't know, in the summer of 2021 that caused me to look more deeply at those programs.
Thank you.
But I've not been provided that.
Thank you.
Representative Newman, the better part.
Yes, thank you. You have a big job. I was I was fascinated in listening intently to your testimony and also the previous testimony by Mr. Adams. I'm just going to begin my question with a comment that I heard years ago from some of my elementary school teacher friends, that if you want to know who's going to wind up in prison, ask an elementary teacher and you'll get an idea of what's coming. In all of the programs that you have, I've heard you say that you can determine a level of participation. I don't want to assume anything, but I'd like to ask, is a level of attitude adjustment on an incarcerated person's end, is that evaluated by you also?
So Representative Newman, that's an interesting question to try to ascertain a level of attitude adjustment. What I will tell you is we absolutely look at their conduct, and you have to look at the conduct at least 6 months prior to their submission of earned time credit, and if their conduct is not exemplary, then I don't even consider the application. It doesn't even make it to my desk.
Thank you.
You're welcome.
Representative Muse.
Thank you for taking my question. One of the things that we've heard about is the problem for some folks may be less with the courses themselves and more with the amount of notifications and how that process takes place. So is there something that could be done to change that process? So for example, I noticed that you have in the list of courses, there are some that have individual names, but there are others that appear to be more of a curriculum where you have to actually complete multiple courses to get a credit. Is there a way to structure things so that it's less of an individualized course that can be completed, maybe in a few hours, and more of a structured curriculum? So basically you're getting maybe more bang for the buck and there are fewer notifications to victims?
Representative Muse, I think that's an interesting question, and it balanced with I don't know that there's always a one-size-fits-all approach to each person. I do think that we could try to be more mindful about the process in which the application is processed. So instead of it being here's one, here's one, here's one, maybe they only remit one application for multiple things every quarter or every 6 months or something to that effect. But we could actually likely change that in policy and not in statute.
Thank you.
Mm-hmm.
Okay, that's going to, all right, Representative Testament.
With the coursework you have, obviously it has to be completed, by the prisoners. I have heard it said that you can tell how many prisoners you're going to have by how many people can read by the 4th grade. Do a lot of your prisoners come to you unable to read at the level they can complete these courses, or are we making some adjustments for them?
Representative Testament, that's a mindful question. People are coming in with a very low literacy level, and we have to tailor our curriculum, if it's not already tailored, to a 5th grade reading level. And we actually have a grant that we've recently deployed that's working to do that through a universal learning design theory. So it's something we have to be mindful of with everything that we do.
Representative Bourdonnais.
Thank you, Chair. Thank you, Commissioner. I keep hearing stories about how traumatized victims are by notifications from the prison, petitions to be paroled, for inmates to be paroled. And I'm wondering what kind of, I heard Nicole, but can we do anything better to prepare our, help victims, get over their trauma?
Representative Bourdonnais, I wouldn't attempt to try to answer that question on the fly here, but I'll certainly work with our Victim Services Administrator to see what we can do to improve or help. To Representative Muse's comment, the process, I think it's the number of times, and I think every person affected by a criminal act really has their own path forward for themselves.
Thank you very much.
You're welcome.
Representative Pratt.
Just a quick one.
Okay, you're back there.
Just a little one. So you notify them every time that they've earned time and they may reduce their sentence to let people know they're going to be getting out early. Do you let them know when they've been penalized and it's gone the other direction?
I've started to include our Victim Services Department on all those notifications.
Okay, thank you.
Yeah, absolutely.
Okay, that's the last question I'm going to allow for this witness. But keep in mind, members of the committee, that Commissioner Hanks is very responsive to emails, and if you have any further questions, she will get right back to you. Thank you for your testimony.
Whatever you need. Thank you.
The committee now calls Joseph Lascasse.
Thank you, Mr. Vice Chair, members of this committee. My name is Joseph Lascasse. I will be representing the ACLU of New Hampshire in opposition to this bill. And I am asking that this committee will ITL this immediately, and I will answer any questions that you may have based on my testimony at the end. The first thing that I just wanted to go into about this bill, of why I'm opposing this, is it's based on a personal concern over whether or not there is a full understanding of the earned time credit system and how it works. Also, coupled with the fact that this is a Department of Corrections, it's not a Department of Punishment, which means that the goal, the number one objective of the Department of Correction is to rehabilitate the people who go through those doors. Because we, as we know, we live in a state where over 90% of the people incarcerated are going to be returning back to the community at some point in time. So the goal should be to make sure that they are rehabilitated, that, you know, they do have an attitude adjustment, as was stated, and that they're ready to come back to the community. What I wanted to point out was starting on line 3, lines 3 and 4, it says the value to the prisoner's rehabilitation, which are not covered under paragraph A through. And the reason, I'm sorry, line 3, starting with that the commissioner deems to be valuable to the prisoner's rehabilitation, which are not covered. The reason why that's there is this is a person's personal journey. As someone who's been sentenced to the Department of Corrections, and I went through that whole process and came back to the community rehabilitated, I can assure you that a person's journey to rehabilitation is unique, it's personal, and sometimes people achieve that milestone of being rehabilitated through non-traditional means. And this goes to Representative Bourdonnais' question earlier about the discretion of the commissioner, leaving that to the commissioner to determine these programs. And it is actually necessary because there is not just one cookie cutter mold for every individual who goes through the Department of Corrections to achieve their rehabilitation. And the individuals who know the best of whether or not someone is rehabilitated is going to be those that work in the Department of Corrections, who are around the residents 24/7. So I think that further restricting and limiting the incentives for people to take control of their life and engage in programs or activities that are going to actually change them, I think presents a dangerous concern that I think that we need to take a look at. One of the things I do want to acknowledge is the fact that, yes, the victims advocate groups are correct about the re-traumatization that can happen through notices. I do want to give them that credence. It is something that I recognize and I respect. One of the things that I wanted to talk about on that vein is the fact that when an individual is rehabilitated, they are no longer the individual who created or did the offense. Physically they may be, but mentally they are not the same person. And that is the shift that we're looking for. We're looking for a mental shift, because that is what determines whether or not a person is going to be rehabilitated. We heard that crime has been decreasing in the state, and crime decreasing in the state means that people who are going back to the community are not re-victimizing people. That, earlier today we heard about re-victimization and the problem that presents to the state. And so when we're hearing that there are people that are leaving the Department of Corrections who are not re-victimizing people, we need to embrace that approach and see what are they doing that we can continue and replicate that process so that, we keep those numbers going up. The other issue that I think of why this bill is dangerous to limit the earned time credit opportunities is the prison itself is actually limited to the environment that it's at to offer earned time credit opportunities. So the prison currently doesn't have Wi-Fi in the prison, right? So if there was a program, every member of this committee could come up with a program that everyone agreed with. Let's just say all 24 members, agreed on a program. If that program can only be delivered on Wi-Fi and it's the most rehabilitative program, it's not currently going to be able to be rolled out in the prison. They don't have that ability. So they are limited to the individuals that volunteer for the programs, that are hired to do the programs, and what technological advances or, capacities they have in order to roll out programs. So the tablet system was a step in that direction, because every resident who is incarcerated has access to a tablet system. And so what that means is that every resident does have the ability to meaningfully engage in the programs that are offered on the tablet system. And I do agree that, whether if this is about having a structure in place for the programs that are there, as opposed to limiting the time, I think that then that should be explored. But to actually just limit the time across the board, that is very harmful. And I use myself as an example of this language specifically. When it talks about limiting A through E, I myself, when I was sentenced to the Department of Corrections, I didn't have kids, so I was not able to do the Family Connection program. I didn't have any mental health issues. I was not allowed to do any of the mental health programs for earned time credit. I already had my high school diploma when I was sentenced to prison, which means that I wasn't able to engage in the GED or high set. I had to buy my earned time credit through the college program, and not every residence has those economic means where they're able to purchase the college programs. And for someone that's incarcerated, that can be expensive. So I think that this bill right here would have specifically applied to me, where I would have been just barred across the board from the earned time that the prison offered, and I think that's an issue. One of the other things too is that at the time of sentencing, a judge and a county prosecutor are aware of the earned time credit provisions offered at the DOC. That is a determination that they make at the time of sentencing. The county attorney will usually meet with the defense lawyer and the judge, and they will say, well, this individual should be eligible for earned time credit, or no, this individual shouldn't. And that right then and there is, if they're eligible for earned time credit at the time of sentencing, it would be safe to assume, hypothetically then, that individual would be able to earn up to 21 months off of their time, and it's going to be through a repeated process. There is not one avenue in the prison to earn 21 months of earned time credit. You have to do multiple things. And I think that when we take a look at society as a whole, we do see many systems where you do have a reward system that's in conjunction with achievements, where a person can keep doing achievements and continue to be rewarded for that. I think that saying that an individual doing a program 10 times, if they're doing 10 separate programs, you don't know what impact that will have on that individual. It may be a program that shifts that person's thinking, that stops them from thinking about things in a criminal manner. And so I think that they should have that ability, and that should be rewarded when they are taking that conscious step to change their actions and change their life. And again, that is a determination after the courts and the county attorney has agreed to that. That's a determination that the Department of Corrections looks at. And I know that they deny people because I'm the one that gets the calls, is like, hey, can you sue the DOC? They won't give me my earned time credit. Well, why? What happened? Oh, I got a ticket. Well, I can't do anything about that if you got a ticket. And so it does happen. It's not just this free reign for people getting earned time credit. There are people that do get it denied. And one of the last things that I wanted to talk on was about the hours in the curriculum. It depends on what the specific program is. There is an accounting program that has multiple things underneath it that I think that Representative Muse was talking about. That you'll see those and you'll see multiple things, and that's why you get one certification. But there are some other programs that are very specific. They are geared towards one aspect, and that is why they're only under one thing. So that is that's what I would have to say on that. Another thing that this is not related to. It is related to the testimony that we heard today, and as someone who was referred to by the statements that were made, I do feel that I have a duty to say this because it was done in a public manner. But we have heard testimony today concerning this bill that I believe we need to be cautionary about, considering where it came from, and given that the fact that there was a public history of bias and racism towards the individuals that would be affected by this. And with that, I will end my testimony, and I'm happy to answer any questions that the committee may have.
Representative Newman.
For these earned time credit programs, can people take like 2 of them at the same time? Can it be taken in that manner, or do they do them one and then another one sequentially?
So that's a great question. You can take programs as long as you are accepted into the program. So if you take the Thinking for a Change program, for example, if this program offers earned time credit, if you're in Thinking for a Change while also currently enrolled in a mental health program, it is possible, yes, that you could get earned time credit for you would get earned time credit for both of them, and you could be enrolled in both of them at the same time. You could be enrolled in educational classes while also enrolled in a mental health class too, and be able to have earned time credit for both of them. But one thing that individuals do, and it's something that I advise people when they call and they ask, is that usually individuals will wait till they have amassed all of the earned time credit that they're either going to go for or that they can get, and then they put in for it at one time. And the reason why is because the wording of it is that it has to occur on the sentence that they are doing. So there is some people don't think that, well, if I have a consecutive sentence, if I parole to a second sentence, I'm not eligible to earn for my earned time, so they just want to do it on one time. And that may not be the case statutorily, but that is a philosophy that people have. So usually people will wait till they have gotten all their earned time, and then they'll put in for it all at once, which will then go to the commissioner if they have the box checked off on their minimus that allows for the DOC to award them earned time, and if they don't, then they will petition the courts.
Quick question.
Sure.
Did they have the tablet program while you were?
Yes.
And there being no Wi-Fi, how does it work? Did they upload the programs before they issued the tablets? How does that work?
So it's an intranet system that they came in and installed. The company came in, they installed routers directly onto the housing units itself, and then these routers they go out to the servers. The servers are hardlined to the internet, and that is, that's secure. That's kept securely. And so the tablets, while the tablets themselves use a Wi-Fi system, it's actually on an intranet. It's intranet, so anything that's on there is only you have access to.
Thank you very much. Thank you for your testimony.
The committee now calls Donna Sytek.
Thank you, Mr. Chairman, and members of the committee. I'm Donna Sytek. I'm from Salem, and I just finished 10 years on the parole board. I asked Representative Abbas to introduce a bill to call attention to some concerns that I had about the Earned Time Credit Program. The legislature has approved the awarding of time for earned time for against their minimum and maximum for certain programs. And I've given you a copy of the statute, and you can see the types of programs and how many days are that they'd be eligible for if they completed them. And I would remind you that the earned time credit is applied not only to their minimum, but also to their maximum. So the sentence is getting smaller from both ends. And you heard the victim advocate talk about travel restrictions that would, when we parole somebody, we sometimes will say you can't go to Nashua because the victim lives there. That only works during the period of their parole. And if their parole is shortened through the application of earned time credits, the victim is less protected. But last year, when I was still on the board, I noticed that inmates that we typically would see 2 months before their minimum were coming to a parole hearing with only weeks left to their minimum. And this was because they'd been awarded earned time credit under the new provision that was offered in paragraph F of the current law, and I've highlighted that. This paragraph F, the other programs, was new. Now, I'm not a stranger to the legislature. I followed legislation, and I said, where did this come from? And looking at my experience on the parole board, suddenly there's all this earned time credit. Indeed, the number of inmates receiving earned time credit in all of 2020 was 274. So 274 people got earned time credit in all of 2020. But in the first 9 months of 2021, it was 1,266, a 460% increase. So what the heck is going on? Because this was during the pandemic, and a lot of the traditional programs had been shut down. So where was all this earned time credit coming from? So I looked at it, and it was being awarded for these other programs under paragraph F. And I said, well, where did that come from? So I did a little digging, and I found out it was added as an amendment to an omnibus Senate ED&A bill that had 23 sections. This committee never saw this provision. It was thrown in, and nobody paid attention to it. So before this other programs provision was added, the legislature went through and evaluated each of the programs that would be eligible for earned time credit. And over the years, the list has grown. And as has been said, in the sentencing document, the judge specifies whether they be eligible for earned time credit. So the new provision gave the commissioner the authority to add programs that she deems valuable to an inmate's rehabilitation without coming back to you. I mean, that's a bit inefficient way to do it. But that's the reason I'm here for you today. I'm worried about one particular subset of the other programs. I'm worried about the programs that are completed on the tablet. All the inmates have access to a tablet, and they can watch a video selected from a list of available programs, and then they answer questions that are multiple choice, true or false. The prisoners have told us they can complete 3 or 4 programs in a day's time, and all of this is done independently. Nobody's watching them. We don't know whether they're cheating. There's no monitoring. There's no in-person group discussion like there would be for a mental health program or an educational program or a sex offender program where you have to go and actually do something other than work on your tablet. So I was concerned about that. And so on the back of this sheet is a transcript of somebody who completed some programs. And you can see from the dates that he would start it on, March 11th and finish it on March 11th and get 100%. And you go through all the programs that he did, and you can do it really quickly. So I would question the value of programs that can be awarded earned time credit without anything other than watching a video and answering true or false. I know that I do a Bible reading every day, and I probably forgot what I read yesterday, so something that you just read and don't have any conversation, any test other than a multiple choice, I just wonder. So all of this is to set up a policy question for you, the policymakers. Do you think it's appropriate to award the same 60-day sentence reduction for spending a day or two watching videos, the same amount as for like a 6-month mental health program, or a 9-month drug treatment program, or a sex offender program, or a hands-on apprenticeship program? The programs on the tablet are eligible for 60 days. Is that equivalent to these in-person programs that require your participation and engagement? So that's the policy question for you. Personally, I don't think they ought to get 60 days for the tablet programs. The rest of the programs under other are very valuable. One of them is moral recognition, moral reconation therapy. And that is a series of in-person programs, and the inmates rave about it, how it has really changed them. Maybe the legislature wants to specify which of these other programs should be eligible for 60 days. Maybe you want to look at the tablet programs and say, maybe they're not, maybe they're worth something. That is 60 days, maybe they're worth 30 days, maybe they're worth something other than that. I'm aware that the Department of Corrections is tightening up their process for documenting all the programs that are eligible for earned time credit, and that's a good thing. But the question for you is whether an afternoon of watching video should merit the same 60-day sentence reduction as a months-long in-person counseling or educational or vocational program. I don't think so. From my experience, the most I've ever seen an inmate awarded earned time credit, we had a woman who was in who took advantage of everything. She got 620 days. That's the most I've seen for any inmate, and that's unusual. We also have, the current members of the board told me about a recent parole hearing where the inmate had been, he was going on Social Security disability, so they asked, what's your disability? Well, I have a learning disability. Yet, he was awarded earned time credit for multiple tablet programs. So, if you've got a learning disability, how are you going to complete a program that you've got to watch a video and read the test? So we wonder about that. So I think this is something that is ripe for legislative review. Maybe you don't want to pass the bill as introduced, but I would hope that you would consider maybe listing the specific programs that you think are eligible for 30 days and decide whether you want to give the same amount for tablet programs. If you think that everything's fine, don't pass the bill. But if you think it requires some attention, I would encourage you to work with the department and figure out what should be eligible for what amount of earned time credit. So I'll take any questions.
Representative Newman.
Thank you, Mr. Chair, and thank you for taking my question. I owe an apology because this paper had been on my desk, and I thought you had already testified, and I asked the question, I was referring to this paper when I talked to Commissioner Hanks and asked about this particular question. So I'll ask you, I'm confused as to whether you're in favor of or against this bill, and because on the one hand you said you think that the paragraph is helpful, and on the other hand you said that this needs legislative review because this may not be appropriate to be counted as one of the things.
That's right. I think my preference would be to amend the bill to say, to add the the programs that are currently offered under other and specify them. Moral recognition therapy, choose love, thinking for a change, and say they'd be eligible for 6 months. And decide whether you want to include the programs that are on the tablet through the CRI, what is it, Corrections Research Institute? I forget what it is.
Corrections Rehabilitation
Institute, yeah. So, I mean, that's one way you could approach it.
Follow up.
So I just want to make sure I understand your answer, that if we fix these tablet programs and evaluate them correctly, and if they have merit, that they should fall in with other programs.
Mhm.
But you would be opposed to the bill as currently written, where it only says there is a one-time use, and I think that means all of the programs. So for
Yeah,
other,
no,
you would only.
there are a lot of programs that are currently offered under other that are worth it. I think if they take moral recognition therapy and they do thinking for a change or choose love, they ought to be eligible for the 60 days for each of those programs. It's only the tablet programs that I'm concerned about.
Thank you.
Representative Muse.
Thank you for taking my question. My question, I'm a little confused in some ways, because tablets and online learning have become extremely common outside of prison settings. So virtually every college I know of offers online colleges now, online courses. Some colleges only offer online courses. Is your issue with the fact that these courses are on a tablet and they're not in an actual classroom, or is it more with the content?
My concern is that there isn't any interaction with an instructor. A lot of these are some of them are for mental health. I mean, where it would be good to have a group discussion. It's not like learning accounting. And I believe that the online courses, you can talk to the instructor. I mean, you might have to type in your question, but there's interaction between the instructor and the student. On these tablet programs, there isn't that interaction. So if you have a question, you ask the guy in the next cell.
Follow up.
Follow up. Do you think that there is a trade-off? You know, for example, you're the Department of Corrections and you have a couple of thousand prisoners that you're basically trying to rehabilitate, but you only have so many teachers. You only have so many people who can lead these sessions. So my guess is that the tablet programs came about as a way to multiply, just to make more course material available to more people without the need to hire more instructors and teachers. So do you have a problem with doing that in general?
No, I don't have a problem with that at all.
So I'm still not understanding your objection to the program content itself.
Not the content, it's the interaction between the instructor and the student.
Okay.
Because I question the value of just reading something and doing a multiple choice test. It's not the way I learn.
Thank you.
Representative Schultz.
Thank you, Mr. Chair. It's great to see you here. I'm a sub from Concord, Representative Schultz, so apologize, I'm not usually on the committee. But two quick things. One, I've never come out about this as a legislator or in public in general, but I have a learning disability. And it is amazing what the technology provides if you have a learning disability. All these advances with online classes have been amazing. And I think I must also be slightly dyslexic, because you can now choose a font specific for dyslexia. Did you know that these advancements existed? Because had you heard that? And then a quick follow-up.
I know that there's a lot that's available online and that are tailored to people's style of learning. I don't know whether these programs are so tailored.
Yeah, they're great on the Kindle for whatever it's worth. And also, I had tried a class on edX, ED, I think hyphen the letter X, where a number of these courses are online. Have you looked at any of the course materials or any of the course content on your own? Because
No,
I was shocked at how cool
Yeah,
it was.
we asked for access to some of
Okay.
these programs, and it was not available to us.
Oh, that's too
I
bad.
looked online to one of the original programs, the Peace Education Program, and I looked online for that, and it's, been used all over the world. This is a wonderful thing, and the examples they give online about this program are for in-person delivery of the program.
Interesting.
Representative Suneman.
Thank you. Thank you for taking this question. For the History 3, looks like economics and financial literacy, do you have, what grade level do you think they would be?
I don't know. I believe that most of the programs are done at like the was it 5th or 6th grade level?
Yes.
Those courses you just referenced actually were pushed by our high school educators through the Granite State High School using their learning management system.
Thank you. And quick follow-up, are these all, if people are using tablets, do they have an option to use a language other than English?
I don't know.
Okay.
The answer is yes.
Okay. Thank you.
Seeing no further questions, thank you for your testimony. Is there anyone in the audience wishing to testify who has not signed up to testify on this bill? There seeing none, I hereby close the public hearing. And I am now opening the public hearing on HB 1512. Yeah, if you could. Was anyone else supposed to do it?
Anybody speaking on this? Yep. Oh, there is? The committee now recognizes Representative Robert Theberge.
Thank you, committee members. I'd like to introduce House Bill 1512-FN, a bill relative to the parole of certain prisoners. That being said, may I, Acting Chairman, Representative Roy, may I address the committee regarding my comments on this bill that I'm in favor of?
The floor is yours.
Okay, thank you very, very much. For the record, my name is Robert Theberge, representative from COAS District 3, the city of Berlin. As you well are aware, the Northern New Hampshire Correctional Facility is located in Berlin. When it first opened up, I was the mayor of the city and served on the first public advisory committee. Ever since then, I've been working with our veterans. And the reason I'm here today is to address the bill in advocating for our veterans. Those of you who have served are very familiar with post-traumatic stress disorder. I, for one, am very familiar with it. And the reason I bring that up is that I have had friends, as a Vietnam War vet, have returned to the States, have committed suicide, have caused problems with their family members. I've had children have asked, what's wrong with my father? I've had wives ask, I can't recognize my husband anymore. And there are situations where something triggers a returning veteran with PSTD that causes, a criminal offense. That being said, I'm advocating for the veterans because this bill, I think, if looking at what the variable should be, I think PTSD should weigh very, very heavily, followed by if they're a model inmate, as well as letters of support from the correctional officers and the warden of the prison. I think it's, and that's why I'm in support of the bill. It's really advocating for the veterans, but for all people. The situation back then, 25, 30, 40 years ago, very little was known about post-traumatic stress disorder. I am not faulting the courts at all. Given what they had before them, I think they did the things correctly. What has come to light is what has followed up in the information we know about PTSD. So this bill will look at an inmate's request for reevaluation of his parole, and given those variables weighted correctly, and particularly with PTSD, may come out with a different outcome. Now, there is a cost associated with this, but then I asked the committee, how do you weigh this? I mean, is it something that, for somebody to be released into freedom, do we weigh our compassion? I'm not saying that it's injustice, but I think the committee should realize that there are certain things, given the amount of time that has elapsed, we can look at the situation very objectively. We have all been subjected to, over the years, those of us with white hair, that you may have been in favor of something 20, 30 years ago, but when new information comes to light, your opinion has changed. So that's what I'm advocating for regarding this bill. Different facts and opinions may come to light to benefit the inmate who is asking for parole. Thank you. I will entertain any questions, but my responses will be only in French, seeing that I'm from a French city.
I have a question.
Representative Testerman, en français, s'il vous plaît.
Okay, merci. Avec plaisir.
Two questions. Number one, we're talking about 1512, which is is looking for an earlier, another parole look at it. Is that correct?
Yes, that is correct.
Okay, I was trying to get PTSD in this.
Well, no, I'm asking that when we're looking at this, that the parole, I guess, committee or people take that into consideration as a very important factor in looking at whether or not the inmate should be paroled or not.
Okay, one last question. There's one. Where'd you come from? Okay. It says in here that it'd be good to have a parole hearing on anybody who has over 25 years. Is that just sort of a blanket? We're going to review everybody that has 25 years of incarceration?
Well, that's why I mentioned that there has to be certain factors or criteria, that the inmate has to be a modeled inmate, that they have letters of support by correctional officers, as well as from the warden. So not all inmates who have been there for 25, 30 years or more would qualify under those variables.
Thank you.
Representative Lynn?
Just a question, but am I understanding I understand that might be your intent, but the bill as it's drafted doesn't say that. It just says anybody that has 25 years.
No, I realize that, and I believe that a committee amendment may be in order if the committee chooses to do so.
Thank you.
Okay.
Just a point of order, the representative is introducing the bill. He's not a prime or a co-sponsor, so be gentle with him, please.
It's all right. I've been here 22 years. I can take it, trust me. but I could dish it back too. Thank you. Representative Connolly, you had a question?
It was more a question of the chair.
Oh, okay. Thank you.
You're recognized for a parliamentary inquiry.
Thank you, Mr. Chairman. Could we get a very basic two-sentence explanation of what this bill would do? Because my read on this, of what this bill would do, has not yet been discussed by anyone.
Well, first of all, that's not a parliamentary inquiry. But I guess you're asking me to explain the bill. What I would want to do is let the members of the public speak. The bill's been introduced. The prime sponsor's not here. Representative's obviously filing on his or introduced on his behalf. I would just let the testimony come out, and then I'll offer an explanation after or during the executive session.
May I ask a follow-up?
Of your parliamentary inquiry?
Of the chair?
Yes.
My understanding of this bill is it would do away with the sentence of life without parole. Is that not correct?
That's my understanding in a short Cliff Notes version of it.
Thank you. It's just good for everyone to know what we're talking about before we ask questions and so on. So I thank you for the indulgence.
Okay.
Recognized for a question of the witness.
Okay, here's a dumb question.
Oh,
Maybe this will
sorry.
help. Hi. It reminds me of what I hear of, and am I right in this? This bill reminds me of what I hear in other countries, that sometimes a famous prisoner will be released because they're really old or sick. I remember that especially of the Lockerbie bombing. The gentleman who was convicted of the bombing was released because he had a serious cancer or something like that. I mean, is that really... Does that seem to be the intent of this, is sort of compassionate release?
Thank you. Oh, sorry. Thank you for the question. No, I don't believe that this bill addresses that issue. If there's a medical condition that's very severe, and correct me if I'm wrong, Commissioner, there is a procedure for allowing them to be released. Is there not? Yeah. Sorry, Mr. Chairman, I asked.
We'll just, this happens when it gets late in the day.
Okay.
When the witness is done with his testimony answering questions, if the question's asked and it's no, it doesn't mean the person they don't get the answer, they don't need it. And that member of the public is signed up to speak, so.
Yeah, I'm sorry, Representative, do you have a follow-up, or?
That was, what you said was helpful.
Okay.
I think I
No,
had an irrelevant tangent, sorry.
Okay. Well, for a segue with that, I mean, I worked 17 years in Africa, and I'm very familiar with prisons overseas. Believe me, the way we treat our inmates here is unbelievably well. They're well fed, taken care of, and whatnot. I had friends that I had to go take out of Kitty prison in Lagos, and that was not a nice scene. If you're in prison there, you're dependent on your someone to bring you food, clothing, shelter, everything, because they do not take care of you. So I really admire our prison system here and the way that we treat our inmates.
Seeing no hands raised, I want to thank you for your testimony. The witness is excused.
The committee calls Jeff Streslin, Attorney General's office.
And just before the witness begins, for members of the public testifying, we're going to limit testimony to 3 minutes per witness.
Thank you. Good afternoon again. My name is Jeff Streslin. I'm Attorney General's office. Our office opposes this bill for several reasons, and I'll explain why. First, the beginning of the bill contains several claims that are offered to justify the passage of the bill. I didn't look in detail at every single one of these, but I did look at one to see how applicable it is to New Hampshire, because when you look at the preamble to the bill, it looks like most of these claims are really not applicable to New Hampshire. One of the claims was that many inmates are serving extended prison sentences due to mass incarceration. I checked and confirmed that New Hampshire's prison population has actually dropped each year since 2017. In addition, I found a news article from 2018 that cited inmate statistics that showed that New Hampshire had one of the lowest incarceration rates in the country, and it was actually going lower at that time. And I confirmed with the Department of Corrections it's actually dropped every year since then. The article also revealed that New Hampshire's incarceration rate was half the national average. So based on the actual inmate numbers from New Hampshire, we do not have a problem with mass incarceration, which would justify what this bill proposes, which is releasing violent offenders from prison early. The second issue with the bill is that it cannot achieve its stated purpose, which is having the parole board review the validity of convictions and sentences. And that's because you'll hear from other witnesses, but the parole board does not have the authority or capability to investigate those types of claims. It's not within their purview. Instead, inmates already have a variety of avenues to contest their claims, to contest their innocence, to contest their sentences, and that ranges from having appointed counsel, the ability to file motions to dismiss, motions for new trial, the appeals process, sentence review, and state and federal habeas corpus petitions. So there exists a system outside of the Department of Corrections to address the issues that are raised in this bill. Another issue that the bill doesn't account for is the fact that the majority of defendants plead guilty to their crimes and agree to incarceration. So this bill would undo all that for violent offenders, including murderers and people who committed sexual assaults, even though they pled guilty, admitted their crimes, and agreed to be incarcerated at the state prison. This bill would undo that and allow them to essentially leave prison early. So again, these are not people for whom innocence or their sentences were an issue. They agreed to those. And again, that would be obviously unfair to those victims' family members, the victims themselves, and the communities involved. The reality is that this bill targets a certain class of inmates, and those are inmates serving sentences of at least 25 years or more. Those make up some of the worst in this state as far as offenders. They include criminals who've murdered and raped their victims, including children. Some of those people who are serving those sentences have killed multiple people, raped multiple people, and are serving consecutive sentences for each victim. So we have double and triple murderers in this state, double and triple rapists in this state. They get a sentence for each victim. So they may have 3 consecutive 25-year sentences. This bill would undo that and say after they've only served one of those sentences for 25 years, they would be eligible for parole and could walk out of prison. That's obviously not fair to any of those victims involved. Each victim counts. This bill would also allow criminals who are serving sentences to get out early, no matter how many victims they've victimized and no matter how many crimes they've committed. Again, we have some people in prison who've committed multiple serious offenses and received multiple consecutive sentences. This bill would undo that and let them simply walk out the door early. Again, not fair to those victims or their families. And finally, as I think was noted earlier by another representative, this bill would be in conflict with existing sentencing laws regarding murderers and people who commit multiple sexual assaults. For example, this bill would undo the sentences for all first-degree murderers. So instead, people who've committed murders during a sexual assault, who've committed home invasions and committed murders, and people who've committed multiple sexual assaults, those people normally be subject to life without parole sentences. This bill would undo that, and instead they'd be able to leave prison early. We also have a law in New Hampshire that says that people who murder children, children under the age of 13, have to serve a mandatory minimum of 35 years in prison before they're eligible for parole. This bill would undo that as well. And finally, this bill would be in conflict with existing law that requires offenders who've committed multiple aggravated felonious sexual assaults against children. Those offenders are required to serve life prison sentences. This bill would undo that and let them leave prison early at 25 years. So those are all the reasons that we oppose this bill. I'd just like to comment on one thing regarding PTSD. PTSD is a potential defense that a defendant could raise if they're charged with a crime. That is best dealt with at the time they are charged with a crime in court. That's not something that the parole board has the ability to explore or investigate at the time of parole. That is something that a defendant could and would potentially raise at the time of their trial, and they have lots of avenues to do that at the time of their trial if they choose to do so. That's everything I have to say. I'd be happy to answer any questions that there are, though.
Representative True.
Thank you, Mr. Chair, and thank you for taking my question. You said something about the bill as written, gives the parole board some authority that they don't have to look at a guilty sentence?
That's correct.
But where do you see that from line 27? Where do you see that
In
that
the
the bill is instructing them to do that? I'm reading it, it just says, shall grant a parole. Hearing.
The bill is intended to address people who've been overcharged, wrongly convicted, or over-sentenced. That's paragraph 10 of the preamble. And so what that says is that that's what the parole hearing is going to be about, to correct that. And the parole board has no ability or authority to address those types of claims. So those claims are all addressed prior to an individual being convicted. So that's paragraph 10 in the preamble.
Thank you.
You're welcome.
Representative True, you have a follow-up question?
Question of the chair?
You have a parliamentary inquiry?
Yes. Am I correct in assuming, Mr. Chair, that lines 27 through 30, or whatever it is, that's the bill? And the findings have nothing to do with what we vote on?
Well, it's kind of a parliamentary inquiry. I think I'm just gonna, that's a question we can discuss during the executive session. Members of the testimony, members of the public can testify and speak freely, and we're not really gonna debate whether we debate them. We agree with their interpretation or not. We encourage everyone to testify, and we'll leave it at that.
Thank you.
I would say that as I read the bill, those findings in the beginning are essentially the reasons why the bill should pass, that 1 through 10. And so that's why I made the comment I did.
Representative Roy?
Thank you. There are avenues available through the courts to address wrongs such as excessive sentencing and things of the nature that are brought up. Is that not true, that people could petition for a rehearing on that?
There are lots of different avenues. I mean, originally a defendant would have a sentencing hearing where they would be represented by counsel and have the ability just to contest the sentence up front. They can file motions for reconsideration. And for Superior Court of felony sentences, a defendant has the right to go to what's called the Sentence Review Board, which is a 3-judge panel, and essentially have a re-review of their sentence as well. They have other ways to contest it along the road, including habeas petitions in the state and federal court. So there are lots of other avenues to contest that.
My follow-up question is kind of tied to Representative True's and your colloquy a few seconds ago. Does the court look at the preamble? Because does the court not try to find out legislative intent when they interpret a bill?
Courts will typically look at legislative intent if there's an ambiguity. And certainly if the parties disagree about the meaning of a statute, it's not uncommon for the parties to cite legislative history, especially because the preamble here says that the general court finds and then lists those paragraphs after. So those would be important considerations if there was a dispute about what the terms of that statute meant. But in fairness, the statute's pretty clear, which says that no matter what somebody does, no matter what crimes they commit, no matter how many victims, they're eligible to walk out the door at 25 years.
Thank you.
Seeing no hands raised, I want to thank the witness for his testimony. The witness is excused.
Thank you for listening. I appreciate it.
The committee now calls Jennifer Sargent, New Hampshire Adult Parole Board.
Good afternoon, Mr. Chairman, honorable members of the committee. I'm Jennifer Sargent. I am the chairman of the New Hampshire Adult Parole Board. I speak in opposition to this bill on behalf of the New Hampshire Adult Parole Board. What I believe this bill is doing, what the board believes this bill is doing, is violating the separation of powers and also serving as an end run around sentencing reform. And that is because what this bill asks the parole board to do is to move the minimum mandatory parole date, which is established by a court. It is the authority of the court to determine in an indeterminate sentencing state such as New Hampshire the minimum to be served and the maximum to be served. The minimum to be served is the minimum parole date. The judge imposes that date, so that the parole board, if asked to hear somebody at 25 years when their minimum parole date was either non-existent in the cases of life without parole or was farther out than 25 years, would actually be altering a judge's sentence. That is a matter for sentence reform. That is a matter for sentencing laws to be redrawn for penalties for particular offenses. The New Hampshire Adult Parole Board does not have as an executive branch, as part of the executive branch, the power to move a minimum mandatory parole date. That is done by not only a judge's date, but then something like earned time credit, where some trigger, some award, some substantial participation in a program allows them to work off portions of their sentence to change their minimum mandatory date. This would also require, practically, as Attorney General Strelzin argued, parole hearings for extremely institutionalized individuals who will not have the opportunity to engage in much programming before getting out, because a lot of the programming is geared towards somebody who is going to parole very soon, because you want the programs to be finished in a timely manner so that they can continue with that on the street. Someone who's engaging in programming a year or 2 or 3 or 7.5 years is in a very different position than someone who has already served 25 years, who is then engaging in programming. The amount of material that the parole board would also have to pull together, read, and review would be extensive. It would be years, it would be all of the information that went into the case itself. There would be many victims who would present themselves. However, we would not, as a board, have all of the input from the members who engaged in the prosecution like a judge would do at a sentencing hearing. I am also a former district court judge, now the circuit court, but at the time I served as a district court judge, it was the district court. I was in Lancaster, Littleton, and Haverhill. Those were my courts, and I circuited around the state of New Hampshire. And I can tell you what goes into a sentence, be it a House of Correction sentence or a felony sentence to prison. I can tell you that the work that a judge must do to figure out all of the factors, general deterrence, specific deterrence, victim implications, how likely the person is to rehabilitate, all of the things that a judge considers, the parole board would not have in front of it. It would have to be a significant retrial, basically, to determine whether or not the person should get out at 25 years. And most of the applications under the current criteria for parole, which are in the PAR administrative rules, would not be met. I would ask that the committee find this bill inexpedient to legislate, and I will receive any questions that you would want to ask me.
Seeing no hands raised, I want to thank the witness for her testimony.
Thank you.
The witness is excused.
We now call Helen Hanks.
Really wish I had food or something to give all of you. Sorry.
I was thinking the same thing.
Good afternoon. For the record, Helen Hanks, Commissioner of the Department of Corrections. Just a affirmation, yes, the prison population actually has been on a decline since 2011. I'll send that to the committee. It's, I think, a very good statistic for the state of New Hampshire. We're 38% down in our population rate. That's good for corrections because our staffing hasn't gone up yet. And we're almost to the actually design capacity from circa 1980, whatever, for the men's prison. Sorry. So with that said, lines 27 and so on, where it references the commissioner shall grant a parole hearing and the commissioner shall schedule a hearing, the commissioner of correction has no authority over the adult parole board. It's fundamentally flawed. So you could compel me to compel them to have a hearing, but they could just simply tell me no. So for those purposes, I think it's not well articulated bill at this point because it confuses and creates authority where authority doesn't exist for the position of commissioner. And just a point of clarification, people who are incarcerated with these lengths of sentences do have steady access to treatment interventions, education, and programming. They don't have to wait for those. I just want to make sure the committee knows that. I do appreciate the information shared by the chair of the Adult Parole Board. With that, I'm going to keep this testimony short and answer any questions you may have for me.
Representative Bourdonnais.
Thank you, Chair. Thank you for taking my question. Actually, I have two, but we'll see where the first one goes. Do you ever see people that have sentenced to long prison terms make drastic changes in their behavior so that they might be, when they come in, a murderer and a dastardly murderer at that? By the time 25 years has passed, they become quite different and maybe even reformed?
Commissioner Bourdonnais, I would say that the answer to the question is we see people who come in with sentences of multiple lengths who make rehabilitation and reform, and we see people who do not. So I see it in many other cases.
Follow-up?
You're recognized for a follow-up.
Thank you. Clearly, you've shown us that the bill is poorly worded. Is it possible we could make it more acceptable and possible to implement?
Representative Bourdonnais, I would leave that to the fine determination of this committee. Again, as the Commissioner of Corrections, I will leave sentencing and everything pre-incarceration to the legislature and the judiciary.
Thank you.
You're welcome.
Seeing no hands raised, I want to thank the witness for her testimony.
Thank you,
Witness is
everyone.
excused.
The committee now calls Jean Fye.
Thank you for allowing me to testify, as I am now a Massachusetts resident instead of New Hampshire. And I would like to make a request if I could. Could you please tell your secretary that to tell me I only have 1 minute to speak is a little ineffective? My name is Joan
Testimony is
Fo-
limited to 3 minutes per
I'm
witness.
sorry?
Your testimony is limited to 3 minutes, not 1 minute. But we'll let you know when the time.
Okay. I'm a retired federal PTSD therapist from the Veterans Administration. I have worked with combat veterans for over 40 years, from all-American wars since World War II. I have known one particular one, Gary Place, who is currently an inmate at the Berlin Correctional Facility since 1984. He is doing time for first-degree life without parole. Gary is a Marine veteran who served in Vietnam and was stationed in Khe Sanh during the 4-month siege of one of the longest and most violent battles of the entire war, and was given numerous awards and an honorable discharge. And one of the things I always used to say to my clients is, just because you're a veteran doesn't mean that your experience is the same as someone else's. With Gary's experience, I compare it to a cousin of mine who was actually an attorney at the embassy in Saigon. who never saw any combat, so he came home without PTSD. That's not the case for Gary. When his trial was covered by the media back in 1983, PTSD was a contributing issue, but most people didn't know very much about PTSD. Things have changed considerably since that time. PTSD now is known to be linked to numerous causes, not just combat, and it is much better understood. You asked a question earlier about had she ever had any experience with people. I had two veterans down in Massachusetts who were World War II veterans who had the very same experience, and they were let out at the age of 70 because they both had serious health issues. And until the time that they died, they were exemplary citizens. Gary immediately, which doesn't happen very often, took responsibility for his actions and turned himself into the police even before it was realized that a crime had been committed. Since 1983, he has worked on his issues relentlessly. And when the bill was up for passing a year ago, he was highly recommended for conditional pardon, even by his former prosecuting attorney. He has incredible support from his family members, friends, former employers, the victim's family. He has completed any and all available treatment programs within the prison, as well as some of those that he could do via mail. He is currently an inspiration in particular to other incarcerated veterans, and there are more than you realize. And he works now as a facilitator for various therapy groups in the prison. I know, I understand this bill was meant for any and all individuals who have served at least 25 years, with a few exceptions, and I think that was the last sentence in the bill. It is important, however, that each inmate seeking a conditional pardon be independently scrutinized and judged based on their own individual accomplishments and behavior. That's my 1 minute.
Representative Bourdonnais, you're recognized.
Thank you, Chair. Thank you for taking my question. Can you repeat your name?
Oh, my name is Joan Fye, F-Y-E.
Thank you.
That's it.
Representative Newman, Representative Sue Newman.
Yes, thank you. There was an executive council hearing that Mr. Place had.
Yes, there was. No, I don't think it actually went to hearing. I think it was a proposal and it got turned down.
Will there be another opportunity for the executive council to
That I don't
revisit
know. I'm
this?
sorry, I'm not a lawyer. I don't know.
Thank you.
See no hands raised. I want to thank the witness for her testimony. The
Thank you.
witness is excused.
The committee calls Russell Roy.
Thank you, Mr. Excuse me. Thank you, Mr. Chairman, committee members. I'm a little hoarse here. My name is Russell Roy. I live in Manchester, and I'm here representing myself. I'm not a member of any group or organization. One thing that I learned sitting back here for the past few hours is that you folks really earn your $100, I'll tell you. So thank you for your service. I appreciate all the work that you do. I'm here today to register my support for House Bill 1512. And I say that notwithstanding the points raised earlier about the problems with the wording in this bill. I have to say, with all due respect to the authors of the bill, that I winced a little bit when I saw the references to people who had been falsely accused of crimes and are serving sentences. This bill, even though that was used to bolster the arguments for support of this bill by the authors, it's misplaced. And so I agree with the previous folks that spoke against that. But I don't think that washes away forget the argument, that particular argument. It doesn't wash away the intent of this bill, which is to offer some redress to folks who have are serving extreme sentences. One thing which is clear to me is that lengthy sentencing that we've engaged in since the 70s has not made us safer. If that were true, the U.S. today would be the safest society. We incarcerate more people in this country since any time in recorded history. But yet, we still face violence in our society. More than 3,000 young people are murdered by their 25th birthday. 57,000 children survive sexual violence. 500,000 women are victims. There's plenty of violence in our society, but long sentences are not making us safer. I'm here today as you sit in consideration of this bill to ask your indulgence in taking a more nuanced approach than we have previously brought to bear. This bill seeks to provide some means of redress to those serving extreme sentences. Yes, people who have committed the most serious sorts of violence, those serving life without parole. This bill is about how we talk about and how we treat people who cause great harm and begin to unwind an unsustainable and unwise policy of extreme sentencing. We heard today before some of the previous testimony talked about the fact that Commissioner Hanks is doing an excellent job, that we've been cited, the state of New Hampshire has been cited by U.S. News and World Report as one of the preeminent corrections facilities or systems in the country. And that is all to be applauded. And it's good to know that our incarceration rates are going down. But that's not reason enough, I think, to abandon this bill or the people that it would seek to serve. I'll provide you with some copies of testimony, but I want to bring your attention to an open letter dated April of 2021 and signed by 64 attorney generals from across the country. This is not just people from New York and Massachusetts, but states like Texas and Florida and everywhere in between. And in this open letter, they address the notion of past extreme sentencing. So Ms. Sargent alluded to the notion about well, what can we do to correct the law? We can't rewrite the sentencing here. This is not about sentencing reform. This is asking for redress for people who are already sentenced to life without parole. Just to quote briefly from this open letter, which I'll provide you a copy with so you can see it in context, but they say, although the role of incarceration is primarily to protect public safety, our criminal justice system has few mechanisms to ensure that only those who still pose a serious safety risk remain behind bars. And it goes on. The tough on crime appellation is the sole propriety of no one. All of us, with leanings on both sides of the reform issue, need to feel safe in our homes and our neighborhoods. No one wants to feel threatened. But I know of no one that says that we shouldn't be prosecuting these people when crimes, particularly violent crimes, are committed. we all need to feel safe, and that prosecution has to happen. My intent is not to engage in excuse-making on behalf of the incarcerated. Ultimately, each of us is responsible for our own actions, regardless of the circumstances. It is, however, important to recognize that violence occurs within a context, and that understanding that context is a piece of the puzzle in ending it.
Excuse
Some
me,
people,
I,
yes.
I do have to limit I did limit testimony to 3 minutes. I want to say that you're close to doubling that time.
I'm
So
sorry.
I do need to ask you to wrap up the testimony.
Okay. Well, it's tough here. Okay. Well, you know, let me just conclude by saying, you know, a lot of times when the legislations of this sort come up, our thoughts go to the victims, and I want to speak in support of victims as well. The truth is that most survivors don't live in the space between totally angry and totally forgiving. They live someplace in the middle, and that allows for people that could be offered this opportunity for parole not to have mercy, but to be accountable, to in accepting responsibility for the harm they've caused, and acknowledging that to the victims, engaging in actions to correct that, and making personal transformation to demonstrate their commitment to that.
Thank you for your testimony. I do have to ask you to conclude.
I appreciate that. I'm
Thank you.
sorry. I'll take any questions you might have.
Seeing no hands raised, I want to thank the member for his testimony. The witness is excused. Any members of the public who wish to testify? They have not testified already? Seeing no one, this time we'll now close the public hearing on House Bill 1512. The members of the committee, we will be executing some bills. HB 1540 will be the first one up. It is an early deadline bill. That early deadline is tomorrow, and we have nothing scheduled between now and tomorrow. Just a hint, there will be more than that one.
Always our judge. I really appreciate your testimony. Is there a legal way to go that? You now you're going to say we're have to adjust the sentence to right. I mean, you could talk I will. Yeah. He may have an idea. I don't have an idea of how that can be done without accepting. I'll let you know. Very good. All right. Thanks for your work on that.
At this time, we're now going to open the executive session on House Bill 1540. All right, when the executive session is now open, Representative Welch, it was just gracefully handed an amendment. It's 2022-0616H. I'm not recognizing anyone to make a motion, so please don't yell anything. I'm just asking, is this amendment, does this rewrite the whole bill, or is it inserted into the original bill?
No, this is, I guess in a sense it does rewrite it. But initially, the reason this amendment was drafted today was to satisfy a conversation between Representative Lynn and Buzz Scher. And the agreeable, and it was to, it's on line 3. Custodial interrogation means express questioning associated with a formal arrest or restraint on freedom that is the functional equivalent of an arrest, or other actions or words by a law enforcement officer which are reasonably likely to elicit an incriminating response from an individual, and occurs when reasonable individuals in the same circumstances would consider themselves in custody. My understanding was that after the discussion between Representative Lynn and Buzz Scher, that they were agreeable that that satisfied. Well, that makes two of us.
Mr. Chairman,
Representative Pantelakis?
is this not already being done in our police stations within the state?
Well, I don't want to speak for every single police station, but my understanding that the overwhelming majority of police officers, they will at least audio record an interview, if not actually record it through a video. It's being done. What this would do is basically set up, it would make it a mandate, an unfunded mandate, for what it may look like, but a mandate no less. At the very least would downshift the cost to the counties and towns. But in any event, if it's not followed, if for some reason whatever they didn't follow, didn't record it, it wouldn't be admissible, and neither would any of the fruits of the poisonous tree. So that's what this would do. Some states have to take a different approach. Some states have, when they give the jury instruction, they would just simply point out to the jury, by the way, when this confession was made, this interrogation was done, it was not recorded when it's the policy of the police department is to record it.
Well, my question is, what is going to be done if the departments do not do this?
My understanding is that if they don't follow the procedure correctly as it relates to custodial interrogations, that any information, evidence, confession that was gained through that custodial interrogation would not be admissible.
Thank you.
Representative Sue Newman.
Yes, this is your discussion time, correct, on this one?
Yes.
There's
no motion. There's no motion recognized. We were just handed an amendment,
Yeah.
but we have to exec this bill today. And
I was pretty taken with the testimony of Cynthia Musso, New Hampshire Innocence Project, and her comment that a third of confessions have been determined to be false confessions. I said to her during the break between the next hearing that there was just something this past week on public radio that I heard, and it was a young person. I don't remember if it was a young man or a woman, but they were, 17 years old, and after hours of interrogation, they had an audio of it. They finally got him to say he killed somebody when he actually didn't, and the person spent years, over 10 years in prison. So I thought that was just interesting with the whole thing, that if it's recorded, you've got something.
so I appreciate listen, if you're a police officer, it makes your job a lot easier to record these an interrogation, because then it's all documented. False confession aside, whether it is or not, this is a policy of whether they should be recorded or not, making that mandatory. I think whether they're recorded or not, you still can have the issues of false confessions. So, just my opinion. Does anyone else wish to offer any comment? Representative True.
Yes, thank you, Mr. Chair. I am still looking at a 28A issue, which is not a small issue in my book. It is a constitutional issue that we cannot downshift. I've heard explanations on why downshifting really isn't downshifting. I've never understood those. But I see this as a 28A. I don't see how I can vote for something that is a 28A issue. Thank you.
Representative Roy.
Thank you. I would tend to agree with my colleague if it specified the manner or machinery or storage that had to be used. As has been pointed out, every police department in the state has got some type of recording device, from a phone to a pocket recorder. They're used in wiring. They're commonly used in police work. It's not something that they would not have access to or would not be able to obtain very, very reasonably. Storage is a thumb drive. If we could make it better so that there would be a statewide database where they could share with the state police, I think that would be great, but that's not before us. But I just think it keeps everybody honest. I like the bill. It makes the police do better police work. It protects the individual, and it's good for the system. So, as I said, since I don't see a mandate with regard to what type of equipment or how expensive they have to invest, theoretically they could spend $20 on one tape recorder and whatever it costs for the tapes, and it's so minimal as to not be impactful.
Representative True, do you wish to be recognized to make a motion? On the underlying bill.
I move House Bill, and stop calling me Mike. I move House Bill 1540 as ITL.
Is there a second?
Mr. Chairman, I second.
It has been seconded by Representative Marston. Representative Lynn.
I tend to agree with my colleague that I think this basically is a good bill. I don't really see the 28A issue. I mean, I think it's de minimis, because I suspect that as you say, every police department has some kind of ability to make a recording. The only as I said before, I think the custodial interrogation thing that the change would in the amendment would satisfy me. And I don't, hopefully all of you, but would satisfy me. The only other point that I would make is the section of the bill that talked about it could be, the person who's being interrogated could waive the requirement of recording, but that waiver either had to be in writing or on the recording itself. I do think that's a problem, because I think there are some, I've seen actually some circumstances, and I think it's not uncommon for somebody who doesn't want their recording to be, doesn't want their interrogation to be recorded, to say, I'm not signing anything and I don't want you even to record that I've said I don't want it to be recorded. They just don't want it recording. So I wonder if we could just end the sentence in which that appears in the bill to just, you know, put a period before you get to provided. That would be my suggestion. Other than that, I think it's a good bill.
Good luck getting an amendment to the bill at this. That's the problem we have. We're up against the deadline. But Representative Burt.
Thank you, Mr. Chairman, and to Representative Lynn, what I would argue with is I think everybody should just shut their mouth when they get arrested, but they don't. So with that said, if they're stroking about not wanting to be recorded, hopefully they have the mindset to say, you know what, I think I want my lawyer and I'm not going to speak. So I think that issue, if we leave it in there, is going to be taken care of by the people that will use that exercise, you know, the constitutional rights that they have to stay silent, which they should. I'm looking at the 28A issue, and Representative Roy, you know, almost said everything I was going to say, so I won't repeat it. So he is 100% accurate. Every police station has something to record. Absolutely they do. So there is not a 28A issue. That's why I put my name on this. That's why I support the bill. So I am the third vote here, and I'm going to be saying no to the ITL. Thank you, Mr. Chairman.
Representative Wallace.
Thank you, Mr. Chairman. I concur. This is although I understand your position, Representative True, but I don't know about Sandowns Police Station, but I know in our little town of Danville, our holding cell has got audio and video recording equipment, as does every PC manufacturer that's in our office. We can record with that. The Rockingham County Jail, the holding cells have video and audio recording already in place, and that stuff is monitored by the guards. It would just be a matter of sending that information to a file someplace in an already existing infrastructure and file storage system. So I don't see the downshifting of the costs, and I'm very conscientious of that, having trimmed 10% a year. Every year I've been the chairman of the Rockingham County Jail out of the budget, which I'll do again Friday. So that's my 2 cents worth.
One issue that comes up with this is once it's recorded, the police officer, I'm not saying they can't, they should not be just leaving it on their cell phone for their own cloud service. That it needs to go onto some type of protected database somewhere, similar to how with the body image cameras. So, the fact that every police officer presumably has a smartphone, we shouldn't rely on that officer to store it on their personal cloud. I'm just saying that it needs to be uniform. What I would say,
nor would that be appropriate.
No, it would not be.
We already have statutes that prohibit the distribution of a post-arrest photo. Do we not?
I wish we did. It didn't make it out of the other body. There would be chain of custody issues, supposedly. If a police officer recording their phone and whoever handled their phone, perceivably has now handled the video. I mean, if my son picks up my phone, I have to add his name to the list. I'm just saying these are problems with that. It should be stored on a device. And I guess my thought with the unfunded mandate is the storage device is the issue, not necessarily the recording device. The recording device is minimal expense. Representative Pantelakis?
The more I read this bill and the more I think about it, I'm beginning to believe it's a good protection for the police and the towns and cities. So I couldn't really say that it was a 28A issue, because if my department doesn't have things to record him, we're in big trouble. So.
Representative Bordenay.
Thank you, Mr. Chair. I'm going to oppose the IT motion. I think that the person under consideration for arrest is already being recorded when they ask not to be recorded. So that will be part of taking care of, I don't want to be recorded. So
Exactly right.
I would suggest that we defeat the ITL motion and pass this bill with the amendment from Roy. Professor, who wrote the amendment? Welch.
If we get to that point, I'll let you do the honors of seconding it.
Oh, we'll get.
Representative Marston.
Thank you, Mr. Chairman. I'd like to make a note that the reason I seconded the motion to ITL is that now we can have this discussion that we've been doing. If there's no second, it dies. With that being said, in my part of this discussion, I have a big feeling that I believe Representative True is 100% correct. We are trying to pass laws and we ain't funding it. And that's an unfunded mandate. And that's going to cause a problem down the road that's going to flare up. I believe that sincerely. I may not be here when that happens, but if you pass this, that's what's going to happen unless you fund the towns the ability to record. Don't leave it up to them to maybe do it, and maybe they store it, and maybe they don't, and so on and so forth. And with all of what I'm saying, and I'm not a lawyer, man, is a good lawyer going to take this apart and rip it up like nobody's business. And so with that being said, I will still ITL. I will vote to ITL. Thank you, Mr. Chairman.
Representative Pratt.
I would have not have thought that this was a unfunded mandate, but in reviewing this letter from the New Hampshire County Attorneys, there's 10 county attorneys on here that are not in favor of this. So I'm going to lean that way, I guess. Sorry.
Representative Schultz.
Thank you. I'm curious to know what the blue sheet reflects in terms of support and opposition. And I texted to Mr. Vice Chair the online numbers. It was 2 for and 2 against, but it also lists their names. So I'm just curious to know if you have the blue sheet and could tell us the tally.
Representative Wallace, do you happen to have the blue sheet?
I do not. It's over on the desk.
This was the second day we had a hearing, so there may be 2 blue sheets. Is there no blue sheet to reference? Okay. Do any members wish to speak that haven't spoken already? I'm just going to point out we had a bill involving body cameras, and the consensus was that was an unfunded mandate. So I guess how is this not? Is it because it's a minimal cost or less expensive? Because there is no cost. How is there no cost? Because my concern is the unfunded mandate, but apparently I'm in a small group here, so talk me out of it.
I will give you $100 if you can find one police department in this state that does not have any kind of recording device on bill. I'll double that.
Okay,
You got 5 minutes.
the
There's
blue
not
sheet
one
from the
police
original
station
hearing
that
date.
does not, I got fingerprinted at the Goffstown Police, not by criminal, criminal act.
Representative Burry, you are live streaming. I
Yes.
make cautious.
No, I wanted a concealed carry license out of Florida, so that's why they fingerprinted me, because I had to do it. But they told me when I walked into the fingerprint room, you're being audio and videoed, and I wasn't even being charged for anything, and the tapes are rolling. Yes, and so if Goffstown's not small, but I know which is small. There's so many other small police departments. They all record because the biggest thing they want is they want to protect themselves. and they want to make sure that whatever the person that shouldn't be talking talks, they want to make sure they get him exact, because what he's going to do is he's going to tell his lawyer once he gets one, go, I didn't say that, and then it's his word against their word. Well, if it's a recording, they can't do that. And I know every police station in the state has one.
So, we have the blue sheet.
It's rather interesting.
2 in support, 4 against.
Why is it interesting?
Would you please add who is for and who is against, please? It is public record. No secrets here.
I think it's a job for the clerk.
So Buzz Share supports the bill. Okay, Representative John T. McDonald, Carroll District 6 opposes. Joseph Ebert, New Hampshire State Police, is against it. Elizabeth Sargent, New Hampshire Association of Chiefs of Police, is against it. Laurie Roberts, New Hampshire Innocence, the Innocence Project, supports it. And Joseph Hoboke, Hollis PD, is opposed.
And Mr. Chair, the text I sent to the Vice Chair also has the names of those 4 individuals.
Well, with that being said, I think we'll, Representative True.
Thank you, Mr. Chair. I do understand people are saying, don't worry about the 28A issue because everyone already has all this stuff in their police stations. The letter from the New Hampshire county attorneys says they're opposed. And why are they opposed? Because many of our law enforcement departments do not have the equipment which is necessary to record, store, and transmit interrogations as mandated. Our officers do not have the electronic storage capacity or the personnel to receive, redact if necessary under the law, and transmit. So there's a difference of opinion. A whole bunch of county attorneys say all our departments don't have the facilities or the equipment to do this, and there are people in this room saying, yes, they do. For this bill, for this ITL, I'm going to go with what the county attorneys of New Hampshire say, that there is already constitutional mandates in place which address the underlying bill. But their main point being, no, many law enforcement departments do not have the equipment or the capacity to store. Thank you.
At this time, the matter will now be put to question. If you're in support of the motion of an expedient to legislate, please say yea. If you're opposed, please say nay. Clerk will now call the roll.
Vice Chairman Roy.
No.
Representative Welch.
No.
Representative Burt.
No.
Representative Lynn. Representative Green. Clerk votes no. Representative Testerman.
Yes.
Representative True.
Yes.
Representative Pratt.
Yes.
Representative Marston.
Yes.
Representative Schultz.
That was too quick. On ITL, no.
Representative Panalakis. No. Representative O'Hearn. Representative Bourdonnais.
No.
Representative Muse.
No.
Representative Ray Newman.
No.
Representative Bolden. Representative Conley.
No.
Representative Bradley.
No.
Representative Sue Newman.
No.
Chairman Abbas.
Chair votes yes.
With a vote of 16 nays, 6 yeas, ITL fails.
Representative Welch, you wish to be recognized to make a motion.
I move House Bill 1540 FN
Representative Borden, you wish to second that? The motion has been,
And 2 not voting?
Did I say 12? Yeah, two not voting. I got 13 to 6. No crossouts.
so that motion has been seconded by Representative Borden. Representative Welch, you wish to speak to the motion?
I think we've discussed it pretty well. The amendment was, I think, fairly clear. The only thing that had really changed was the definition of law enforcement officer and what an arrest is, or custodial interrogation. I think that's sufficient.
And I think, Representative Marston, you recognize for parliamentary inquiry.
Sorry.
So, Representative Welch, the question was of which amendment we are dealing with. My understanding is you're offering Amendment 2022-0616H.
Correct.
Right, so this time, the matter will now be put to question. The question is whether to adopt the amendment. If you're in support of adopting Amendment 2022-0616H, please say yea. If you oppose, please say nay. The clerk will now call the roll.
Vice Chairman Roy.
Yes.
Representative Welch.
Yes.
Representative Burt.
Yes.
Representative Lynn.
Yes.
Representative Green.
Yes.
Clerk votes yes. Representative Testerman.
No.
Representative True.
No.
Representative Pratt.
Yes.
Representative Marston.
No.
Representative Schultz.
Yes.
Representative Panalakis.
Yes.
Representative O'Hearn. Representative Bourdonnais.
Yes.
Representative Muse.
Yes.
Representative Ray Newman.
Yes.
Representative Bolden. Representative Conley.
Yes.
Representative Bradley.
Yes.
Representative Sue Newman.
Yes.
Chairman Abbas.
Chair votes yes.
16-3.
The amendment
is adopted.
Amendment 2022-0616H has been adopted. Representative Welch, wish to make a motion about to pass as amended?
I make that motion.
And Representative Bourdonnais, you wish to second that? Anyone wish to speak to the question?
All right, can I just, I still think that issue about what, you know, when somebody doesn't want to agree, I still think that needs to be changed, but that's not a reason not to, I intend to vote yes. That can be either changed by a floor amendment or changed in the Senate. I don't think it's a reason not to proceed, so I intend to vote yes.
If anyone wishes to although I don't mean to rush this, the fact of the matter is we're not here tomorrow to exec it, so it's today or never. So a floor amendment to address that, Representative Lynn, I would have no problem putting the best, whatever we send to the other side, assuming it passes the House, we should send them the best. If it's possible, maybe Representative Welch and Representative Lynn, you guys can continue that healthy conversation.
If I could just for a second, you don't feel that the fact that this would mandate recording of an interrogation, so that recording would be press start. Hello, my name is Officer so-and-so. We're here today to interview you. You're being audio recorded. I don't want to be recorded. Boom, stops. He's captured. Would that?
You know, I'm thinking, I mean, I think often it would happen that way, but I could see sometimes where the police officer might say to the person as they're sort of taking him into the interrogation room, listen, we're going to have to, we're going to have a conversation. We're going to have to record this. And he says no, before they even get in there. Yeah. So that's the kind of situation where I think it could come up. But, as I say, it's not a big deal. I don't think I think it could be worked around.
Representative Marston?
I just even have a problem with this in the sense that if, and I can give a couple of at least one example, but my problem is if somebody were trying to arrest me or gonna take me to this police station, the only words out of my mouth would be, I want my lawyer. And then I would stop talking, period. And I can give you an example of how I feel. And yet I think the police do an exact job. I wouldn't want their job. I commend them. But I had police come to my door, and I live in an apartment complex, buzzed them up. They got to my door. They said, can we come in? Do you know what my first words to them were? No, you may not. And then we talked a little bit, and then they did come in based on what they said to me. But I, at that point, still knew that if they saw something, and I don't have anything, I don't do marijuana, I don't have weed, I don't have anything. But when you allow the police into your house and they see something that they know is not kosher, bam, you are in trouble. It's in the evidence. It's out in the open. They're not searching your drawers. They're just, and that's why I say, you got to use your head when it comes to the police. I want my lawyer. So again, I can't abide by this. I know where you're trying to go. I love David Welch, Representative Welch, and not in that off-color way, but I respect him. I respect what he's trying to do, and yet I also respect Representative True. And I think this is an unfunded mandate that's going to come back and bite you in the butt. Thank you. I appreciate the time, Mr. Chairman.
Thank you.
Mr. Chairman, if I just, really quick, I just want to make sure that we all as a committee understand and appreciate the fact that law enforcement does what we pay them with our tax dollars to do, and that is to catch criminals. And, you know, sometimes it doesn't work out right, but besmirching all of law enforcement as, you know, we got to watch out, they're out to get us, is also not the way to go. They're doing what we pay them to do, and at great personal risk to themselves oftentimes. So
You're missing one point. We make the laws that they have to enforce.
That's correct.
In this legislature.
Well said, Representative Pantelakis. Well said, Representative Roy. At this time, the matter will now be put to question. If you're in support of the motion of ought to pass as amended, please say yes. If you're opposed, please say nay. The clerk will now call the roll.
Vice Chairman Roy.
yes.
Representative Welch.
Yes.
Representative Burt.
Yes.
Representative Lynn.
Yes.
Representative Green.
Nay.
Clerk votes yes. Representative Testament. No. Representative True.
No.
Representative Pratt.
No.
Representative Marston.
No.
Representative Schultz.
Yes.
Representative Pantelakis.
Yes.
Representative O'Hearn. Representative Bourdonnais.
Yes.
Representative Muse.
Yes.
Representative Ray Newman.
Yes.
Representative Bolden. Representative Conley.
Yes.
Representative Bradley.
Yes.
Representative Sue Newman.
Yes.
Chairman Abbas.
Chair votes no.
With a vote of 13 to 5 and 2 not voting, it passes.
I got 6. 6 no.
You're killing me over here.
By a vote of 13 yeas, 6 nays, the motion of ought to pass as amended passes. Representative Welch, will you prepare the majority report? And ju-
vote again?
13, 6, 2.
And just a reminder, that report needs to be done ASAP, tonight, because the deadline's tomorrow.
Who's doing the minority?
Will there be a minority report?
Yes.
Same instructions. If it's not in by noontime tomorrow, it won't be accepted. So, tomorrow's the deadline to get it out, move it out of the.
So hurtful.
I know.
I know the deadline. I know the deadline.
All right. And this time we'll now close the executive session on House Bill 1540.
Mr. Chair, I just wanted to thank you and the committee. You've hosted me again as a
We're not done.
substitute.
We're not done. We get some more.
And thank you for
You'll be
allowing
regretting
me
that.
to be early for once.
And I'm
Sorry.
glad you're thankful because you got one more to go. At this
And
time,
thank you for welcoming me to the next bill.
at this time, we'll now open the executive session on House Bill 1178. Representative Burt, you wish to be recognized to make a motion.
Yes, I would like to make a motion of, ought to pass as amended. With amendment 2022-0479H, which is very well written.
Is that has been seconded, and that has been seconded by Representative Wallace? Representative Burt, do you wish to speak to your motion?
Yes, this amendment that came forward is well written. It goes right to the point. You know, I believe even the AG is in support of it, or they're not going to oppose it, because I don't think they support much. They want to stay as neutral as they can, I guess. It's just a good amendment. And so the overall bill with the amendment will be a perfect bill to send to the other body, which they should be happy with. And thank you.
Representative Lynn?
Yeah, I just want to second what Representative Burt said. This really was a collaborative effort of, I think, a number of interest groups. And as Representative Burt said, we did run this by Attorney General Formella. He indicated he had no problem with it. I think you're probably right that he may not come over and say, you know, he affirmatively supports it, but that's just because they don't generally want to take a position on policy things that they think is for the legislature. But I think it's a good proposal. I note that one of the people I suspect that this committee has heard from previously was Alan Rice from the Gun Owners of America. He made the suggestion, the last proviso in section 2 of the bill, which, and I'm just quoting here, it says, provided that the provisions of this chapter shall not provide for the distribution of information required to be destroyed pursuant to 18 U.S.C. section 922 T2C. That was at his suggestion from that organization's counsel, and frankly, that was something that none of us had thought about, and it's a very good point because there is this federal statute. You know, when you have the instant background checks, that there's a provision in the federal statute that says the records of that have to be destroyed, except for that by the federal government. They have to be destroyed except for that unique number, and so this would prevent any distribution of that kind of information. So I think I agree with Representative Burt. I think it's a very good proposal.
Representative True.
Thank you, Mr. Chair, and I'm going to speak slowly because if we're here after 5:30, the chair buys everyone dinner.
Okay, slow it down.
Is somebody going to, I hear that the amendment is a very good amendment. Is somebody more familiar with the amendment than I am going to explain the changes the amendment makes to the original bill?
Representative True. So, in the original bill, I'm looking at the amendment. If you look at lines 9 to 18, that is in the original bill. That is unchanged. And then if you look at page 2, lines 4 to 7, that's the severability clause. That is also in the original bill. My understanding, those provisions, word for word, have not changed. And last year, the House had a similar bill, and we passed an amendment in this committee that was identical to the severability section and the first section, which starts on line 9. That's what is being added in the amendment is lines 19 through 29 on page 1, and then on page 2, lines 1 through 3. So that's what the change is. And my understanding of it's a clarification that this is simply a policy issue relating to the regulation and enforcement of firearms. If someone is involved in trafficking narcotics, the state or county or municipal police officer could assist in enforcing the federal drug laws if they so choose so. But not strictly just to enforce firearm laws. That's what this would do. There have to be something in addition to that. But you cannot use it as a shield, per se, from... This is the exact language we passed last year. That's what that second paragraph does. It's really just re-emphasizing that. Representative Pratt.
Is there anywhere in here that there's a penalty for noncompliance?
There is no express penalty. However, there was a bill we recently passed in this committee. Now, we haven't passed it in the House yet, but it did pass on consent. It had to do with the police accountability and police standards, where we expanded the members of the committee on that. In that bill, there is a provision that basically, if a law enforcement officer willfully disregards their duty, this is basically restricting what police officers can do.
Okay, so that covers it.
If they would be subject to that disciplinary board, is my understanding. But there's no. Some states have passed provision like this. They have different types of enforcement penalties enforced by the Attorney General. This does not have that.
Okay, it's good. Thank you.
Representative Conley.
Thank you, Mr. Chairman. I'm not entirely sure how I'm going to vote on this right now. It's not because I've changed my mind on firearms, but I do think one should be consistent in one's views. If I don't want the federal government enforcing cannabis laws in our state, if I don't want the federal government enforcing immigration laws in our state, would I then not be consistent and support this? I'm wondering if somebody could address whether or not the grants are at risk. We heard about that earlier during testimony, but that's just where I am at it with this.
I will say HB 1598, which is the bill we passed 17-4 in the committee, had some language, not identical, but similar, where it would prevent police, local law enforcement officers from participating in enforcing cannabis laws with the federal government. So we have passed this policy before in other subjects. In regards to the grants, I asked that question during the public hearing, if there was any examples where they could say any state was denied a grant or denied funding because of this policy, and there was no examples provided. So
again, a quick follow-up. So I think it was Alan Rice, with whom I don't generally agree on much of anything, said federal officials enforce federal laws, state officials enforce state laws, and it's hard to find a flaw with that argument. Although I would hope that other members take a similarly holistic approach when we have other bills before this body that have a similar question of federalism and so forth.
Representative Pantelakis.
Yes, can somebody give me a reason for this bill? I mean, it says a presidential executive order. Has there been one put out there?
There actually was
It's never come down to New Hampshire.
Well, I can answer your question. In respect, whether there is not an executive order, those can happen at any time, and I will just be pretty straightforward. I'm pretty sure the current president has said if legislation isn't done that it would be done through executive order. That has not happened, but during the campaigning process, that was said several times over.
But what about any money that's coming in that might be deterred by this?
I heard that concern. I asked specifically what grants, are there any grants that they're specifically worried about that the state of New Hampshire wouldn't get, or are there any situations where other states were denied grants or lost funding as a result of any policy similar to this? And not a single example could have been provided. We're not the first state to entertain a policy like this. So, since last year, I think two additional, I think Texas and Missouri also have now passed not the exact same bill, but a similar policy.
Okay, thank you.
Representative Bradley?
Yes, I just have a question. So if there was an executive order by the president and he decided to say, we need background checks for all gun sales, we here would not have to abide by that. Is that correct?
Well, it's not that we wouldn't be abiding by it. My understanding is the local police officers, whether state, county, municipal, they would not be enforcing those laws. That's a federal order. It would be for the federal government to enforce that. A firearms dealer is licensed by the feds, and therefore, if they do not follow the executive order, I can imagine they would have some licensing issues. And unlike the cannabis laws, the ATF tends to actually enforce the federal laws, so there would be some issues there.
And they are already doing that based on a couple of EOs on firearm accessories presently.
You do appreciate the answer. Representative Newman, Ray Newman.
Yeah, I just have a question. I mean, right now, the police, local police, cooperate with federal enforcement of firearm laws. Is that correct or not? Are there instances of that where they work together to enforce federal? And if this passes, would they be able to do that based upon this amendment?
I'm not prepared to tell you specific examples, but if this were to become law, the police in New Hampshire would not be able to simply to help and assist federal officers enforcing any federal firearm regulation if it's inconsistent with New Hampshire's law. So if our law is the same as the federal law, we could still participate. There would have to be some other criminal offense unrelated to the firearms in order for the local law enforcement officers to be assisted in that investigation.
So we do not have a state law about firearms in schools, is that correct? We have a state law that does that?
The only state law that I'm aware of,
my question.
there is no specific law that talks about members of the public. There is a law prohibiting students in schools.
So with adults, there is no state law that prohibits an individual from carrying a firearm into a school.
That's under the current state law. That's correct. We had that bill last term. We had the bill on that issue.
So
both
if
years.
there were a mass shooting or something that happened in a school or an individual whatever, if this amendment passes, then the local officials and municipalities would not be able to assist them. Is that correct?
No, because there's several capital level crimes that were committed. Murder, shooting someone in a school for no reason is illegal, and that's a felony. It's a murder in the first degree. So if that were to happen, because there is a underlying offense that is against state law, the first degree murder is illegal in New Hampshire, then if the federal government asked us to help assist with that, we would be certainly within our rights to do that. The mere fact that someone's using a firearm illegally does not stop local police officers from enforcing other laws. It's the mere fact of the gun regulation itself. So, for example, if the federal government passed a law restricting the capacity amount of rounds that a firearm can hold, let's say they made it a 15-round maximum, the state of New Hampshire would not assist in enforcing that.
Thank you.
Representative Bornay.
Thank you, Chair. Is there a motion on the floor? Okay. Well, is there a motion to auto pass as amended?
It's the motion's actually to adopt the amendment.
Okay, fine. I would say I will support the amendment, but I am going to oppose the bill. The amendment does improve the bill, and I will support that amendment. Thank you.
Representative Roy.
Thank you. I'm going to address my comments to my colleagues who would be inclined to, for a gut reaction to vote against this. And I'm not going to try to change your mind. I just want you to think about something. If we went back in Mr. Peabody's Wayback Machine a couple of years ago, and there were a different executive in the White House, and he started issuing executive orders saying, you know, I prohibit this, I prohibit that, I feel like people would think differently. So there's an important reason we have federalism, because we like to do what we like to do locally. And we don't want someone in Washington telling us what to do and what not to do on a federal level. So I throw that out as food for thought, and I align myself with Representative Conley's thing. You know, we're going to have to be consistent. If we don't want them meddling in something, then we don't want them meddling in anything. Thank you.
Could I reply to that? I don't think the people that you address that comment to pass laws based upon a gut feeling. Thank you.
I didn't address it to anyone specifically.
Representative Pantelakis.
Yes, I just feel this amendment is not necessary, and that our constituents out there that aren't gun crazy, okay, don't care about these things. They want us to pass things that will protect them and take care of their thoughts and business. And this, every time we turn around and pass one of these gun things, it comes out like we're all in a world of our own out there. That's just the way I feel. My constituents call me and ask me if you have anything else to do in criminal justice besides pass gun laws. And I say, yeah, we get a few other bills.
Representative Muse.
One concern that I have is that New Hampshire law doesn't mirror federal law when it comes to firearms trafficking, which is an increasing problem with New Hampshire providing essentially a flow of guns into other states. By not even being able to cooperate with federal investigations, one of the issues is the issue isn't guns falling into the hands of people who are legally able to own guns. You know, when we're talking about trafficking, with guns falling into the hands of gang members, felons, and people who are prohibited by our own law from actually having guns. I see that potential issue with it, and you know, I'm also you know, looking at the wording, which continues to talk about prohibiting cooperation. It's one thing to actually tell our law enforcement folks, you are not able to enforce this on your own. It's another thing for us to say, you can't cooperate with an ongoing federal investigation into firearms trafficking, which I think is what this bill would actually get into. And if I'm misinterpreting this, set me straight. But
well, just to clarify, if anyone, whether they're a criminal selling guns illegally, a licensed firearm dealer, or it's a private exchange between two people, anyone who transfers a firearm to a person that is prohibited under law, disqualified under law, that is a crime in and of itself. So if someone in New Hampshire is transferring a firearm to someone who's a felon, that is already against the law in New Hampshire. So this is not encouraging that activity, nor would local officials be prohibited from assisting in that investigation because that person's committing a crime in violation of New Hampshire law.
We do spend a lot of time talking about enforceability in this committee. And, one of the things that we are, would be doing would be essentially taking the teeth out of any enforcement mechanism for firearms trafficking in this state.
When was the last firearms trafficking case prosecuted in the state of New Hampshire, Representative?
You're asking me when the
Yes.
last fire? I do not know.
Well, you anecdotally said that that's a problem here in New Hampshire, so I'd like you to support your allegation with facts, not supposition.
And, Mr. Chairman, your statement about people that's not supposed to have guns, shouldn't have them and can't get them, maybe you'd like to go and tell my 2 grandchildren that their father, who was chief of police of Greenland, a little town, they buried him because someone that wasn't supposed to have a firearm shot him. So, I mean, that's...
And and I'll just clarify my comments, and I'm sorry for what happened with your family. And all I'm saying is that if anyone were to transfer a firearm to someone who's not allowed to have one, whether this bill passes or not, that's still a crime under New Hampshire law and a crime under federal law. So that issue raised is not impacted by the House Bill 1178 or the amendment. That's already, and that should remain illegal because there is certain disqualifications in place. And that would even happen in a private situation if I were to simply gift a firearm to someone who I was just a friend of mine. If that person's not allowed to possess one legally, I would be committing a crime, even if I didn't sell it. So any type of trafficking like that to felons would already be illegal. And that's the point that I was trying to make. Representative Lynn?
Can I just make a point, in response to the idea that, like New Hampshire, because of its laxed, quote-unquote, gun laws, we are a supplier of guns to other places. That's a frequently made argument around the country. But I submit it's really a fallacy. Stop and think about this. If the theory is that New Hampshire's gun laws are so lax that we're causing the problem in, let's say, Massachusetts or New York, the guns are going down there. Well, logically, you would think if that was true, if the guns were coming from New Hampshire, there would also be a real problem in New Hampshire. It wouldn't just be in these other states. There would be a big crime problem in New Hampshire. Or the same argument is made in, Indiana. Indiana supplies all the guns for Chicago. But you'd think that if that were true, there would be because the guns are originating in Indiana, there'd be a huge gun problem in Indiana. But in fact, there isn't. So it's
In all
just seems
due
to me-
respect to you, Representative, do you remember that there was 6 guns found in Massachusetts that were bought in state of New Hampshire stores that committed crimes?
Yes, 6. So this is the huge problem? 6?
It's huge to me.
There is actually, this information is actually published by the ATF. I only read the ATF publication. It's called Time to Crime. And what it took into consideration was any firearms, and it went state by state, how much time would go by between the time the firearm was sold to the point in time where a crime was committed with that firearm. In New Hampshire, the average time period was over 8.5 years between when the crime would occur with the use of that firearm. Now that's the ATF public. I didn't fact check that anything beyond reading the report.
And I don't have any problems with guns. I own one. But I'm just saying that out there in the public eye, they wonder what we do besides make laws about guns. And if you don't think this isn't going to be a newspaper issue, it is. And I mean, all due respect to you guys and what you think. But that's my opinion. I think that we ought to do something else besides pass these things. That's all.
Representative Schultz?
Thank you, sir. 2 things. First, on the trafficking piece, I found an interesting quote from the Giffords organization, which, okay, throw the bias at it, but New Hampshire penalizes any person who, in purchasing or otherwise securing delivery of a firearm, gives false information or offers false evidence of his or her identity. New Hampshire has no other laws aimed at firearms trafficking. And to circle back on that issue, of course, gun use is dramatically different in Gary, well, maybe not Gary, Indiana. South Bend, Indiana versus Chicago. This could be the same here. You know, our culture in New Hampshire is basically a neighborhood, suburban, and rural community. The way people use guns, I'm from Kentucky. I grew up, my first 26 years of life, minus college, I spent in Kentucky, and we lived on meat that my family hunted when times were tough, for sure. So I'm not against guns, but it is definitely a spurious claim, I think that'd be the right way to put it, to say, how can there be trafficking of guns from New Hampshire to Massachusetts that cause any problem? Because we'd have a problem here. You cannot compare urban use of guns to gun use in Concord, where I am a state rep. The culture, I mean, do I really have to explain all the layers of culture? I mean, so much is different at an urban level versus here. And I've lived in Washington, D.C. and Louisville, Kentucky, where there is immense gun crimes. Guns are just used differently. So selling guns here, because our laws are lax, goes to the greater Boston area because of the way guns are used in trafficking drugs. I don't know. Did I really have to spell that out? I don't know. But obviously, guns will still be here. They're just used for hunting or self-protection or sometimes use in a violent crime, for sure. But you can't dismiss it just because it doesn't look as ugly. We also have far fewer people by density of area than a lot of those places. There's just so many layers of data I could provide. This is just off of the top of my head. It's spurious to say, therefore, New Hampshire doesn't have a gun problem. We would have it just like Boston. I just hope that is helpful for you to think it through.
Just a small point. If someone from Massachusetts came to New Hampshire to acquire a firearm, the dealer actually has to, not only does that person have to be in compliance with New Hampshire law, they have to comply with Massachusetts law. So Massachusetts law, let's say they had a capacity which they have some regulations on capacity restrictions. If someone comes to the store here and they show their identification, the dealer is not going to make the transaction because it's not the New Hampshire law, it's the other state's law. There's that too, but this right off the bat, that's.
I
To say
understand
that
what you're saying.
we're supplying the surrounding states.
Yes.
That's not, unless that person the sale is also complying with the other state's law. The sale's not supposed to happen. I mean, if it does happen, that is an illegal sale, from my understanding.
Through
Other than for
multiple
the snatch and
means.
grabs at gun shops lately, they may be Massachusetts perpetrators.
We know this from
We've had
the
no role.
law enforcement that gather in Boston every year or so often. I will admit, I'm not an expert on this, or I would have boned up on this better. But I do know this from sitting at the feet of Representative Catherine Rogers, who knows this issue well and has attended these meetings, and she's been the only representative from New Hampshire at times. And law enforcement official after law enforcement officials say the majority of the guns used in crimes probably, well, I can't say how they obtain them, but I can tell you the guns are coming from New Hampshire as best they can determine at a much higher rate than happens in their state. So that means our gun laws are conducive to giving guns to Massachusetts, but it sounds like you guys
What law
debate this a
enforcement-
lot, and I'll let the point go.
Can you just explain what law enforcement agency in Massachusetts is blaming New Hampshire for Massachusetts
I
gun
know that,
violence?
and I can look this up, but I know that there were multiple. I know the mayor of Boston and the state, I believe the state police and other agencies gathered together and invited people from New Hampshire, including representatives from the governor's office, invited other places because of this guns and drugs. We get the drugs, we give them guns, is basically the way to water. Am I the only one that has heard of this? I can't be. This has probably been in testimony. Does anybody want to back me up here? But it's definitely, let me look this up for you. Come on, Amy.
Representative Green, you're recognized.
Thank you,
never heard
Mr.
of
Chair.
that? Okay, interesting.
Speaking of gun trafficking, one of the largest gun trafficking that was carried on was by the federal government in Fast and Furious, where guns went to Mexico and ended up with the cartel.
Representative Burt, you're recognized.
Thank you, Mr. Chairman. And, Mr. Chairman, I think we're getting way off track. If anybody shoots somebody, the local police is going to arrest them. This bill is not going to stop that. If they wave a gun out the window driving down the road in a road rage, the local police, state police are going to pull that person over and they're going to arrest them. It has nothing to do with this bill. This bill only tells the feds or the local police that an executive order or other federal statutes, if they limit magazine capacity or ban a certain type of gun, it will tell them that local police will not enforce the federal mandate. That's it. Now, if I commit a crime with that, I'm being arrested by the local police. It just isn't, we're way off topic here. And, so back to the bill, it's just, we're telling the local police they are not going to enforce the federal gun laws or executive orders. And with that, it's the way it should be. It's the separation. We did it with marijuana. We are, a free state here to do marijuana to a point against federal wishes. Federal wishes say, don't do that, and we're not losing any federal money over it. The feds aren't coming in here and arresting people over marijuana, and and I just don't see why we're so far off topic of what this is intended to do. Thank you.
At this time, I think at this time we can at least move the question whether to adopt. The question is whether to adopt amendment number 22
Burt Wallace.
0479H. If you are in support of adopting the amendment, please say yea. If you are opposed, please say nay. The clerk will now call the roll.
Vice Chairman Roy.
Yes.
Representative Welch.
Yes.
Representative Burt.
Yes.
Representative Lynn.
Yes.
Representative Green.
Yes.
Clerk votes yes. Representative Testament.
Yes.
Representative True.
Yes.
Representative Pratt.
Yes.
Representative Marston.
Yes.
Representative Schultz.
No.
Representative Panalakis.
No.
Representative O'Hearn. Representative Bourdonnais.
No. Oh, yes, sorry.
Representative Muse.
No.
Representative Ray Newman.
No.
Representative Bolden. Representative Conley. Representative Bradley. Representative Sue Newman.
No.
Chairman Abbas.
The chair votes yes.
13 yeas, 6 nays, 2 not voting. That was
that was the amendment.
That's the amendment.
We,
13-6.
by vote of 13 to 6, the motion is adopted. Representative Burt, you wish to make a motion about to pass as amended?
Yes, Mr. Chairman, I would like to make a motion about to pass as amended. Thank you.
That is seconded by Representative Wallace. Any comment? I mean, we kind of were going covering both anyway, but if any additional comments to be made? Seeing none, the matter will now be put to question. In support of the motion of ought to pass as amended, please say yea. If you're opposed, please say nay. The clerk will now call the roll.
Vice Chairman Roy.
Yes.
Representative Welch.
Yes.
Representative Burt.
Yes.
Representative Lynn.
Yes.
Representative Green.
Yes.
Clerk votes yes. Representative Testament.
Yes.
Representative True.
Yay.
Representative Pratt.
Yes.
Representative Marston.
Yes.
No.
Representative Panalakis.
No.
Representative O'Hearn. Representative Bourdonnais.
No.
Representative Muse.
No.
Representative Ray Newman.
No.
Representative Bolden. Representative Conley.
Yes.
Representative Bradley.
No.
Representative Sue Newman.
No.
Chairman Abbas.
Chair votes yes.
12 yeas, 7 nays, 2 not voting.
Motion of ought to pass as amended is passed. Will there be a minority report?
Oh, you said minority? I'm sorry.
Representative Burt, you're preparing the minority report?
No, there will be a majority report. No, ma'am.
Representative Burt, I assume you'll do the honors?
Yes, I'll have the majority written tonight.
Representative Muse. At this time, we will now close the executive session on House Bill 1178. Yes, just next week, we have a session on Wednesday and Thursday, so obviously we won't be here Wednesday morning. Friday, unless, I'm going to leave that for a subcommittee to be scheduled that day, so there won't be any public hearings otherwise. So not to the following week. So
But we do have subcommittees this Friday.
there are subcommittee hearings this Friday. So and I'm going to put a subcommittee together on HB 1476. I will email that out to the committee. Representative Lynn.
I just wanted to take a minute to thank you all for having me here as a substitute today. And the really important question I had was for the chairs. Where are you taking us to dinner tonight?
You're not going to like it.
And Mr. Chair, I was gonna say a nice things, but I'm taking them all back.
Representative
Just
Lynn.
kidding. I really like you guys.
I know there was that
Thank you,
comment
Mr.
was
Chair.
Representative Lind, you may get a gift card to use on the way home.
Everybody's going to get Canada Pure on the way out there.
The committee is now adjourned for the day.
Oh, we should have did the purple paint.
No, it's 6 o'clock.
Take 5 minutes.
Now we're going to get like 200 more emails till next. Oh my God, it's been another week. Oh my
I
God.
tried to tell you. Too late now.
Another week.
You're adjourned.
Yeah. No. It's late though.
Yeah.